Ready for you, Chair.
Good to go, Denise?
I'm ready. Thank you.
All right. Good morning. We are back on the record with the evidentiary hearing in the matter of the application of NextEra Energy Transmission Southwest LLC for a limited certificate of convenience and necessity to transact business of a public utility in the state of Kansas. This is pursuant to docket number 22-NETE-419-COC. Very well. Before we return to the examination of witnesses, I'm going to turn to you, Mr. Schulte, and consider, if we can, a bit of old business from yesterday. During her testimony yesterday, Ms. Walding indicated that NETE had executed option agreements and easements with several Kansas landowners. These are easements that pertain to the proposed Wolf Creek Blackberry line. At this time, I am asking NETE to provide the commission with copies of all of these executed agreements.
Those would be confidential. We could provide those, submit those confidentially, presumably. And would it be submitted, I guess, would it be submitted to the commission only and not a filing in the case? Or would it be a filing in the case where parties would be, other parties to this case would have access?
I believe it should be submitted incidental to the docket in this matter.
Can I have a moment to confer?
You may.
Okay, thank you for the time. So the form agreement has already been submitted into the record of this case. And subject to confirmation, we could stipulate that all of the executed agreements are consistent with the form, and that the only unique information would be landowner specific names and legal descriptions of their properties. And we could also provide the number of executed option agreements. Beyond, and the reason why we are hesitant to provide a filing with, even if they were marked as confidential, providing a filing with specific names and land owner description or legal descriptions of land would be, it would violate the privacy of the landowners who have executed those agreements, and it would be confidentially competitively sensitive.
How so?
It would impact future negotiations with landowners, and these are not recorded easements. These are option agreements. So they're not otherwise public.
They are capable of being recorded, however, are they not, in the event that NextEra should exercise the option to take the easement?
I believe that they would be recorded, or would there be a separate form that's recorded? Yeah, I'm
trying to recall from memory. I've seen the option agreement. I thought it provided space and all for recording.
Yeah, I just don't have the facts on this right now. Could I have some time and get back at a after maybe a recess this morning or later in the proceeding today?
Certainly, we could defer this for a bit.
Okay.
That would be fine. Let's do that. We'll try to touch on it around or after some break. You let me know when you're prepared to do that.
Okay, thank you. I appreciate that.
All right. All right, very well. Let's resume the examination of witnesses this morning. Ms. Kafer, if you would, please call your first witness.
Okay, Evergy calls Darren Ives.
Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Okay, will you state your name and place of employment for the record, please?
Yes, my name is Darren Ives. I'm the Vice President of Regulatory Affairs for Evergy. I work at 1200 Main, Kansas City, Missouri.
Now, are you the same Darren Ives who caused to be filed in this docket direct testimony on May 17th, 2022, cross-answering testimony on May 27th, 2022, and testimony in support of the settlement agreement on June 7th, 2022?
Yes, I am.
Do you have any corrections that you need to make to those testimonies today?
I have two minor corrections to my direct testimony. The first one is on page 5 of my direct testimony, line 16. Halfway into that line, it says CN application. That should say CCN application.
Okay.
And then I have one other spelling issue, and it's on page 20 of my direct testimony again. It's in item number 7, line number 7 on page 20, 4 words in, there's an S missing in Kansas.
Are those all your corrections?
They are the ones that I am aware of.
All right. Well, if I were to ask you the same questions today as are contained in your direct cross-answering and testimony in support of settlement agreement, would your answers be the same?
Yes, they would.
Okay, I'd like to move for the admission of the direct cross-answering and testimony in support of settlement agreement of Mr. Darren Ives to the record.
Is there any objection? Without objection, they are admitted.
Okay, thank you. And I'll tender Mr. Ives for cross-examination.
All right, thank you. Good morning, Mr. Ives.
Good morning, Chair Keen.
As we've done with prior witnesses, let me turn first to the commission and provide them with the option either to ask cross-examination questions of you now or to defer. I'll begin first with Commissioner Duffy.
Thank you, Chair Keen. Good morning, Mr. Ives.
Good morning, Commissioner Duffy.
I'm on page 19 of your testimony. And
My direct testimony?
yes, the one where you just made the correction.
Okay, I'm there.
So as I look at items 1 through 13, in the settlement agreement, do you feel that these are satisfied to the company's level of satisfaction? These items?
Yeah, that's a good question. The short answer is yes. The settlement process is certainly a negotiation with a number of parties with diverse interests, and there's some give and take by all parties to get to a settlement position. But we certainly evaluated the settlement agreement against our requested conditions. While we didn't get everything that we had laid out in our testimony in our case, we feel that the settlement agreement is sufficient with the set of conditions that would allow the commission to find the issuance of the certificate to be in the public interest.
Okay, thank you. That's all I have at this time, Chair Keen.
Thank you, Commissioner Duffy, very much. Commissioner French.
I'm going to reserve any questions until after cross. Thank you. As much as I'm looking forward to talking to Mr. Ives.
I'll be here.
Very well. Okay, Mr. Ives, let's have a bit of a colloquy. If I could, I'd have you turn first to page 8 of your testimony, yes, that pertains to the testimony in support of the settlement agreement. Darren, page 8.
All right, 1 second.
Tell me when you're there.
Okay, I've got it pulled up, and you said page 6?
8, please.
Page 8. I'm there.
All right. I'm looking specifically at lines 6 through 8.
Yes, sir.
For the record, I'll read into the record what appears on those lines. Beginning with line 6, there's a question. It says, does the settlement agreement address the specific concerns expressed by Evergy in his direct and cross-answering testimony? And your answer, beginning on line 8, is not all of them, because like all settlements, it represents a compromise among the parties. End quote. have I accurately portrayed your testimony as it appears within this particular purview?
Yes, for lines 6 through 8, that's correct.
Okay. So let me ask you this as the outset. In assessing the pros and cons of this project, would you agree that the commission is not reconciled or restrained or confined to compromising on any matters concerning the long-term interest of Kansas ratepayers or the public interest?
I would agree with that, but I would just say, generally the commission has given strong considerations to the settlements that have been entered by a diverse set of parties and the outcome of those.
Would you not agree that even given that, those past approaches, each one of those is going to be subject to the specific facts and circumstances of each particular docket or case that's before the commission?
I would agree with that.
Mr. Ives, I'm going to ask you a very difficult question. And I would appreciate, it would be within your style anyway, a detailed answer. If you believe that the answer or your testimony could potentially touch on confidential information, please advise. Here's my question. Given the portions of your testimony that I have just had read into the record, what specifically are the concerns that you had that are not addressed in the settlement agreement?
Yeah, so I would say when we put our conditions together in this case, two considerations. One, that this is a very unique docket. There was some unique confidentiality to materials that were available to be reviewed, and there are still things in this docket that I have not been privy to see, even though I'm the policy witness for one of the interveners talking to you today on it. So that's pretty unusual, a little bit harrowing, if you sat in my seat, to be in that spot. So when we put our conditions together, we focused on some very specific guardrails and parameters that we would ask the commission to consider in the conditions, to give the commission and parties the transparency that we did not have. We think it's important that there is the ability for the commission to understand and appreciate the details underlying the bid and the construction of the line and the work that will be done and the ultimate impact on Kansas customers of that work. Specifically, I'll give you a couple examples. Mr. Harrison can talk about it a little bit more, but a couple of the conditions that he discussed that are not word for word conditions that are in the settlement agreement ask for, I would say, tighter specific definitions of the terminology that's used in the force majeure language, tighter, more specific definitions of terminology that is used in the exclusions to cost caps.
Sorry,
Proceed.
I'm off video. I just want to remind the commission and the parties that the categories of cost cap exemptions and I guess exclusions to those exemptions are themselves confidential, regular confidential, not confidential competitive.
Yeah, but I apologize. I did not intend to give any specific categories. I'm speaking very broadly about our request for tighter definition of words that are used in the categories. And the fact that that tighter definition language did not make it into the settlement agreement. And I think that
Sorry.
May I be heard on this matter, please?
Hold on. Mr. Schulte, are you objecting?
No, I am not objecting to this discussion. I just think that we need to abide by the confidentiality provisions that we've all agreed to and go into confidential session if we want to have a detailed discussion about cost caps. We don't want to cut off the discussion.
Okay. I think it's important for the public interest and the commission to delve into the details of some of these matters. If it appears that we are going to perhaps transgress what is confidential or otherwise, I'm willing to entertain our using the breakout room, pardon me, as the format within which to consider those issues. I don't know, are you suggesting that just by the general reference that Mr. Ives has made to the matters he's discussed so far, that there's a risk of breaching confidentiality? Mr. Schulte?
Well, yes, there is, because some of the requests that Evergy made in their testimony and that, we discussed during the settlement conference were about, what those categories of exemptions were and how they were defined. And so if we're going to talk about what those categories are and how they're defined, then that would be confidential.
Now, when I look at Mr. Ives' direct testimony, the original direct testimony, and I'm looking on pages 19 through 21. These are the pages that were referred to by Commissioner Duffy in her question. And it contains a list of the conditions that Mr. Ives was suggesting the commission consider in connection with this matter. I don't see any of those paragraphs, and they allude to this subject matter. I don't see any of those paragraphs designated as confidential. Am I reading them incorrectly?
We're to clarify, Mr. Ives was testifying about those types of items. He testified generically, not knowing what the specifics of the exclusions were as to the NextEra bid. And so I think as he started to talk about this here, he was still talking about it generically. If we want to get into the specifics of the categories as to the NextEra bid, and not just generally what exclusions from these types of cost caps are that we're seeing across the country in competitive bid situations, then that's where we need to get into a confidential session.
Thank you very much, Ms. Kaver. I think the distinctions you make are distinctions with a difference, and that's exactly my reading of it as well. Mr. Schulte?
Yeah, we don't object to Ms. Kafer's classification of the difference there. So
All right.
if we're going to stay on the right side, then we don't have any problem with continuing an open session.
Thank you.
May I be heard on the matter?
Briefly, Mr. Zakura?
Mr. Schulte did not interpose an objection. He simply interrupted the questioning of a witness by the commission. If he wants to make an objection, it should be an objection.
Thank you. Thank you.
This is not even his witness.
Thank you.
Okay.
Thank you, Mr. Zakura. I understand that. I was trying to reach some point of clarification about whether or not he had actually objected. I think I did ask that question, and we were headed down the course of trying to figure out where we were going with respect to confidential treatment. And then Ms. Caper proffered her suggestions, which I thought were well taken. We're going to go back and stay focused here. Mr. Ives, I return to you, and if you could continue with your testimony.
Yeah, so I was giving a couple of high-level examples of things that maybe did not end up in the settlement agreement that we had more specifics on in our posed conditions in our direct testimony. And I think that is much of what you'll see in differences between the conditions that we proposed in the hearing and where we ended up in settlement. It's around the detail and the definition of what ended up in the settlement agreement. All that said, as I mentioned to Commissioner Duffy, we certainly spent a lot of time with the parties. We certainly appreciated the additional conditions that NETE Southwest worked with the parties on to get to the settlement agreement. And in balance, we're comfortable that at this stage, the conditions in the settlement agreement would allow the commission to issue a certificate that it could find in the public interest.
Well, I could take that much from your testimony. I did read that in your testimony. I'm going to go back and re-ask the question because I'm looking for detail. I want specifics. I want detail. Again, what are the concerns that Evergy has that were not addressed by the compromise, which is the settlement agreement?
So specifically on page 19 of my direct testimony, my condition 1, it indicated that the certificate should be for the project, and that if NETE wants to construct additional projects, including generation lead lines that would tie into the project, it should file an application with the commission to amend its certificate. The settlement agreement addresses that it's specific to the project, and that were they to come in with a separate transmission line project, they would need to come back to the commission. It is silent to any need to come in and ask for an amendment to a certificate should they at some point in the future want to attach a generation lead line to the project. So that's a specific to number 1.
Thank you. Thank you. If I may interrupt you just very briefly, Darren, and I don't mean to have you lose your train of thought.
Sure.
The course that you're proceeding on now is exactly what I was requesting by my question. If we can go through each one of these items, we're focusing on the conclusions and the recommendations that you had initially. I'm looking for the delta. I'm looking for the difference between what you had intended here and what the settlement agreement contains, realizing the position that you've taken with respect to the settlement agreement. Please continue.
Sure. So condition number 2 on page 19 talks about if facts upon which the certificate is granted change, we suggested that NETE should be required to come before the KCC, get its certificate confirmed in light of those changes, or alternative, the KCC could issue a show cause order. The settlement agreement does not address that condition directly. My comfort is that the commission has the authority to evaluate certificates that it is granted, and it has a staff that will be getting reports and various information as a part of the settlement agreement that can draw conclusions as to whether there should be follow-up with NETE Southwest on that. But that's another difference between the settlement and the condition 2 that was proposed. So similar, condition 3, again, it was a very specific condition that we put in around, activities or operation that could cause net detriments to Kansas, that NETE should be subject to proceedings before the KCC, including the possibility the certificate would be revoked. That piece of that condition is not directly addressed in the settlement agreement. My answer to that would be similar to my response to item 2 not being in there. I think the visibility that I hope the reports and the other conditions provide to the commission and parties will create an avenue for the commission to make that assessment of a future need to discuss something like that with NETE should it arise. The second part of 3, talking about compliance with environmental rules and regulations, it is addressed in the settlement agreement. Item number 4 is not specifically addressed in terms of the certificate lapsing automatically if certain steps are not accomplished on the project by certain dates. However, the settlement agreement does discuss information that will be included by NETE in their formula rate filing and the provision of construction reports that should provide adequate detail for the commission and parties to understand the progress of the project as it moves through the construction phase. That's the intent of the ones that are in the settlement agreement. Item 5 is substantially addressed by the settlement agreement. The words are a little bit different, but I know NETE witnesses talked about it yesterday, that there is a commitment to provide NETE financial guarantees over the first 40 years of operation of the line. I know there are some questions to work through that were raised by Commissioner French yesterday. I think those will be resolvable. There have been, parent commitments and guarantees that have been able to be enacted in other circumstances where the parent might not have been a party to a docket or agreement. So I think we'll get there on that. And NETE certainly had already offered NETE guarantees regarding the financing of the construction of the line. Number 6 is another item that was attempting to address the lack of transparency of information at the time that the testimony was put together because of the confidentiality provisions in terms of specifics around caps and exclusions that we suggested the commission may want to put in place and clearly define. We already talked about the fact that some of that specific detail is not in the settlement agreement, although there are commitments by NETE, again, in the formula rate filing to have the type of information in their formula rate filing that will be consistent with the RFP and the bid details that were submitted for the project by NETE, and the hope would be that will be sufficient to allow for identification of concerns when that filing is made and becomes available. Number 7.
Darren, if I may interrupt, let's back on 6 again.
Yes.
I'm at the top of page 20. The sentence there that is, again, I'm drawing from lines 1 and 2. NETE SW should be required to provide specific example as to how its cost cap would be determined. What was your thinking there, and does the settlement agreement address that?
Does not address it directly, although I think that I believe that will be able to be assessed with the commitment that is in the settlement agreement for the formula rate filing that NETE will make to provide the details to show that they are applying the parameters of their bid appropriately in the formula rate filing.
All right, thank you. And then the next sentence, the lines continuing on 2 through 4. How does that suggestion square with the settlement agreement?
I believe that is consistent with the language that's in the settlement agreement on NETE's commitment around the formula rate filing.
All right. Thank you for indulging my interruption there. I think you were headed to paragraph 7 when I interrupted.
Yes, sir. Paragraph 7, as we talked about earlier, the settlement agreement does not specifically address generation lead lines and additional substations that may be attached to the project itself. Certainly the settlement agreement addresses the line itself as proposed to be constructed by NETE, and I think we heard testimony yesterday from the NETE witnesses that they are not aware of any plans at this point for generator lead tie-ins or additional substations as they contemplate the route and the completion of this project. Eight is very similar to some of the things that we've talked about in the earlier items in regards of our interest in more transparency than was available at the time that we put the testimony together, specifically around caps and exclusions. We've already talked about that and where that stands in relation to the settlement agreement and what our hope is in regards to the commitments that are in the settlement agreement in regards to the formula rate filing that NETE will make and some of the reports that they have agreed to make as a part of the settlement agreement.
I may interrupt again.
Yes, sir.
With respect to the statement you just made, I guess my follow-up question, just for clarity, would be, do you believe the settlement agreement adequately addresses the issue of cost caps and cost containment within the context of providing adequate public notice of those matters?
I believe it does, based upon the language in the settlement agreement that NETE has committed to, complying with the parameters that were set out in the RFP that was issued for the project, and ultimately the specifics that they included in their bid related for the project, and the combination of that, the reporting that they have agreed to in the settlement agreement, the FERC formula rate details that they agreed to in the settlement agreement. It's not as direct as we had asked for, obviously, in terms of getting it out in front of the commission at this point, and making sure that the commission was comfortable with the details. all that said, the commission has seen more detail than I have. So I think they will be prepared to make their assessment on that as well. Number 9. Number 9 is in. Number 9 is in the settlement agreement, acknowledging the commission's jurisdiction on items, and there are items to address, affiliate transaction contracts, and also asymmetrical pricing standards that the commission generally employs.
Before we move on, Mr. Ives, if I may interrupt again, with respect to this subject matter, this waiver of statute issue, if I can have you turn back a couple of pages, turn back to page 13 of your direct testimony.
Okay, I'm there.
Pardon me, let's turn to, I misspoke. Turn to page 15, please.
Okay.
I'm looking specifically at lines 6 through 15. The question you were asked here is has to do with the statutes that NETE Southwest is requesting be waived. And you provide quite specific reasons why several of these should not be waived. If you could bear with me, if you could go down through those statements that you'd made, beginning with line 7 through 15, and in light of the settlement agreement, give me your sense about the waiver and its impact with respect to each one of those items you noted there.
Yes, hang on 1 second, please. I'm trying to pull up the settlement agreement, so I've got both documents kind of handy here.
Certainly.
I'm at home under quarantine, so my work arrangements are suboptimal. Yeah, so as you look at page 15, you know, a number of those statutes requested to be waived had really been requested to be waived based upon you know, NETE operating under FERC from a rates perspective. I had indicated throughout this answer that I agree with that from a rates perspective, but that there are other provisions within those statutes that may be applicable to sufficient service and facilities that would go beyond rates. And when you turn and you look at the settlement agreement, you know, the language that's in there on page, I think it's page 12 of that agreement, or item K, you know, NETE acknowledges the commission's jurisdiction under all the statutes not specifically waived by the commission, and that they have the authority to oversee the CCN, including you know, opening proceedings to investigate compliance as suggested. And I think that's what we were really trying to make the point on these items on page 15 of my direct, that the commission should not be interested in just waiving them on a blanket basis, but acknowledging the FERC authority over rates and retaining any other such authorities that they may deem necessary to assert on this CCN made sense to us. And I think that's what the settlement agreement allows for.
Thank you.
I am probably lulling you to sleep. Item 10 on page 20 of my direct testimony, protections for landowners consistent with good utility practice and expectations that the commission has set forth for treatment of Kansas landowners. Certainly have some landowners represented in this proceeding. The language in the settlement agreement does not specifically address this condition 10. I think there will be another docket for the siting of the line, which the settlement agreement does acknowledge that docket won't start until after a commission determination in this proceeding. And I think that will be the place that the commission will probably be most likely to address landowner communications and landowner agreements and things that need to be in place in order for the commission to be comfortable that there are adequate Kansas landowner protections should the siting of the line be approved in that docket. Item 11 has a lot of words in it about compliance with standards in the construction of the line and standards for interconnection and interaction with Evergy. The settlement agreement has provisions in place that NETE has agreed to in terms of interconnection and concerns that we had expressed around Wolf Creek. It has some language in there about NETE's confirmation of adherence to the RFP process and the components that were required to be included based on that RFP and their bid. So I think it's adequately addressed just in different components and in different words in the settlement agreement.
If I may interrupt again, Mr. Ives, with respect to paragraph 11, I'm looking specifically at lines 31 and 32. Your suggestion was that NextEra provide proof that it has resolved the line galloping issues experienced on other Kansas lines. I'm asking for your take on that with respect to the settlement agreement. With respect to the galloping issue, generally, I will reserve my questions for Mr. Harrison. But with respect to this and the settlement agreement, I'd appreciate your take.
Yeah, for sure. And I think Mr. Harrison and Mr. Vetch both can probably share more insight on the galloping issue from an engineering standpoint than I would provide. But and I'm looking forward in the settlement agreement here, I believe, if I can find it, NETE agreed. Yeah, here it is, item I. NETE agreed to provide staff with a copy of a galloping study referenced in response to the staff data request. They also agreed that in the design and construction of the project, they would seek to limit the galloping issues by incorporating mitigation methods derived after the engineering studies are completed, which is implied, at least to me, that will be informed by the galloping study that they are providing. So, and I know there was some discussion on that from NETE witness yesterday, but I think that at least gives the staff and the commission the opportunity to see the assessment that's being done and the mitigation that's being put into the project by NETE related to those earlier galloping issues.
Those forms of proof, the forms that you had in mind with respect to providing proof?
I'm sorry, I missed that, Cherokee.
Yes, perhaps it was inarticulately stated. You've just described, I think, with some detail, the relationship between this issue and the settlement agreement and how you think it addresses this issue. My question is, you're suggesting here that the NextEra provides some proof of the resolution of the galloping issue. Are you convinced that the terms of the settlement agreement get us to that point?
I'm convinced that the settlement agreement should provide adequate information so that the staff and the commission can make an assessment of whether or not the mitigation on the project is appropriate based on the study.
All right, thank you. Again, within paragraph 11, Darren, if you could take a look at lines 34 and 35. It's the next two sentences down. You're concerned about including some provision with respect to cost guarantee monitoring and enforcement processes at the SPP. Is this matter addressed within the settlement agreement?
Well, certainly, certainly the settlement agreement does not address specific enforcement process at SPP as outlined, but it does it does address and this will tie into number 12 as well, right? And we've talked about this some, the provision of reporting and information on project performance through the construction phase that should be beneficial for parties to make an assessment. And we also talked about the transmission formula rate and the details that NETE has agreed to put into that filing at FERC, which certainly can be addressed at FERC by parties to those proceedings should they have questions around the results that are submitted in that TFR filing.
Thank you. On to question 12, if you would.
Yep. So that really kind of ties into 12. There are provisions in the settlement agreement for some quarterly progress and construction reports. They are not, I would say, specifically defined as to the content. This commission and the staff have received historically construction progress reports on different types of projects. So I'm confident that NETE will be able to collaborate with the staff as those reports are getting defined and developed, so that the commission will get the type of information that's consistent with what it's seen in other construction progress reports. So the specifics in the line items are not in there, but I think the settlement agreement suggests that they should be in a form consistent with what the commission has received in other dockets, which allows some flexibility for staff to provide some input into that process, would be my hope. And then to round it out on item 13, on page 21, the emergency response restoration communication plan, the settlement agreement, I do not believe specifically says that they will be approved by the commission, but it certainly says that it will be provided by NETE as part of the information that's listed on page 15, line item 3i, for the response plans and the communication plans. Says they'll be filed. I apologize, that was lengthy, but I hope helpful.
No apology necessary at all. It's exactly what I expected. It's very consistent with your previous testimony. It was quite fact specific and granular, and that's exactly what I was looking for. And I appreciate the fact that you're doing this not feeling well and almost under duress. So my apologies to you for that, and I hope you'll feel better very soon.
Thank you.
That concludes my cross for the time being. I'll now turn to Mr. Zakura. You're muted, Jim. Jim, you're muted.
Good morning, Mr. Ives.
Good morning,
You
Mr.
actually-
Zakura.
You actually look very comfortable.
I am comfortable. I may be sweating a little bit with my recovery.
Well, I'll do my best not to put stress on you, but I'll ask a few questions
Sure.
if I could. And my questions, Mr. Ives, are going to be basically in two categories. One will be the category of the settlement agreement, sir. And the second will be with regard to your responsive testimony of May 27, and particularly your responses to the testimony of Dr. Macomb, which would be on Mr. Ives, 11 to 15 of your testimony, cross-answering testimony. So
Okay.
those would be the two areas of my inquiry, and I'll stay close to the commission's caution to be expedient in my examination. So let me first look at the settlement agreement with you, sir. Your company entered into a settlement agreement that has a number of conditions included in it. Isn't that correct?
Yes, sir.
And so would it be fair to say that you would not be in favor of the granting of any certificate to NextEra absent those conditions?
Yes, sir. I think, we just talked through the differences between our original proposed conditions and the settlement agreement with Chair Keen. I think, the settlement agreement strikes the right balance if those conditions are placed upon approval of a certificate. And I think in large part, if you look back through prior proceedings in front of the commission on transmission only certificates, that they often have some additional conditions and reporting requirements and things like that that the commission has imposed. And many of these are similar to some of those prior dockets?
Let me just speak to one part of the settlement, first of all. Why is it imperative on the commission to say they do or do not have jurisdiction under any kind of statutes? Why does that belong in the settlement agreement?
Well, I think like many things in a settlement agreement, it's intended to add clarity around, in this case, whether or not the commission has the jurisdiction over rates, which I think, it's my contention that FERC for transmission projects like this has that general rate authority. And as we talked about, it's also my position that there are components of those statutes that are listed there that go beyond just rate making, that the commission probably does retain jurisdiction on, but it's an effort to add some clarity for parties that were interested in signing on to the settlement.
Would you sign on to that settlement? Excuse me, I keep doing that. Would Evergy agree to the settlement without the admission of jurisdiction or no jurisdiction by the KCC on any of those statutes?
Well, I would suggest that Evergy's concern was, which was the request by NETE Southwest, was for waiver of a number of those statutes. I would be more concerned if the conditions provided for the waiver of a number of those statutes, some of which I think have areas of applicability for facilities and services. I guess if the commission didn't want to specifically state that FERC had the authority over rates, that'd be a discussion that the signatories would have to have if that change came through, and see if it was still worthwhile. Hard to say without seeing specific language.
Well, were you concluded, Mr. Ives?
I think so. I was just going to say, Mr. Zakura, I believe the commission has, in prior cases, concluded that FERC has the authority for transmission level interstate rates. That's why I'm not concerned that language is in there. I don't think it's inconsistent with positions the commission has taken previously.
Well, Mr. Ives, let's set aside that for a question. Based on my experience and practice of law, jurisdiction is very often fact specific. Why would the commission in a settlement agree that they don't have jurisdiction when we don't know what the facts would be at the particular time?
Well, Mr. Zakura, I've probably given you all the answer I can give on that. As you know, I'm not an attorney. I've shared my opinion on it. I'm sure the parties will brief their views on that. This is a little bit more of a legal question.
Okay. Well, fair enough, Mr. Ives. Let me turn staying with the settlement agreement. Let me ask you a few other questions. Okay. Now, would you agree with me, Mr. Ives, that because of the conditions that are in the settlement agreement, that the notice to construct will have to be readdressed by the Southwest Power Pool?
I don't know that I would agree with you on that. I think I would agree that there certainly will be dialogue with the Southwest Power Pool if this certificate is approved with these conditions. I assume you're referring to the shift in the boundary of the line to be outside the property line of Wolf Creek. And if that's the question, I don't know that the NTC, I don't know that that's a significant enough change that the NTC would need to be modified in order for that to happen. But it'd be worthy of a discussion with SPP.
My question, sir, was a little bit broader than that. For instance, there's been much discussion about the 25-mile co-location with Evergy. And as I understand the testimony of the NextEra witness yesterday, that's yet to be determined whether or not that would affect the price or the bid that NextEra made to SPP. If in fact, sir, that increased the bid, would you in that instance agree that it would have to go back to Southwest Power Pool for further consideration and either affirming or denying the, I don't want to use initials, notice to construct?
Yeah, so fair enough. I understand your question. That's a little bit different question because I don't believe the settlement agreement requires for that double circuit to be done. It requires for it to be considered and evaluated. So if ultimately the decision with NETE Southwest in conjunction with their coordination with Evergy was that it was something that might be possible, I think you're right. That would likely require dialogue with SPP and consideration of changes to the NTCs. Too early to suggest what all that might entail, because as you heard yesterday, and I agree with, there would be a significant amount of work and discussion and coordination and negotiation that would be required to understand those details before making that determination.
Let me ask you one final question on this, just as a hypothetical, Mr. Ives. What if that discussion ended up that the price increased by $10 million to do the co-location? Would you in that instance say that there would have to be a new NTC issued?
Mr. Zakura, I think if there were a decision made to pursue a double circuit option after all that work that I discussed, I think likely there would need to be additional work done with SPP in consideration of the NTC. I'm not sure I would put a dollar threshold on it, but I think it is likely if that were a change in the way the line was being put in.
And I said final question, but I hope this is the final question on that, Eric. If should there be a condition on this in the settlement agreement, in your company's opinion, that would allow for an increase in the notice to construct in order to accommodate the co-location?
At this point, I don't think it's my company's opinion, I guess, or in my opinion, not necessary, because the commitment in the settlement agreement is to make a good faith assessment of the viability of doing that.
Is the good faith assessment dependent upon no increase in the cost?
I think it's dependent on a whole host of things that have been yet to be determined.
Mr. Ives, may I please turn you to your cross-answering testimony, sir?
Yes, sir. Where
And
you had mentioned for where you had mentioned starting on page 11?
Yes, sir. And that is the portion of the testimony, Mr. Ives, where you're being responsive to Dr. Mackholm's testimony. Do you have a chance to get to that, sir?
Yes, sir, I have it.
Okay. Now, you speak in terms of reliability benefits in your testimony, your responsive testimony. And I have a few questions I would like to ask you about that. Okay. The first question is, Wolf Creek has been there since 1985 and producing power since that time. Are these reliability concerns you're talking about new? And if so, what has caused them to become, or at least in your opinion, come to the forefront?
Sure. You're correct. Been there operating since the mid 80s. But that means two things, right? Much of those facilities are vintage mid 80s now, which brings a different level of maintenance and reliability as time has passed. And two, certainly the market in the surrounding area and the prevalence of other generation sources in that part of the state. It's different than it was in 1985.
Well, I have a couple of questions on that. When you speak of different generation resources, are you speaking of wind generation?
Yeah, primarily. I'm not an engineer. I haven't done an assessment of all the things down there, but I'm sorry. I am certainly aware that there are, wind facilities that have attached to the system in that general part of the state. Yes.
And I'm pretty familiar with the operations of Evergy. They haven't built any fossil fuel generation in that part of the state for some time. Is that correct?
That's correct.
And you speak of the vintage of some of the lines. Let's go a little slower on that. There's already existing three 345 kV lines. Do you know when those were built and how long they've been in operation?
I suspect that's a better question for Mr. Vetch. He'd probably be a lot closer to that than I would be.
Okay. Now, you speak in your testimony about unplanned transmission outages that are due for various reasons. And I want to ask you about that, sir. When did those unplanned outages start? How many of them are there? What were the durations? Let's put some quantification around that if I could.
Yeah, so that's not really the intent of my testimony and not the type of information I'd be able to provide you. The intent of my testimony in that area is to acknowledge that it sounds very resilient to indicate that there are three lines coming off of Wolf Creek. But in the circumstance of a nuclear facility, and Mr. Vetch can probably elaborate on this better as well, there are certain contingencies that are required to be maintained for the safe operation of a nuclear facility. One of those would be if that one of those lines is down for a planned or an unplanned reason, maintenance or service, that Wolf Creek is no longer allowed to operate under its regulations at full output if it's down to two lines that are in service. When you add a fourth line, it creates additional flexibility to say that if you did have one of those outage needs, or planned or unplanned, that you have a little bit more flexibility in terms of continued and maintained operation of the nuclear facility. I'm not suggesting it. Let me just say, I'm not suggesting at all that there have been reliability concerns or issues with the operation of Wolf Creek. I don't want anybody to take that away. I think you know, and parties know that Wolf Creek operates at a extremely efficient and proficient level. But those are the realities of the regulations that Wolf Creek faces relating to those lines.
I think you were anticipating my question, Mr. Ives, and I appreciate that. The Wolf Creek operating history is excellent. Wouldn't you agree?
By and large, yes, absolutely.
And there's no history of outages where Wolf Creek has been down because of transmission line unavailability that I'm aware of.
I'm not sure that I can address that, Mr. Zakura. I don't know if I'd say history, but I suspect over time there have been times when, for one reason or another, storm or other reasons, one of those lines has been down, which has probably required Wolf Creek to modify its operating parameters during a maintenance or repair.
Now, this gets to my further question, and what we always try to do at the commission is to quantify the general statements. Are you able to quantify how many times since 1985 Wolf Creek has been down because of some kind of unplanned outage and suffered from not having a fourth line?
No, sir, that's not the intent of my testimony. And I want to be super clear again. You continue to say Wolf Creek is down. What I have said that is if one of those lines is down for maintenance or not available for service, Wolf Creek would have to modify its generation profile, not go down, but it would have to modify its operations that it would not have to do with the fourth line in place.
Let me follow up with a question on that. You spoke in terms of it was down for maintenance. Well, that happens frequently, doesn't it, or on some kind of a plan schedule?
I'm talking about the line.
You're not talking about Wolf Creek. You're talking about the line at that point.
I'm talking
correct?
about if one of the three lines is off service, the implications that it can have on the operating parameters of the plant. That there would be more resiliency and less risk of that with a fourth line out of Wolf Creek.
Let me ask you a question. You talk about, as I understand your testimony, sir, you talk about increased reliability with the fourth line. Have you quantified that benefit? Because it's not in your testimony.
I have not quantified that benefit. I have certainly discussed with our engineering team our belief of the reliability benefits of the fourth line on operations in that part of the state. And I think we heard yesterday, and hopefully we'll hear more from SPP's witness, some of the reliability and economic benefits that the SPP study process considered in selecting this line.
And you did hear the testimony yesterday that, as I understand, no, let me rephrase that. And it's your understanding that SPP quantified benefits based on their portfolio of ITP 2019 program.
It's my understanding that SPP's witness will be the best person to have that discussion in front of the commission.
Mr. Ives, I thank you for your testimony. I wish you well. I hope you get to feeling better. Thank you, sir.
Thank you, Mr. Zakura.
Thank you, Mr. Zakura. My inclination is that we take a break. We've been going for an hour and 20 minutes here, I think in the interest of our court reporter and perhaps many of our participants. Let's take a 5-minute break at this time. We will recess. We'll be in recess until 10:25.
Chair Keen,
Yes.
can I ask that we do a slightly longer break so that we might have a breakout session with the commissioners to discuss the issues related to the leases you requested?
I'm not sorry, what are you proposing again?
just a breakout session with the council and the commissioners to discuss the leases you requested earlier.
Yes, yes, we can do that. Let's go ahead and take a break. We'll return from break and then we may actually do that.
Commissioner?
Mr. Kimmel?
Yes, this is Rustin Kimmel. I just want to renew my objection based on KSA 66-106A that allows for no person desiring to be present at a hearing by the commission shall be denied admission. So I would object. I understand the commission intends to go into a special session that we won't be included in. However, I believe that KSA 166-106 requires all persons to be admitted to those hearings. Thank you.
So your objection is overruled and it is noted.
Thank you.
All right. Let's have a break for the benefit of all parties. We'll come back on the record and then we'll consider the request by Mr. Cohen. It's now 10:21. Let's resume here at 10:26. We're in recess until 10:26.
What exactly are they?
Denise, are you ready?
Yes, I am. Thank you.
All right, very well. It's now 10:28. We are back on the record again. It's been requested that the commission return to executive session. That would include myself, Commissioner French, Commissioner Duffy, and our counsel, both David Cohen and Brian as well. So we're going to do that. We're going to retire to executive session. Denise Hass's court reporter, you will not be a part of that. Having said that, we will, at this time, Denise Grau, if you can make the arrangements so that we can move to a breakout room, I'd appreciate it.
Breakout room is ready and I will open it now.
Thank you. Denise, if you could bring us back to the open session. Here's where there. Denise Haas, are you ready?
I am, yes, thank you.
All right. It is now 10:55 a.m. and the commission is returning from its deliberative session. Mr. Schulte, are you here?
I am.
Okay, very good. During the deliberative session, the commission considered my request to you regarding providing the executed agreements of the option agreement and the easement. The commission now has collectively, I had requested that myself. The commission now is requesting you to consider stipulating to providing us with the number of executed agreements that you have and provide us with some indication of how many of that number involve the exchange of monies without telling us specifically what those monies are. And that you confirm that all of the executed agreements are identical to and in the form of your form agreement for this purpose. Are you amenable to that stipulation? And that would be in lieu of providing the executed agreements themselves.
I'll need to, in lieu of, yes, understood. Can I confer?
You can confer, and once again, we're going to move on with the hearing. So we will maybe take this up. You provide some notice about where you stand on this issue, if you would, to David Cohen. And that way we can do that without further delay in the public forum.
Thank you.
And we can announce in public forum certainly what your decision is. Fair enough?
Understood. Thank you.
All right. Very good. Let's return now. Darren, are you here? Darren Ives. Yes, you are.
Sir. Yes, sir, I am. Good to see you again.
Thank you for your indulgence. Sorry for the interruption of your testimony. Let's return to your cross-examination. I would remind you that you remain under oath. We'll turn next for cross to Mr. Kimmel. Do you have any questions of Mr. Ives?
Yes, Commissioner, I just have a couple questions for Mr. Ives.
All right.
Mr. Ives, good morning. My name is Rustin Kimmel. I represent Darren McGee and Rochelle McGee Smart. I don't believe that we've ever met before.
We haven't. Good morning, Mr. Kimmel.
Good morning. Commissioner Keene asked you several questions regarding the conditions that you believe that the commission should incorporate into a certificate earlier this morning, specifically in regard to your direct testimony on page, I'll direct you to page 20, paragraph 10. I guess I'll first ask the question. I assume you recall Commissioner Keene's questions, correct?
Yes, sir, I do.
Okay. In response to Mr. Keene's question, as it relates to paragraph 10 on page 20 of your direct testimony, I'm going to paraphrase your testimony because I don't have a written transcript of it, but what I took away from it was you believe that the landowner issues could be raised and addressed in a later docket. Is that a fair summary of what your testimony is?
I think so, Mr. Kimmel. I probably did not say to Chair Keene, but I believe this to be true. I believe the commission, has the authority at any point to investigate, complaints or issues that Kansas landowners may be having with somebody seeking to construct on their property. That said, I also think that is a likely topic in consideration as we move into that siding docket. Yes.
One of the, I'm sure you know this, but one of the issues that the landowners have raised is they're concerned that NextEra is conducting business without a certificate of convenience in violation of 66-131A when it engages in negotiations of easement agreements and access agreements. Are you aware of that?
I am aware of the position. Yes.
Yes. Could you explain how, by waiting till a later docket, that the commission can appropriately address the landowner's concerns that NextEra is now conducting business without a certificate of convenience?
Yeah, Mr. Kimmel, from my perspective, and NETE Southwest certainly better addressed to answer some of these questions and concerns on this project, but from my perspective, they are certainly not executing. At least my belief, eminent domain. They're not in a position to do that. They probably can exercise the ability to enter option agreements, which is different from my perspective than eminent domain. So I think that still leads me to the conclusion that when you get to the siding document or docket, that would be a time where would want to make sure that there were adequate protections for landowners before there were actions taken on any sort of eminent domain basis.
Mr. Ives, would you agree that entering into access agreement and easement agreements is conducting business?
I'm going to object because I think that you're asking Mr. Ives to provide a legal opinion, and he's made clear in his testimony he is not a lawyer.
Sustained.
Mr. Ives, I'll represent to you that the plain language of the statute KSA 66-131A specifically prohibits conducting business without a certificate of convenience in the state of Kansas. Do you think that it is, or excuse me, strike that question. Referring back to your direct testimony, paragraph 10, you suggested to the commission that the commission should impose protections for landowners consistent with good utility practice. Is that an accurate statement of at least a portion of paragraph 10?
Yes, that covers the first half of 10 for sure.
Do you think that it is a good utility practice for NextEra to conduct business without a certificate of convenience?
I would.
I'm going to, excuse me, Darren. I'm
Sure.
going to register. I'm going to register an objection again, because I again think are they conducting business is the legal analysis of the statute. So same objection. Mr. Ives is not an attorney.
Sustained.
I have no further questions, Commissioner. Thank you, Mr. Ives.
Thank you, Mr. Kimmel.
Thank you, Mr. Kimmel. Let's turn to my fellow commissioners, see if they have any questions via Mr. Ives at this time. I'll begin with Commissioner Duffy.
Thank you. Mr. Ives, so there were a number of bidders on this project. That's correct, and Evergy was one of them. Is that correct?
It is my understanding that there were a number of bidders, as at least identified by alphabetical nature in the IEP report. And Evergy did have part of one bid in that process, yes.
Were you surprised that you did not receive the award? That Evergy did not receive the award?
I don't know that I would say surprised. If there's one thing that that we have learned in the competitive transmission environment, it's very competitive right now. But I think we felt like we made a very compelling bid to be considered by the independent panel.
Okay, thank you. Thank you, Mr. Ives. I hope you begin to feel better.
Thank you, Commissioner Duffy.
Thank you, Commissioner Duffy. Commissioner French, any further questions of Mr. Ives?
I've got a couple, and I can hear your voice, Darren, so I'm going to see how long I can make you talk.
Awesome. I'm ready.
I'm just kidding. I will keep these brief. So there's been discussion of a couple potential changes to the project, one of which is probably the much more significant change of double circuiting an existing line. That obviously holds a lot of allure from the perspective of not impacting Kansas land. But I understand there's potential cost implications with that. There's a lot of analysis that would have to go into whether that's viable. So it seems pretty attenuated at this point of going down that path. So I'm not going to ask you questions about that right now. I understand the discussion that's taken place, but I did want to address with you the smaller but more specific change to the project, which was moving the interconnection point from I guess inside the fence line to outside the fence line at Wolf Creek. And if you listen to my questions, I think you caught that my concern was just, does moving that interconnection point, does it somehow I assume that would require Evergy to construct some more facilities to reach that interconnection point. Are those sponsored upgrades that Evergy and its customers are going to have to pay for, as opposed to being a portion of the project that would be paid for spread across the whole region? If you could just give me a little of your thoughts, if you can, on what the potential cost impact could be of moving that interconnection point.
Yeah, no, that's a fair question. I think, if you start back at the beginning of the discussion, right? We talked about that what SPP really does when it sets out NTCs, right, is it picks interconnection points, and then it says, we're hoping the bidders will find a path to put these interconnection points together, right? They don't get in the business of selecting path, selecting route. That certainly will come. We've talked a lot about the $85 million, the line component, related to NETE Southwest. Evergy has an NTC on the project as well, right? Because we have an NTC to do the work in the Wolf Creek substation and the interconnection work to that substation. So that NTC for us works similarly to NETE Southwest. It is part of the regionally funded project that was sent out, and that is how it will be charged out by Evergy. So were we to add that 1.5 miles of line to move it past the fence line, that would fit within that. So it'll be regionally funded, just like it would have been were NETE Southwest to put that line in.
Okay, so it remains part of the NTC receiving regional funding. It doesn't become a Schedule 9 or a sponsored upgrade chargeable just to Evergy's customers.
That would be my understanding.
Okay, that is exactly the answer I was looking for. The only other question I have, and I guess, feel free to defer to SPP's witness on this, but you're the policy witness for Evergy. I think you have high level visibility into SPP's planning processes. I guess I want to ask your expert opinion on some of, I guess, the rate impact issue as it relates to the Evergy companies, the KCP&L pricing zone and the Westar pricing zone. I looked at the ITP report, the 2019 ITP report. I'm going to reference some of the pages from it. If you want to have it in front of you, I don't think it's probably necessary. But I know in Ms. Walding's testimony, she went through the list of projects that's right up front at the beginning of the report. I think, my count was there's 34 reliability projects, there's 9 economic projects. My understanding is, the reliability projects, there's just associated with those, there's not necessarily benefits that go into the cost benefit analysis when you're looking at those. And so the benefits come from the 9 economic projects. I think Ms. Walding indicated there's really 2 of those projects that are big and that are providing the bulk of all the benefits that outweigh all the costs of the reliability projects in this portfolio. And I think it was her expert opinion that, if you look at the electrical system and, you're, while we don't maybe have a specific cost benefit for the one, the Wolf Creek to Blackberry, that if you really look at it, that's about the only place all of the benefits flowing to the Westar and KCP&L zones could be coming from. And I think it was her expert opinion that that it is either very likely or it just is her opinion that it's a driver of net benefits to your zones. Do you share that opinion at a very high level?
Yeah, I did hear her testimony yesterday on that. By and large, I generally agree with that. It is not perfect, right? When your question is, give me some very specific details on this one project and, put it down to a customer level, that's not really how the process is designed to work at SPP and how the cost allocation process has been developed and, all the things that we could talk about. But that said, I think the process that SPP has in place, certainly stakeholder developed, agreed to, approved by FERC, and I think it is as good as we have to look at projects to benefit the region and Kansas customers. SPP was very specific when they did that ITP study around focusing on that area in Kansas. They had identified that as a priority for congestion and economic relief. And certainly this project came out on top as an effort to alleviate that. So I feel confident after all that work that it's the right project for the issues that are going on down there right now.
Let me ask the question a slightly different way. And I'll ask this question of SPP as well. If SPP and all the member utilities were to build all of the reliability projects and the economic projects, but remove the Wolf Creek to Blackberry line, would you expect that to have, would you expect that to benefit positively or negatively Westar and KCP&L customers or Evergy customers? From I guess just an economic standpoint, I think the reliability benefits are, we'll say, separate.
So if the portfolio moved forward without this line, what would I presume the impacts would be to Evergy and its Kansas customers. I think it would be, I think it would be detrimental as compared to having the line constructed. We are supportive of the line. We think it's important. Our questions were around adequate protections to understand that it was going to be done, reliably and consistent with how to interconnect with our system and with enough protections for Kansans. But we have always been supportive of the line.
So if we go forward and we build all the reliability projects and we build all the economic projects in other states and we pay our share of those, but we don't build the economic project in Kansas, your high level opinion is that would be a net detriment to your customers.
That would be my opinion. I think you would still have two things. You would still have less resilience around having a fourth, not having a fourth line at Wolf Creek and some of the discussion I earlier had. And I think you would still have a high likelihood of congestion in the state that, my view of congestion is it's a market inefficiency that suboptimizes outcomes for customers for the ability to get low cost energy to load.
Okay, so I wasn't going to go there, but I actually, that's something I want to ask about real quick. Just Evergy's view of congestion relief. First of all, would I be correct in saying that levelizing LMPs is not just a zero-sum game, in that it doesn't just mean one side goes up and one side goes down. It is also an optimization exercise to let more low-cost energy on for the entire region. Is that correct?
That's exactly right.
The other, I guess the other thing I wanted to explore is, right now, you would agree that there are times where our region, particularly Western Kansas, but also much of the Evergy area experiences negative pricing at times, correct?
Yes, sir. That's true.
And would you view that as a signal of a healthy market or a healthy price signal to your generation?
No, not at all. Not at all. I mean, that continues to be, an ongoing inefficiency of the market operation that I hope we continue to work on through additional transmission projects coming online and leveling out some of the congestion that's causing that, because it does not create appropriate price signals for generators, and it certainly doesn't always put you in a spot where you have the least cost resource available for service to customers in the state.
So I won't, I know that one component of this ITP is some higher locational marginal pricing in the Sunflower or Western Kansas areas. And I won't necessarily ask you to speak to their operations, but if you could maybe just talk about, if you were to see a slightly incrementally higher locational marginal pricing or less negative pricing in your zone, I guess, could you speak about what the benefit of that is? Or I think you said there is a benefit and it's a function of a better market, or it indicates a better market, but maybe in just real world terms, why is that good for customers?
Yeah, so I think I think with the appropriate price signals, it allows the market participants to get the price signals, and it allows SPP to dispatch appropriately based on the true cost of generators in the market. And it begins to get distorted as you have negative price signals or other things where probably suboptimal allocation of generation across a footprint occurs. You always want to have the most efficient market you can have with the most effective pricing signals, so that that supply is getting allocated to load at the least cost nature. And when you have congestion noise in that process, it makes it less likely that that occurs.
I might be extending myself a little, but would it be fair to say that we have some traditional resources in this state? And when I say traditional, I mean fossil resources, coal and natural gas that might be, I guess, when they experience negative pricing or depressed pricing due to congestion in the market, they probably are not receiving a great price signal and may not be able to achieve revenues to sustain them. Even though we need them for reliability, the market might not be sending that signal. Is that a negative impact of congestion and depressed market pricing and the need, and I guess an indication of the need for levelizing LMPs?
Well, if you extended yourself, you did it pretty well. I agree with that.
I guess it was a leading question. All right. Well, I don't think I can think of anything else to ask at this point. So I think we'll let you off, Mr. Ives. Thank you.
Thank you, Commissioner French.
Yes, thank you, Commissioner French. Commissioner Duffy?
Yeah, if I could, Mr. Ives, back in Dr. Loomis's testimony, he does refer to, I believe it was $10.1 million for substations. And I think that was, if I'm remembering correctly, identified to Evergy. So that's not the movement outside the Evergy boundary of the interconnection. That's something different.
That's correct. I mentioned that that we have been issued an NTC related to this project,
Right.
so that we can do the appropriate substation upgrades and interconnections to the Wolf Creek substation and support the interconnection of that fourth line. So that would be funds that's part of our NTC, and as I mentioned to Commissioner French, that will be regionally funded, just like the line portion that we've spent so much time talking about with NETE.
So that is the $10.1 million that was identified in his testimony.
I think so. My only caveat, Commissioner, and maybe Mr. Vetch will know specifically. I'm not sure if that's all ours. There's also an interconnection point for the project with AECI. So I'm not sure if it's both or if that is all our NTC.
Okay, thank you. And then furthermore, have you quantified the reliability savings you incur by having that fourth line so that you don't have to take down Wolf Creek for any number of reasons? Is there a dollar amount that can be identified with the reliability issue of the fourth line?
Yeah, that I hate to do this because he's kicking the table right now. Probably I might defer that question to Mr. Vetch.
Okay.
My guess is it's probably not super straightforward to calculate that, but Mr. Vetch should be best suited to answer that.
Okay, thank you. Thank you, Chair King, for allowing me to revisit.
Certainly. Ms. Kafer, any redirect?
I just would like to make one clarification with you, Mr. Ives. You were asked about whether Evergy was a bidder on this project. Was Evergy as an entity the bidder, or was it an affiliate?
We actually did have a component of one bid in the process as Evergy.
Okay.
But we also had an affiliate that was involved in the process.
Okay. Thank you. That's it.
All right, very good. Mr. Ives, I believe we've we've reached an end for your testimony and your being subjected to cross-examination. We very much appreciate your appearance here today and your responses. I personally appreciate your responses to my questions as well. And so at this time, you are excused and dismissed, and we wish you the very best in your recovery, and we hope it's soon.
Thank you, Chair Keenan, commissioners.
Thank you. Okay. Ms. Kaver, if you would, please call your next witness.
Everybody calls Mr. Kelly B. Harrison.
Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Okay, will you state your name and your address for the record, please?
Kelly B. Harrison. I reside at 1012 Mound Ridge Drive, Lawrence, Kansas, 66049.
Okay. And are you the same Kelly B. Harrison who caused to be filed in this docket direct testimony on May 17th, 2022, and cross-answering testimony on May 27th, 2022?
Yes.
And do you have any corrections that you would like to make to that testimony at this time?
No, I do not.
If I were to ask you the same questions today as are contained in your direct and cross-answering testimony, would your answers be the same?
Yes.
I'd like to move for the admission of the direct and cross-answering testimony of Kelly B. Harrison into the record.
Is there any objection? Without objection, it's admitted.
Tender Mr. Harrison for cross.
Very well. Good morning, Mr. Harrison.
Good morning.
Let's turn first to the commission. See if commissioners opt to ask questions of you or defer. I'll turn first to Commissioner Duffy.
I'll defer. Thank you.
Thank you. Commissioner French.
I don't have any questions at this time, but would reserve the right to ask after cross. Thank you.
All right, thank you. I do have several questions for you, Mr. Harrison, as you might suspect. Let me ask you an overview question here. I'm going to turn back before I do that even. I want to make sure that I'm clear about your background. I'm looking on page 2 of your direct testimony here where you set out your background. If I were to summarize that by saying that it's extensive, it's detailed, and it's largely focused on transmission issues, would that be a fair overgeneralization?
I would say I have spent a lot of time on transmission issues and in regulatory and environmental.
I appreciate your humility, sir. I think you're an interesting witness because you have, at least as I'm seeing it within your experience, extensive transmission related experience. Would you accept that?
I would.
All right. Several questions. Let me start by asking you this. What bidding factors within the scheme of the SPP request for bids in this particular case you think contributed most significantly to NextEra's low bid for the Wolf Creek Blackberry line?
When you say bidding factors, I believe the cost portion of their bid was the driving factor for why they won the bid.
Very well. Then in connection with cost, what factors there do you think provided them with the lowest cost bid?
Well, I've been out of the business for a while, so I don't know what labor costs and equipment costs and such has done in the last 4 or 5 years. But I can say that the cost per mile that's in that bid is much lower than anything I can remember. So I don't know if they've got just great negotiated contracts with vendors for materials and equipment. One of the things I learned in the discovery is they are going to use non-union labor. And I do think that makes a difference. And the other thing I note, when it compared to the SPP original estimate, which we just looked at a second ago, they estimated 105 miles for the length of this line. And I believe NextEra's NETE is assuming 94 miles with the one route they've proposed so far. So that's, taking 10 miles off of a line, if you assume it's $1 million to $1.5 million a mile, that's $10 to $15 million right there off of the starting point from what SPP had. So those two drivers for sure.
When I look at your direct testimony somewhat holistically and try to identify some of the major concerns that you have, this is the list I come up with. And if this list if it's misrepresented, if it's inaccurate, if it's incomplete, please tell me. But this is the list of concerns I see that you have raised: reliability, safety, management and resource commitment to prompt resolution of problems and emergency responses, landowner relations and dealing with local issues, coordination with other utilities, with what I would perceive as being an overriding concern about affiliate transactions and cost caps. Again, is that a fair overgeneralization?
I'll give you the liberal generalization of what you just said to me.
Say again.
I would say that's a fair generalization of my testimony. I gave you the liberal view of that.
I see. Were you in attendance yesterday when Mr. Mayers, on behalf of NextEra, provided testimony?
Yes.
I would appreciate your take on his testimony regarding the extensive use that was proposed by NextEra of spun concrete poles.
Well, with respect to spun concrete poles, I don't have any issue with spun concrete poles as far as the structure goes. He apparently thought I did, but I don't. We looked at those late in my career at Westar. And the last time we looked at using concrete poles, one of the big issues was the cost of distribution, or getting them from the plant to the location, because they're very heavy. As I noticed in my testimony, it's what I think 20 to 50 tons, something. They're weigh a lot, 20 to 40, 25, 40 tons, whatever it is. So we looked at those. I do not have an issue with the spun concrete poles. The only ones that I believe that from the old Westar property that I oversaw, we had on our property was down in Wichita, but they were from a much older vintage, and we did have problems with them with freeze and thaw cycles that we have here in Kansas, causing them to fracture and actually retain water. So, there hasn't been a lot of use of concrete poles in Kansas for any a long period of time. And I mean, I'm talking 20, 30 years. I realize that NextEra uses them down in Florida and have for years. That's not the same environment as Kansas. But again, I'm not opposed to a concrete pole if it does its job.
I believe it's been proposed that there are going to be 500 plus poles for this line, and that struck me that it was like 80% or 90% of those will be spun concrete, and that doesn't provide you with any concerns prospectively.
Not as long as they're designed to handle the forces that are required by SPP. And I have confidence that the engineering firm that NextEra uses will do that.
Okay. What about the utilization of down guys?
I have never been a fan of down guys. Anybody that knows me from this company knows that I do not like down guys. And just the experience that we've had with lines that have a lot of age to them, down guys fail. We've had lines fall down across a road because a down guy fails. We had farmers, tear into them. In a city, they certainly are a problem for traffic safety. Somebody runs into them. But that's true for a pole too, but they can hit a down guy. And whenever a down guy is, taken out, it's removing the strength of that structure. So I've always limited the use of down guys when I was over transmission. And I did say there's probably certain areas, because I do know it costs more to not have down guys. You put a self-supporting structure in it, you have to drill a hole, put a foundation in, and use a bigger structure, a stronger structure. So there's a cost element to that. So that's a trade-off that the commission will probably look at in the siting application with landowner requests of not wanting down guys in certain places. I do think in large open spaces like pastures, there's probably not a big deal, but to use a down guy in that area, like I said in my testimony. But there's a lot of places that I would suspect that landowners will not like them. And from a safety standpoint, the communities probably don't want them.
Within your direct testimony, you expressed some reliability concerns about the issue of line galloping.
Yes.
Yes. Do those concerns remain?
I'm always concerned about line galloping on any transmission line. And the reason I raised those was because of what the commission staff had learned in a data request response on how certain lines were operating in Kansas. I believe they're generator leads that NextEra has. And so my request was that NextEra provide a solution to those galloping issues. They can occur throughout the year. It's not necessarily just with ice. And there's many different ways to mitigate them. And it really has nothing to do with the type of structure. So the concrete pole's not going to make a difference. It does have to do with the spacing, as Mr. Mayor's pointed out. It also has to do with, I believe, the span length between structures. And so one of the ways to make a line less expensive is to stretch out the spacing between poles. And certain things can happen as a result of that. So we did ask for in the settlement that they provide a study. I have confidence that the engineering firm, again, that is going to do that study for them will find a solution. At the end of the day, if it still has problems, I'm confident the staff can come back and request further changes to be made if necessary. So I think with what's in the settlement, I'm comfortable with the issue of line galloping.
All right. In this particular instance, what major concerns or risks give you potential costs, cause for concern with respect to potential cost overruns?
Well, now that I know more about the cost cap and how it's meant to be calculated, which then they did provide us a number in our settlement discussions, I have less concern about the cost of the line. If NextEra shareholders want to take the risk of, building this line and possibly coming in more than the cost cap, that's their prerogative. So the settlement discussion or the settlement we've submitted, I believe, takes care of my concerns with the cost cap, specifically understanding some of the other cost containment items within that.
Post-settlement agreement, what concerns, if any, do you have with affiliate transaction costs?
None at this time. That was another item that was included in the settlement, was to do asymmetrical pricing.
And that gives you some comfort.
Yes. I'm confident staff will make sure that happens.
Okay.
You have a great staff, by the way.
I agree.
You're fortunate.
If you could, Mr. Harrison, I appreciate your indulgence. If you would turn to pages 24 through 26 of your direct testimony.
Yes, I'm there.
Of course, what we find here, beginning on line 20 of page 24, carrying over to the conclusion of your testimony here, is a summary of the pre-settlement agreement concerns that you had expressed in the form of conditions you were suggesting that the KCC should consider imposing upon NETE as the operator of this line. Am I correct in summarizing that?
Yes.
And what you've identified here are essentially, as I count them, 7 concerns. Many of these we've already addressed with Mr. Ives. As you look through, I'm going to ask you a really holistic question. As you look through these list of concerns that you had, and you view those through the prism now of a post-settlement agreement circumstance, are there any of these concerns that remain? If so, which ones?
Well, in the very first one, definitions for certain exclusions, and one we can't talk about without going into confidential session, is probably the one that would concern me the most.
Okay. And again, without forcing you to, I'm not trying to, there's no tricks here. I'm not trying to indirectly do something that circumvents what we cannot do directly. But generally, I take it what you're concerned about is the level of specificity and detail within those definitions. Is that correct?
Well, in one particular word or exclusion that I went into a lot more detail in on my cross-answering testimony, which you would have, and most of which I have discussion in there, is all confidential. But if you were to read that, I think you know which term I'm talking about.
Fair enough. Any others within the list of 7 that you have post settlement agreement remaining concerns?
No. In fact, some of these were addressed verbatim almost in the settlement, and maybe a little bit beyond in terms of reporting. And so I would commend NextEra for reaching the settlement that we have.
Very well. Well, that concludes my questions of you thus far. Mr. Harrison, I appreciate your testimony very much. Let's move on here. Mr. Zakura, any questions for Mr. Harrison?
No questions for this witness.
Thank you. Mr. Kimmel, any questions of Mr. Harrison?
No questions.
Thank you. Mr. Astrab, any questions of Mr. Harrison?
No questions for me. Thank you.
Thank you. Mr. Jevons, any questions for Mr. Harrison?
No questions for Mr. Harrison from staff.
All right, I'll turn to my fellow commissioners and see if they have any questions at this point. I'll begin again with Commissioner Duffy.
Thank you. No questions.
Thank you. Commissioner French.
Just one question, and it relates to the spun concrete poles and whatever experience you have with that. I understand, the technology and procurement may be part of the competitive or confidential competitive, but I guess generically, what I'd like to ask about is, I'm concerned by your comments that we don't have a lot of experience placing these poles in Kansas with our freeze thaw cycle. I'd agree with you that it's pretty different than the Florida freeze thaw cycle. And I'm concerned by your limited experience that at least the poles that Westar had were maybe not holding up so well. I think you indicated those were probably a much earlier vintage, perhaps a different technology. But if you could elaborate on that to help me understand why you have comfort with the proposal that, obviously we don't want to see 100 poles go up and then the ratepayers pay twice because we've got to replace them all with steel poles. So if you could just elaborate on why you have comfort that this technology is going to work.
Well, one, NextEra has used it, obviously, in many places. The technology, I'm absolutely confident, is much different than the structures I was talking about. Were probably, I think they were in the mid 80s that were put in the Wichita area, only for a couple of miles. And they certainly beat wood, but particularly on an open prairie that burns a lot. So, yeah, like I say, we looked at concrete poles before, and I think with Valmont, they're a very well-known vendor. They provide the steel structures that we've used. So they're a well-known, well-established vendor. So I have confidence that it'll be a good product.
Okay. So I guess that there is you think there's a pretty big difference between the technology that Westar employed in the 80s versus what you think is being put in now, and you have confidence in both the vendor and the engineering firm that's designing this, that at least in your opinion, those issues would be addressed.
Yes.
Okay. That's what I was looking for. I appreciate it. That's all I have.
All right, thank you. Ms. Kafer, any redirect?
I did not have any redirect. Thank you.
All right. Well, Mr. Harrison, I believe we've come to the conclusion of your cross-examination. We appreciate very much your appearance before the commission today. You are excused and you may step down virtually.
Thank you, Mr. Chair.
All right. Ms. Kafer, if you would, please call your next witness.
Okay, and please, as a commission, I would like to have my co-counsel present this witness, my co-counsel, Mr. Trevor Wilford.
Very well. Welcome, Mr. Wilford.
Thank you, sir.
Just as an aside, I think it turns out that we're both quite a distance from the Kansas Board of Tax Appeals at this point.
That is true. Thank you.
Both alums of that panel.
I make it there every so often too, so.
Very good. Appreciate all the parties excusing that aside. Mr. Wilford, if you would, please call your next witness.
Yes, we call Steve J. Vetch.
Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Please state your full name and business address for the record.
Yeah, Steve J. Vetch, 818 South Kansas Avenue in Topeka, Kansas.
Are you the same Steve Vetch who submitted written direct and cross-answering testimony in this docket on May 17th and May 27th, respectively?
I am.
Are there any corrections you wish to make to that written testimony?
There are not.
Would your testimony today, if given live, be the same as your written testimony?
Yes, it would.
Mr. Chairman, I move for admission of Mr. Vetch's written direct and written cross-answering testimony.
Is there any objection? Without objection, they're admitted.
And now I'll pass the witness.
All right. Good morning, Mr. Vetch.
Good morning, Chair Keen.
Let's see if beginning here, if the commission has any questions for you or opt to defer. I'll begin first with Commissioner French.
No questions. Thank you.
Thank you. Commissioner Duffy.
No questions at this time. Thank you.
I have no questions either at this point. I'll turn next to Mr. Zakura.
I have no questions for this witness. Thank you.
All right. Mr. Kimmel.
No questions. Thanks.
Well, Mr. Wilford, I think you're off the hook on redirect. I don't believe we have any questions for you, Mr. Vetch. I appreciate very much your appearance here today. I appreciate very much as well your testimony that is spread across the record. I think it's quite beneficial to the commission, and we appreciate your having done that. Having said that, you're excused and you may step down virtually.
Very well. Thank you, sir.
Thank you, Chair Keen.
Let me go off the record for a moment.
Not at all.
Back on the record. Our next witness is Mr. Allen, who is with the Southwest Power Pool.
Chair Keen, may I be heard on this matter?
Say again.
May I be heard on this matter, please, for a moment?
Mr. Zakura, please.
I have worked with counsel for SPP, and we've agreed to go ahead by agreement and admit a number of exhibits to save time of the commission. May we do that either after the witness is sworn or before, whatever the commission prefers? It would save a lot.
Sure, I would prefer that we wait until after. I would prefer that we wait until after the witness is sworn.
Thank you very much. I'm hopeful that this will save a lot of time for the commission.
All right. What I'm kind of deliberating on, Mr. Allen, is whether or not we should take a lunch break at this point in advance of your testimony. Does the commissioners have any preference one way or another?
I'll chime in. I believe it's time for lunch.
Well, that's it. That did it. If Commissioner French, not to preclude your opinion.
Nope, my only opinion would be we should be short because I think we've got a lot to get through still.
I
Well,
would agree.
that we have a lot to go through is probably the understatement of today, maybe the year. It's 11:55. Mr. Allen, with your indulgence here, I think we will take a lunch break. We will keep it to, my inclination is to keep it to 20 minutes. Am I pushing the envelope too hard? I don't see too much reticence there. Denise, does that give you adequate time? Denise has.
Yes, that's fine with me. Thank you.
All right. It's 11:55. We will be in recess until 12:15, which time we'll return and commence the examination of Mr. Allen. We are in recess. Denise Hess, are you ready?
I am ready. Thank you.
Denise Grau, could you put us back on the full screen? Or Michelle? It's now 12:15. We're back on the record. And I'll turn to Ms. Starnes and ask if you would please call your witness.
Yes, Chairman Keene. We would call Kelsey Allen. And we may want to do a sound check for him.
Yes, Mr. Allen, would you speak into your mic, please?
Yes, can you hear me?
I can indeed, thank you. Denise, if you could swear the witness, please.
Yes, please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good afternoon, Mr. Allen. How are you?
I'm doing well. How are you, Ms. Starnes?
I'm doing well. Would you please state your name for the record, sir?
Kelsey Allen,
And by whom are you employed?
Southwest Power Pool.
And would you provide your work address, please, sir?
Yes, it's 201 Worthen Drive in Little Rock, Arkansas.
Did you file direct testimony in the proceeding that we are having a hearing on today?
I did.
And that was filed May 17th of 2022?
Yes, it was.
Do you have any changes to the testimony that was filed?
I do not have changes to my answers to the direct testimony. I do have one change regarding my title. Testimony was submitted as Kelsey Allen, lead engineer. I am now principal engineer.
Okay, Mr. Allen, does that change your duties in your work, your duties and responsibilities on behalf of SPP?
My responsibilities and duties have only expanded. I still have purview over the duties that I was doing before.
Okay, so the description of your duties in your testimony would not significantly change?
No.
Okay, if you were asked the same questions as you were asked in your testimony today, would your answers remain the same?
They would.
Chairman Keene, I would move the admission of Mr. Allen's testimony into evidence, please, sir.
Is there any objection? Without objection, it's admitted.
And Chairman Keene, I believe that Mr. Zakura and I have agreed on the admission of a number of KIC exhibits. Would you like for him to go through those, or would you like for me to go through those?
Whichever is your pleasure.
Okay, Mr. Zakura, you correct me if I'm wrong, but I've written the numbers down that we've discussed. They are KIC 7, 8, 9, 10, 11, 12, 13, 14, 15, 21, 25, 26, 33, 34, 35, 39, 40, 41, 42, 43, 46, 47, and we will introduce as 40, he will introduce as 48 our data request responses to KIC 1-05 and 1-06 when we provide those to him tomorrow.
All right. Is there any objection?
No objection. I would just confirm that that is accurate. And I want to express my thanks to Ms. Starnes and to Southwest Power Pool. Throughout this proceeding, they have treated me with the highest professionalism and courtesy. And hopefully I've done the same with you, and it's greatly appreciated. Thank you.
All right, thank you, Mr. Sakura. Without objection, all of the exhibits listed by Ms. Starnes are admitted. Ms. Starnes?
I will offer the witness, Chairman.
All right, thank you very much. Good afternoon, Mr. Allen.
Good afternoon, Chair King.
Thank you for your indulgence of our delaying your testimony for a few minutes. We appreciate that. Let's begin as we have with other witnesses. First with the commission, see if it's their pleasure to either ask questions of you now or defer. I'll begin with Commissioner Duffy.
Yes, good afternoon. I'll defer. Thank you.
Thank you. Commissioner French.
Yep, I'll wait until after cross. Thank you.
All right, very good. Mr. Allen, I do have a few questions for you. Let's start with some of the general questions, if I can. To what extent does the Southwest Power Pool seek input from the states that are affected by projects such as the Wolf Creek Blackberry line prior to the issuance of a notice to construct?
We have an extensive stakeholder process with representatives across our footprint in the 14 states. Those are open meetings that anyone can join. We have many different working groups with representation from utilities and companies across the region. We also have a regional state committee that is made up of representatives of the state commissions and work with a cost allocation working group that reports to the regional state committee and gain their input into the process as well.
Okay. If you could take a look at page 12 of your direct testimony. Tell me when you're there.
I believe I'm there.
All right. Correct me if I'm wrong, but as I review your testimony as it appears on page 12 and over onto page 13 and actually beyond, but specifically with reference to those, you set out here a pretty extensive stakeholder and vetting process. Is that a fair conclusion?
Yes.
Projects such as the one before us go through a lot of review through these various working groups. Am I correct on that?
Yes.
From the perspective of SPP, do you view basically the various organizational groups that are involved as set out on page 12 and the process as well that's explained on 12, 13, and within your entire testimony? Do you view these as stakeholders?
Yes.
To what extent do you view ratepayers as stakeholders?
I believe through our open meetings that ratepayers can join and participate in the process to the extent that our members represent ratepayers as well. I believe there's participation through that.
Let's take a look at, if we could, together at page 8 of your testimony.
Okay.
I'm looking specifically now at lines 8 through 13. And for the record, I'll read that and have you check my work on that. Beginning on line 8, this is from your direct testimony. It states, as the RTO, SPP is responsible for preparing long-range plans, providing a roadmap for future transmission reinforcements, that address a wide range of needs within its region. This requires that SPP's transmission planning process be regionally focused rather than locally focused. That excerpt is really from lines 8 through 11. Did I accurately portray your testimony in that regard?
You did.
I guess my question to you is, what is your definition of locally or locally focused? What is it, in other words, do you consider to be so local as to be excluded from consideration by the SPP process?
We have an extensive process that focuses on development of models and assumptions that we use to develop the regional plan. We have certain rules in place as guided by tariff and our ITP manual that afford us the ability to look at issues on a regional basis. We do get into specific issues to the extent that facilities are under the SPP tariff. Typically that's 69 kV and above. To the extent there are issues that are local in that regard and are isolated, we do address those. But as the RTO, we are looking for more holistic solutions that can address a multitude of needs if that is what it calls for.
All right. So in connection with a process such as the one that brings NextEra before the commission today, to what extent do you consider agricultural, commercial, petroleum production, or recreational land uses local, therefore beyond the purview of SPP's consideration?
Could you restate the question?
Ms. Hass, could you restate my question?
Yes. Question. All right, so in connection with the process such as the one that brings NextEra before the commission today, to what extent do you consider agricultural, commercial, petroleum production, or recreational land uses local, therefore beyond the purview of SPP's consideration?
I'm not sure I understand the question in the context of the duties of our.
Let me re-ask the question if I could, Mr. Allen. Let me try to re-ask the question. Through all the processes of review and vetting that these kinds of projects go through within SPP, at what point is any consideration given to the agricultural, commercial, petroleum production, recreational, or other land uses of the property through which these lines might be placed?
Okay. Yeah, SPP does not consider the route and during the construction of specific transmission. We're looking at what are the best electrical connections to the system in order to resolve the issues that we foresee. We do not consider, as a general practice, specific issues in terms of land use and the other items that you have mentioned.
So they are pretty much irrelevant for the vetting process within SPP. I don't mean to unfairly characterize that. If I have, you correct me.
I believe the context that I would give is that we work with our stakeholders and specifically transmission owners to determine feasibility of the projects that we propose. So to the extent that there are those issues that are more local in nature such that a transmission project cannot be constructed, we take that into consideration.
Have you had the opportunity to be present throughout the hearing since yesterday?
I have, yes.
All right. We've had testimony by various witnesses concerning a parallel 161 kV line parallel to the proposed route here that's currently in existence and being operated by averaging it's roughly 25 miles in length. Did the processes within SPP in considering the award of this particular bid take into consideration this parallel line and its implications?
Again, to the extent that there are feasibility concerns, we would take that into consideration. But in the case of, proposing new greenfield transmission, we don't typically consider the, existing right-of-way of transmission that gets into routing concerns. SPP does not do routing studies, do not do detailed analysis to that effect. I would say that we, from a cost perspective, we would expect that expect but not require that the designated transmission owner attempt in good faith to keep costs low. But there is a process for that when cost estimates get out of bandwidth to address those issues.
In those instances, are there cost caps or other assurances to prevent the kinds of costs that may potentially be incurred here from happening?
So cost caps are, I believe, only set for competitive projects. The majority of the transmission that we propose fall under the purview of the incumbent utilities. We do not require specific cost caps for those projects, but we do have a process and a stakeholder group that has purview over cost changes as a transmission project goes through the process, such that if the projected cost of those projects get out of bandwidth, they're required to go back through the stakeholder process for review.
And that's post notice to MTC also, right?
That's correct.
So prospectively, some of those costs could be rather substantial, could they not?
They could, yes. I believe our current bandwidth after an NTC is issued or based on the cost within the NTC is plus or minus 20%. And if costs exceed that, those projects then go back through our project cost working group, and the stakeholder that represent that group discuss and decide whether or not to rebaseline those costs and continue to move forward.
Okay. In this case, were you aware of this parallel line running roughly 25 miles adjacent to the proposed route of the Wolf Creek Blackberry line as the principal engineer? Were you aware of this?
Yes, I have knowledge of the transmission system. I may not know all the specifics of the lines in the area, but yes, I believe I'm aware of this.
I believe that's all of my questions for the time being. I may reserve time for additional ones as we proceed. I appreciate your indulgence of my questions indeed. Let's turn next to Mr. Zakura. Jim, you're muted.
Thank you, Chair Keen. Good afternoon, Mr. Allen.
Good afternoon, Mr. Zakura.
I please want to confirm with you a couple of points that were stated in the opening statement of council, but I want to confirm them with you as a witness. And the way I'm going to do that is I'm going to refer you to some testimony in this case by a curb witness.
Okay.
Denise, it may just be mine, but I'm seeing Jim on a frozen screen here.
Yes, I'm not hearing Mr. Zakura.
I don't know if you can hear us, Mr. Zakura, but you're on a frozen screen at the moment.
Jim, you may try turning your video off or just simply reconnecting.
Yes. You might consider that, Jim, if you would. Still looking, I don't see him on as yet.
He has not come back up in my list as trying to join again yet, so he's having more trouble than he realizes.
Mhm. While he's trying to reconnect, let me do this. I think it's just one of these Zoom situations. We'll try to take into account the however bizarre this may make things. But let me turn to you, Mr. Kimmel. Do you have any questions to ask of Mr. Allen?
Not at the moment, no.
Okay. So wait another moment here, see if we can reconnect with Mr. Zakura, or he with us. Michelle, could you try contacting him by phone to see if
I would, but I don't think I have a phone number for him.
Maybe Mr. Cohen or Mr. Fedotin.
I can do that if you want.
Please do.
Are we in recess, Chair Keen?
Let's do this. We will go in recess right now, absolutely, and we'll return shortly.
Commissioners, I raised Mr. Zakura on the phone. I'm going to give him the phone number to call in.
Michelle, for whatever reason, David, in what he just said was somewhat muffled, but as I understood it, he was going to try to call in. Can you manage
Yes,
that
and
arrangement
he
for us as
just connected for the call in.
well? Okay.
So he's
Well,
on by phone now.
I was giving him the phone number and then he said he had reconnected, so he didn't need it. So
He is connected again. Are you hearing us okay, Mr. Zakora?
Yes, I am. I'm hoping it wasn't the commission who disconnected me, rather. So,
Jim, we would never think of it. We would never think of it. We have gone off the record. We're going to go back on the record again, Denise. Now,
I'm ready. Thank you.
yes. Mr. Segura, if you would continue your cross-examination.
thank you. Oh, there's Mr. Allen. Thank you. I'm not sure exactly when I was offline, but let me start over again, Mr. Allen. In the opening statement of Ms. Starnes, she indicated generally the extent and the manner in which SPP operates, and particularly with regard to the BlackBerry line. And I would like to confirm with you as a witness in this case, just what was done and how we approach this, how you approach it at SPP. And the way I'm going to do that is to read to you some of the testimony, a few lines of testimony of the CURB witness, and see if you would confirm it, or if you don't confirm it, if you could say where it's not correct. I'm reading from that CURB testimony, and it says, CURB subsequently met with SPP to discuss whether the benefit cost analysis or rate impacts of the Wolf Creek BlackBerry project have been quantified specifically for Kansas customers, and if not, whether they could be. It is my understanding that SPP has not performed Kansas-specific benefit cost and rate impact analyses for the Wolf Creek BlackBerry project. SPP expressed concern over the practicality and accuracy of the results if it were attempted to do so. Would you confirm those statements as being accurate, or if they need to be amended in any fashion, would you do that also, sir?
They are accurate.
Thank you, sir. May I further read one passage that's in the CURB testimony? And again, I would ask you, sir, to either confirm it to be accurate or to tell me where it's inaccurate in any manner. This is the testimony. Because SPP's transmission planning process is regionally focused rather than locally focused, benefits and costs for the Wolf Creek BlackBerry project have been quantified by SPP at the regional level. Neither SPP nor NETE Southwest have quantified the Kansas-specific benefits of the Wolf Creek BlackBerry project for analysis in this docket. Would you confirm that as being correct?
That is correct.
Now, I would ask you, I'm going to ask your help, okay? Yesterday, what was introduced into the record by KIC, sir, was what is called KIC 42, and it is a statement of the market. And on the second page, which is page 32 and 34.
Jim, will you give us just a chance to get to that?
Certainly. Thank you, Heather. Thank you, Ms. Starnes. Excuse me.
Mr. Allen, please tell me when you're ready.
We are getting it pulled up on the screen here. Okay, we are ready.
What I am pleased, sir, asking for your assistance on is on the figure 4.6 and 4.7, the load serving entities are identified by initials. Would you be able to assist in filling out the record, sir, by telling me which of those initials are Kansas load serving entities? And could you spell out that, compare the initials and then spell out the entire name if you would?
I am somewhat familiar with these initials. They look to be initials of market participants, and this document was prepared by our market monitoring unit that I do not typically interact with. I wouldn't want to speculate on all of these, specifically the initials after the slashes. I don't recognize a lot of them.
Can you identify the Kansas load share, the load serving entities?
I will say the group at the end, I believe it says WRGS. I believe that's Westar Generating Services. Again, I think that's a market participant, and we typically don't consider market participants in our planning process.
Can you identify Sunflower Electric Power Corporation?
Yes, I believe that is SEPC and about the, yeah.
And can you identify Midwest Energy?
Yes, MIDW.
Can you identify, sir, KMEA, Kansas Municipal Energy Agency?
Yes.
Can you identify KEPCO?
I believe that is KEPC, Kansas Electric Power Cooperative.
Okay. Now, let me step back a minute. You say the load serving entities, and you group everybody, as I heard your testimony, that are WRGS, is that correct?
Yeah, I believe that stands for Westar Westar Generating Services, Western Resource Generating Service. I'm not sure. I believe the WRGS is a market participant, and I do not recognize any of the acronyms on the other side of the slash.
So let me.
Jim, this is Heather. If you might allow me to clarify so it helps you to understand, these are not necessarily the same abbreviations for transmission owners and related to transmission owners and their pricing zones. These are related to market participants, and sometimes the market participant is not the transmission owner. It may be a marketer or someone else. That's why the abbreviations may be confusing.
Okay. Let me approach it. Thank you, Ms. Starnes. Mr. Allen, let me approach it a little bit differently if I could, please. This, on 4.6, the price by load serving entity summer, it says average prices for the summer period were the highest in entities around Southwest Missouri, okay, and portions of Oklahoma, and the lowest in Western Kansas and Nebraska. Do you see that?
Yes.
And can you identify the entities in Western Kansas that are the lowest? I look at the pricing zone, which I believe is KIC 30, and it looks to be Sunflower and Midwest Energy.
Yes, those are two of the utilities in Western Kansas.
Now, if I could, Mr. Allen, I would direct you to KIC 35.
Okay.
Do you have that before you, sir?
Yes.
And KIC 35 was produced by SPP. And what does this represent? Is it a pricing zone, or describe for me what this map represents, particularly emphasizing Kansas?
Yes, I believe these are the transmission pricing zones. If this map is not intended to directly reflect that, I believe that to be true. And would it be accurate to say, sir, that
when you talk, excuse me, when SPP speaks of the lowest prices in Western Kansas and Nebraska in KIC 42, SPP would be referring to Sunflower Electric Power Corporation and Midwest Energy.
Yes.
Now, if I could, please, Mr. Allen, let me direct you to KIC 34, sir.
Okay.
Do you have that before you, sir?
Yes.
Now, the question that KIC propounded to Southwest Power Pool was this. Exhibit BW-3 states in part at page 111 of 185, this will help to levelize systems LMPS, low generator LMPS in the west and high load in the east. Do you see that, sir?
Jim,
Where-
I'm confused.
what
Which
page are you on,
exhibit are you
Jim?
referring to?
You know what? I did not, excuse me, Heather, good correction. Sir, it's the response to KIC 1-09 to Southwest Power Pool.
Which exhibit is this?
This is exhibit KIC 34.
Thank you, Jim. That has multiple responses, so I just wanted to make sure the right response.
Yeah, you're entirely appropriate, Ms. Starnes. It's the response to 1009. Okay. Please excuse me, Commission and Ms. Starnes, for my incomplete description. Do you now, sir, have that before you?
Yes.
Okay. And the response to A is that, as I read it, sir, and I believe you verified this response on this next page. SPP did not analyze LMPs at the state level as part of the 2019 ITP assessment. Is that correct?
That's correct.
So let me back up a minute if I could. I'm trying to not take you all over different places, but let me start at the beginning. That was very helpful. Thank you, sir. Would you please turn to page 19 of your testimony? And I believe, Ms. Starnes, there's only one set of testimony, correct? That's right.
Yes, sir, that is correct. And what page did you refer to?
I'm referring, please, to page 19. Do you have that before you, Mr. Allen?
Yes.
And I'm particularly interested in the statement, SPP was able to address the stakeholders' direction to provide a path forward for the area to properly evaluate and resolve the issues present in day-to-day operations and in the planning horizon. Do you see that statement, sir?
Yes.
May I please ask you to identify for the record, what stakeholder direction and did you receive and who is the stakeholder, please?
I believe this sentence is specifically referring to reliability issues that we identified in the 2018 ITP near term. We had a discussion with the transmission working group about addressing the specific issue that we saw in that study, and conversations also expanded to discussion on the declining transient stability margins at the Wolf Creek plant. And the transmission working group asked SPP to evaluate the specific reliability issue. It was a thermal violation in the 2018 ITP near term. Also consider the transient stability issues at Wolf Creek, as we also looked at congestion in the southeast Kansas area in the 2019 ITP.
Let me ask you some questions about that, some further questions about your answer. And as you would note, I included 3 glossaries in our exhibit because there are engineering terms and acronyms used. You use the term transient stability. Is that correct?
Yes.
And transient stability, as I understand it from my limited research, and certainly I'm not an engineer, but some of that, and perhaps in this case, is caused by the addition of non-dispatchable renewable resources such as wind energy on the system, which cannot be as closely controlled as fossil fuel generation. Would you agree that that's part of the issue involved when you're talking about transient stability?
I have to say that I am by no means an expert in transient stability. I have not performed any studies in that realm. My understanding through conversations is that, yes, as you get more inverter-based resources interconnected to the system that displace machines with rotating mass, that yes, that can cause system support concerns in the transient and voltage realms. But I am by no means an expert in transient stability.
I will say you're far more of an expert than I am, sir, but we'll continue on here. This gets me basically back to the situation where it seems like much of what SPP is doing in the 2019 IDP projects, as well as to some extent the Blackberry, the Wolf Creek to Blackberry project, is related to the addition of wind energy to the SPP system in very material amounts. Would that be a correct statement?
Yes.
And with all of the benefits of wind energy also come challenges. Would that also be correct?
That's correct.
Mr. Allen, may I please direct your attention to KIC 22? And if I could identify that for the record, that is an order rejecting a tariff, and it's issued on June 11, 2021. And would you agree with me that this was an application of Southwest Power Pool?
I am unfamiliar with this document. I would have to read through to confirm that.
Chairman Keene. Chairman Keene.
Yes.
This is
Yes.
Ms. Scott.
Yes.
I don't object to the document, but I do object to whether it's relevant with respect to Mr. Allen's specific testimony. I don't expect that he's going to have any specific knowledge about this document.
I'll overrule to the extent that he may answer within the purview of his knowledge.
Thank you. Ms. Starnes, I'll get to what I think is the relevance, and your objection can certainly continue.
Thank you.
Can I address your attention, sir, to paragraph 7, which is on page 3?
Okay.
And would you take a moment to read that? And I have a couple of questions to ask you. Now, again, these questions are related to the issue of congestion that you speak about in your testimony. I'm trying to limit it to that. But this would you agree that this is an example of both the blessings and the challenges of wind, particularly as it relates to Sunflower Electric Power Corporation?
Yes, I would agree that this is one of the challenges, but the SPP transmission system is open access, and to the extent that a generator wants to connect to the system and they go through all the proper processes, they can.
And specific, thank you, sir. And specifically, this particular paragraph notes that in 2011, Sunflower had 550 megawatts of wind capacity with 900 megawatts of demand. And by 2020, there were 3,100 megawatts of wind capacity and still 900 of demand. Do you see that?
Yes.
And would you agree with me that that could be characterized as congestion?
No.
Why is it not congestion, sir?
Congestion is related to the characteristics of the transmission system. The difference between amount of generation and amount of load does not have anything to do with congestion.
Well, would you agree with me that part of what the 44 projects of ITP 2019 is designed to address is the issue of congestion and being able to move volumes more, I think in your terms, efficiently from the west part of the region to the east part of the region?
That is correct. There are transmission limitations between the west and the east that cause congestion.
And when I read the testimony in this case, they talk about, as I understand it, the testimony speaks about difficulties with regard to congestion from time to time that exist around the Wolf Creek Nuclear Generation Station. Would that be a correct understanding that the congestion issues occur there?
That is one point on the system, one area of the system that we did observe congestion, yes.
And let's back up and look at this kind of, as you do in your planning, from a holistic standpoint, okay? Now, would you agree with me, if you have knowledge, that in 2020, Kansas produced 26% more electric energy than was consumed by Kansans? That Kansas produces in excess?
I cannot confirm that number. I can say that the western portion of SPP has a very rich potential for renewable energy.
And again, speaking to that and reflecting back on your discussion of the open access tariff, if parties make a request to SPP to attach wind energy or solar in the western half of Kansas, what is the process that you take at KCC prior to attachment of those resources?
I am unfamiliar with the specifics of the generator interconnection process.
Would you agree, based on your prior testimony, that so long as the tariff provisions are met, that SPP would attach additional wind resources to its system in the western half of Kansas?
As long as all of the requirements are met to do so, yes.
And your testimony was that Kansas is I don't want to paraphrase. I think you said wind rich, or in some fashion you made it a descriptive term. Would you state that again so I won't misstate it?
Could you refer me to the page that you're looking at?
May I ask the court reporter, I don't want to misquote the witness. I think you said wind rich or wind rich potential or something of that nature. May I please ask the court reporter to read that back?
Do you want me to just look back through his responses or?
Yes, it would be in the last minute.
Okay.
Thank you, Ms. House.
Okay, that I believe the answer you're referring to is, I cannot confirm that number. I can say that the western portion of SPP has very rich potential for renewable energy.
Thank you, Ms. Haas. Mr. Allen, may I please ask you to expound on your answer, rich potential for renewable energy? What do you mean by that,
Yes.
sir?
Yes, we have done analysis as part of development of our future scenarios, where we have pulled data from the National Renewable Energy Labs, and they provide information to the technical potential of renewable energy development in different areas of the country.
And what do those studies generally indicate, sir, as to the rich potential in, and if you can be specifically for the state of Kansas?
I do not have numbers off the top of my head, but they report on, I believe it's the potential installation capacity from a technical standpoint that is locational and weather related, geographical and weather related. It is not related to the characteristics of the transmission system. That's why they call it potential, technical potential.
Does that, well, let me direct you back to KIC 42. Are you there, sir?
Yes.
And let me address you, please ask you to look at the bottom of the page. Excuse me, it's page 33, which is the second page of the exhibit.
Okay.
It says Western Kansas has abundant low-cost generation, primarily wind. Do you see that?
Yes.
Okay. And is it your testimony that based on the studies that you have, that SPP has done, that abundant low-cost generation, primarily wind, could be expanded based on potential additional wind additions in the state of Kansas in the western half of the state?
I'm not sure I follow the question. Can you restate?
Let me please restate it as best I can. Would I be correct in my understanding that SPP sees the potential for additional material additions to wind energy in western Kansas?
Yes. through our analysis of, again, the data from the National Renewable Energy Labs, as well as our review of projects submitted by customers entering into the generation interconnection process, that certainly leads us to believe so.
Are you able, sir, to quantify what that potential is? Would it be 2 times what it currently is, or 3 times, or are you able to quantify that in any manner? That's my first question. And the second question is the study that you are referring to that SPP has conducted, is that available to the public?
We did not perform a study. We were referencing, I believe, our review of development of our futures, some analysis performed by the National Renewable Energy Labs, NREL.
Elsie, just a moment, please. Chairman Keene, I'm going to object to Mr. Allen responding to the first part of the question, as I believe it calls for speculation.
Mr. Zakura, could you rephrase the question?
I'll do my best, Chair Keene. Would it be your opinion, based on your analysis of, based on the SPP analysis of the wind study that you referenced, that there is potential for material increases in the amount of wind energy in Western Kansas?
I can't speculate on that. Again, the NREL data that we looked at was for technical potential. There are certainly limitations in terms of access to transmission and impacts to the transmission system. Typically, what we kind of keep track on for analysis and what we include in our futures assumptions is activity in the generator interconnection queue, which shows us the desires of the customers looking to interconnect.
I do not believe you're a specialist in the area of the interconnect queue, but would you be able to state how much wind additions are in the SPP interconnect queue for Kansas?
I would have to point you to our website, which I believe has now has a nice new dashboard that shows all of the requested interconnections to the SPP system.
Mr. Zakura, this is Heather. I believe
yes,
when we provide you tomorrow the responses to KIC information request 1-05 and 1-06, that is going to provide you to a link. That's going to provide you a link to a new generator interconnection dashboard that SPP has set up, which I think will answer some of your questions.
thank you. I guess may I stop for a moment and ask for some direction from the commission? I would like to include as an exhibit the response to the data request that will be provided tomorrow by SPP and Ms. Starnes. Does the commission have a particular procedure they would wish me to follow to include that in the record?
Mr. Cohen?
Yeah. I think you could authorize Mr. Zakura to file something in the docket, a late filing, and I guess if you authorize it now, you wouldn't have to seek permission.
All right.
I'm open to being told I'm wrong on that by anyone else.
Chairman, we have no objection to that at all.
All right. Right. You want to move the introduction of that? You want to make your proposal, Jim, for me to rule on something here?
Okay, may I please? I would request the commission authorization to file when received, most likely tomorrow, the response of SPP to KIC 1-05 and KIC 1-06, which as represented by SPP would be a link to the interconnection queue, which would enable anyone going to that link to find out the volume, well, if not the volume, the request for interconnection into SPP in the state of Kansas. Ms. Starnes, did I relate that correctly?
I think that is correct. I would call it a generation interconnection dashboard. It may include some of the information you're requesting. It will include what is public information. How's that?
Okay. And may I ask the further question, Ms. Starnes? Then the parties would, I'm trying to get the record correct here. The parties will then have to take another action, and that is access the dashboard and to go to whatever sites that are included therein. So what would be offered, Chair Keen, would be the link to the dashboard, which would then access further information to parties.
Is there any objection? Please go ahead and continue.
Okay.
Are you finished, Mr. Zakura?
No, I have a bit more if I can, but I.
No, I mean with respect to this request.
Yes, I am. Thank you.
Okay. Is there any objection to this procedure or the admission of this information? Hearing none, it will be admitted.
Mr. Allen, I would please direct your attention, sir, to two exhibits, sir. The first one would be KIC exhibit number 8. Do you have that before you, sir?
Pulling it up now. Okay.
And for the purposes of the record, Chair Keen, this is KIC exhibit 8, and the first page is entitled Who We Are. And I could direct your attention, Mr. Allen, to the third page of this exhibit. Do you have that before you, sir? And on the right, it says that the country's highest wind speeds are in the SPP balancing authority. Do you see that, sir?
Yes.
Is this the kind of studies that you were talking about that SPP reviews?
Yes, this is very related to our review of the technical potential numbers that NREL reported.
And within the area that's identified, Kansas is right smack in the middle of the area of wind, correct?
Yes.
Now, if I might, sir, turn your attention to the next page, which is labeled 124. And it says at the top on the left, wind energy share of electricity generation. Do you see that page, sir?
I do.
And do you see that Kansas is listed as 41.4%?
I do.
And I think as recalling your testimony, one of the criteria that you use or think about when you're doing your planning are statutes that have, for instance, renewable requirements. Is that correct?
That's correct.
And do you recall what Kansas renewable requirement was prior to its, I guess it was revoked? Do you recall what our requirement was in Kansas?
Not off the top of my head.
Well, I don't mean to put words in your mouth, but I believe it was 20%. So this would indicate that Kansas is doing pretty well. It doesn't indicate that it might not do better, but it's doing pretty well at 41.6, correct?
Yes, I, yeah.
Now, let me direct your attention to what is page 127, and it's a few pages back, sir, of this exhibit. And it's installed wind capacity by year. Do you see that, sir?
1 second, please.
Kelsey, it's page 7 of the PDF that is that exhibit.
At the top, it's titled Installed Wind Capacity by Year.
Yes.
And it carries an SPP page number of 127. And I think Ms. Starnes identified it as the 7th page. Do you have that, sir?
Yes, we are there.
When I look at this installed wind capacity by year, this is for SPP, correct?
That's correct.
This is one remarkable graph, I would say. It goes from basically 0 to about 27,000 installed megawatt of wind capacity in 20 years, correct?
Yes.
And the sharp increase in the slope begins at about 2014 and goes to 2020, correct?
That's correct.
Now, if I were to ask you, sir, based on your position at SPP, what would your projection be of the installed wind capacity in years beyond 2020?
Chairman Keene, I'm going to object because I believe that calls for speculation.
I don't mean for it to be speculation. I mean for it to be, if you have done an analysis and estimated what it would be, could you provide that to the record?
Well, I can point you to Exhibit 1, I believe, the 2019 ITP report that shows our projections for that study.
And
let me get
would you mind?
myself.
Oh, excuse me, sir.
Yes. So one of our futures, we projected an installed wind capacity of 24.6 gigawatts by 2029. And in the second future, we projected an installed wind capacity of 30 gigawatts by 2029.
Could you?
We were having trouble keeping up.
Could you help me with the conversion? This is in megawatts on the left side, and I believe you were using a different nomenclature. Can you relate it to megawatts at all so that we could keep the consistency with the graph?
Yes, that would be 24,600 megawatts or 30,000 megawatts.
Now, let me turn, if you would turn a couple of pages more to it's labeled SPP 129. And it's titled at the top, Why Fuel Diversity Matters, SPP's Record Wind Swing. Do you see that?
Yes.
And that, as I see that, the wind swing is from about 18,000 megawatts to about, what is it, under 4,000 megawatts. I guess it's, 1,744 megawatts. And for what period of time is that swing?
It looks to be over the course of just short of a day.
Okay. So from 17,861 to 1,744 in the course of a day, correct?
That's correct.
And is that particular swing the reason in your testimony and the other SPP documents There's a lot of discussion about diversity of generation.
That is one contributing factor. Sure.
Let me ask the question a little bit differently. When the available wind resource goes from that level within a day, in order to provide service to the region, SPP has to dispatch other types of generation. Would that be correct?
That's correct.
And those would be coal or natural gas or nuclear, or at least other forms, which would be primarily coal and natural gas, correct?
Typically fossil generation, yes.
Okay. Now, would it be correct to say that the region relies not only on this abundant wind resource, but also its existing fossil fuels generation in order to provide continuous, reliable service?
Yes.
And is there a plan at SPP to deal with these two items? A, the addition of additional wind energy, and B, the retirement of coal or natural gas plants.
That is part of what we do via the ITP process, and our specific charge with that is to develop the transmission necessary to support those changes.
Let me give you a hypothetical. If this commission were to decide, or if our state legislature were to decide that we wanted to move away from fossil fuels and retire those plants earlier, would that have an impact on SPP planning?
Yes, changing projection of retirement dates would certainly have an impact on planning, and that's something we go through and discuss and make adjustments to every time we perform an ITP.
And that would be, I think, in one of the categories you discuss as your planning as social or societal impacts on the transmission system. Would that be correct?
I don't know that retirement of generation is social or societal impact.
Let me redefine the question a bit then. If our legislature or if the commission decided that it was not good for the climate to have as many fossil fuel plants as we have, and made a decision to retire them, not on the basis of obsolescence, but on the basis of carbon emission, would you consider that to be societal?
I would consider that public policy direction that we do consider in our transmission planning processes.
Okay, your characterization was better than mine. It is a public policy determination made by either a public service commission or the state legislature, as the case may be, correct?
Yes.
And since you have 14 states, that particular decision might be different in each one of those states. Would that be correct?
That's correct.
And so the planning process at SPP must deal with at least 14 different sets of public policy on the issue of how we go forward as a state and country with either renewable or fossil fuel generation. Would you agree with that?
There's the potential for that, yes.
Just a few more questions, please, Mr. Allen. I would please direct your attention to KIC 9, sir.
One second.
And this is, the first page is titled SPP 101, an introduction to Southwest Power Pool. And may I ask you, sir, to turn your attention to the third page, which is actually labeled 1 in the right-hand corner.
Yes.
Okay. And may I address your attention, sir, to the last paragraph on that page?
Okay.
And the third line from the bottom, sir, we've had some discussion on this before in this hearing, but it says the portfolio contains economic projects that help improve the locational marginal price levelization. Do you see that?
Yes.
And the first question I have, sir, is define for me what you mean when you or when the SPP says locational marginal price per an LMP levelization.
So levelization of locational marginal prices means reducing the price separation between different points on the system that is caused by congestion.
And I think that in your earlier testimony, in the answer to the data request, your answer was that SPP did not study any specific Kansas rate impacts or price impacts.
Not
and I
for
can go
the
back.
state of Kansas. Our
Excuse me, sir. I didn't mean to interrupt you, sir.
No, our structure for our modeling follows the pricing zones. We try to look at when we're performing economic analysis, the benefits equivalently to how costs are allocated. So that's typically at more of a utility level than a state level.
Now, let me ask you just a couple of more questions about this, and I'll refer you back to KIC 42.
Okay.
Now, when you talk about levelizing marginal price, looking at figure 4.6, what does levelizing marginal price do in the future to the array of prices displayed on 4-6? If you know.
Price levelization in terms of LMPs, that means that the dots and diamonds on the screen would get closer together.
That means the lower ones would move more to the top, or more to the center, I guess would be a better way of saying it.
That is likely the case. Yeah, a fully levelized system would have one locational marginal price.
Chair Keen, thank you. I believe I've concluded. Thank you very much.
All right, thank you. Thank you, Mr. Segura. Mr. Kimmel, any questions of this witness?
No, Commissioner.
Thank you. Let's turn back to the commission, see if we have any further questions there. I'll turn first to Commissioner Duffy.
Thank you. If you could give me a moment. Okay, no, I'm good. Thank you.
All right, thank you. Commissioner French.
Thank you. Just a couple questions, I think 3. Good afternoon, Mr. Allen. Good to see you again. So I guess the first question I have is maybe more of a clarification, because I am the Kansas representative to the Southwest Power Pool and attend a lot of the meetings you reference. And this is going to sound a little, may sound a little gruff, but I want to confirm sort of what the RSC's role or the state regulator's role is, and what our role is not in your process. So I'm going to start off with a statement, which is I agree. We're given a lot of opportunity to participate, receive education, and we do have certain areas of authority that under SPP's tariff. But specific to the ITP, would you say it's accurate that the regulators are educated, but the regulators do not approve, the state regulators do not approve the ITP? Is that correct?
That's correct.
What groups does the ITP and these specific projects, what groups do they go through to receive an approval?
For approvals, we start at the technical working groups. So typically these ITPs will be reviewed and approved by the transmission working group and the economic studies working group. It then goes on to our market operations and policy committee, and then up to our board of directors for final approval.
So just to be clear, the state regulators, state staff have likely been kept in the loop, have been educated, have been given an opportunity to comment on these projects, but have not signed off in any way. Is that fair to characterize it that way?
That's correct.
Okay, I appreciate that. The next question I'd have, I thought there seemed to be a lot of mixing of terms of your planning process, the ITP planning process, and the justification for any specific project. And I wanted to clarify how the specific Wolf Creek to Blackberry project is justified within the ITP. A first foundational question, my understanding is that the ITP identifies projects on the basis of either an economic project, a reliability project, or a project to meet public policy goals. Is that correct, accurate characterization of the three types of projects?
That is correct. I will also mention we have consideration of operational issues that drive operational needs, but I believe at the end of the day, those are also categorized into either reliability or economic.
Okay. This Wolf Creek to Blackberry line, this is not justified on the basis of meeting any state's public policy needs, correct?
Correct.
And I understand you've laid out a lot of reliability issues that this project solves, but this was not identified or justified on the basis of being a reliability project, correct?
Correct.
So that leaves us with economic. This was identified and justified to be built on the basis of economic benefits. Is that correct?
That's correct.
Okay. I think that's all the questions I had there. I just wanted, because we had discussed public policy, we discussed sort of the fact that other resources might be driving some reliability concerns. I thought it was important to clarify what was and was not the justification for the project. The last item I want to talk about, could you, well, maybe it may not be necessary for you to refer to it, but I want to ask you a question about Dr. Jeff Macholm's testimony, direct testimony, and he has a recommendation at the end of his testimony, and that recommendation reads, request SPP to examine and report to the KCC on the feasibility of curtailing wind generation that impinges on reliable operation of the transmission system in Kansas and causes Kansas rates to rise. I will admit I'm not sure quite what he means with that last sentence of causes Kansas rates to rise. But I do want to ask you about the feasibility of curtailing wind generation that impinges on reliable operation of the transmission system. My understanding is that SPP currently curtails wind generation when it cannot be reliably dispatched or delivered. Is that correct?
That's correct. That's a function of our market operation.
And I think there has been some discussion that, or I guess, let me put it this way. When we talk about building economic lines, sometimes those are economic because they would allow us to not curtail lower cost generation as much, or they might allow us to connect more lower cost generation. Is that correct?
That's correct. And I will mention when we're justifying economic projects, it's on the basis of adjusted production cost savings. So that's directly related to cheaper versus more expensive generation.
And I guess one final question along those lines, do we build every project, or would we build every project necessary to reach zero congestion or to reach zero curtailments?
Absolutely not. Some congestion is good congestion, and we weigh that against the cost of each project and make sure that the projected benefits are greater than equal to or greater than the cost of the project.
So if there were wind generators that connected into the system and additional transmission was needed to deliver their energy to load, but the cost of building that transmission didn't outweigh the benefits of that low cost generation, those projects would likely not be identified and recommended for approval in an ITP. Is that an accurate statement?
That's correct.
Okay. I think that's all I have. Thank you.
Commissioner Debbie?
Thank you.
Yes, to follow up on Dr. Malcolm's Malcolm's suggestion and deny the CCN, would the profound changes that he thinks will happen in terms of better and more coordinated planning actually happen, in your opinion?
I have not read Dr. Malcolm's filed testimony.
Okay.
Could you elaborate or point me to it?
Well, it was just referred to by Commissioner French, and I don't have it at hand. I just recall it, but that's all right. Just wanted your opinion on that.
If you could be slightly more specific in what you're asking, I could try to answer.
Well, it goes back to what Commissioner French was referencing in the discussion, that he believes the continued proliferation of wind is not advantageous to the system. So he doesn't believe in doing that.
I would say that to the extent that new lower cost generation can reliably interconnect, then it will lower energy prices for the SPP region as a whole.
Okay. Well, what happens if we just reject the CCN?
If this Wolf Creek to Blackberry project is not built, I think we would see reliability issues in the area around Wolf Creek that we would have to address. Transient stability is not technically a part of the ITP assessment, although we were directed by the transmission working group to consider it during this study. So I would assume that Evergy would have to relook at those concerns and potentially do something there. And then we would start to see congestion in this area again, such that we would probably relook at this area in terms of congestion and potentially propose a project again.
Okay. While I have you here, I do want to ask this. This was a 2019 study. Storm Uri, would that change your thought process on any of this? That is being proposed right now in the plan. Does Storm Uri change? And as it relates to what we're discussing today, does Storm Uri factor in at all on this discussion?
Could you clarify Storm Uri?
Well, that almost brought SPP to its knees, but it didn't. So if congestion is a problem, and this would alleviate that, will there be other benefits beside? I mean, Storm Uri had a, it's not just summer peak. We know now we've got winter issues. So as it relates to Storm Uri and what this project is will this be a benefit to alleviate some of the problems that SPP experienced during Storm Uri in terms of moving the load around, I guess, and keeping the lights on for the region?
Yeah, I apologize, Commissioner Duffy. I apparently just don't remember my storm names.
Oh, I'm sorry.
You're referring to the winter weather event.
Winter
not
weather
too long ago.
event. Right.
Yes.
I wish I had your ability to block that out.
No, I am definitely acutely aware of the event and the issues that SVP experienced. Yes, just didn't remember the name. But yeah, to the extent that we can increase capacity, transmission capacity on the system that allows for more efficient delivery of energy across the system, that certainly allows us more access to generation that is farther away to still be able to reliably serve load.
Okay, and I guess one final one. It was on page 152 of the Southwest Power Pool report. It does talk about the Butler, Altoona, the Neosho, Riverton lines. So as proposed projects, right? It's
proposed issues that this will address. Yes.
Issues, yes. So will the addition of this line help alleviate some of those issues? Is there a connection?
Yes, so in our 2019 ITP assessment, we saw congestion on the Butler to Altoona line, as well as the Neosho to Riverton line. The Wolf Creek to Blackberry project effectively parallels one of the 345 kV contingencies that is causing congestion, specifically on Butler to Altoona. And one of the reasons we chose to connect the line out of Wolf Creek into Blackberry was because that moving it to the east into Blackberry mitigates a contingency that was causing congestion on the Neosho to Riverton line. So we're effectively protecting against two, and related to those two facilities, we're protecting against two major 345 kV outages that cause congestion in the area.
Very good. And also you've identified, I think the word is aging, they're aging lines. So not only the congestion, but the age of the line. And does that factor in as well? Of those older?
Yes, I would say directly from the 2019 ITP, to directly address the age and condition of the line. We looked at redirecting some flow, residual congestion that was not addressed by the Wolf Creek to Blackberry line with a phase shifting transformer. I don't want to get too out of bounds of my testimony here, but in subsequent ITPs, we have continued to look at that area and try to look at ways to more directly address the aging condition. And I believe Evergy also has plans to do that.
Okay. Thank you. Thank you, Chair Keen.
Absolutely. Mr. Allen, I do have some follow-on questions for you. Many of these, frankly, are prompted by the questions that were asked by my fellow commissioners. So we'll go through these fairly quickly. There aren't many. One's an overview question that kind of dovetails with the first question I asked you, but I'm going to go back and ask it again in a different way. Beyond the Regional State Committee and its role, and I want to add parenthetically here that we're grateful for the efforts that Commissioner French is engaged in with respect to his liaison activities with the SPP and his role on the Regional State Committee. I want that's a given with us. But let me ask this question. Beyond the Regional State Committee and its role, what role did Kansas ratepayers, regulators, or utilities play in developing and vetting the necessity for the proposed Wolf Creek to Blackberry transmission line prior to the SPP notice to construct?
I can't specifically talk about the ratepayers. Again, those meetings are open and anyone can participate, but we definitely had lots of participation from Kansas utilities. We have representatives from those companies on our technical working groups. The Market Operations and Policy Committee is a full representation committee. So Kansas utilities would have participated in the approval at both of those stages of the process.
So if I understand your response, then basically in terms of ratepayers, ratepayers are in a situation similar to all of us as citizens in this republic, in the sense that we're represented. We have a representative government. By analogy here, the interests of ratepayers are represented indirectly through various proxies who have a Kansas connection. Is that a fair statement?
That's fair.
Again, by way of overview, Mr. Allen, within the SPP footprint, how many nuclear generating facilities are there?
That is a good question. I think we're down to one.
Would that be Wolf Creek?
That would be.
I thought there was one in Nebraska. Am I wrong? But you're the SPP guy, not me. Is there not one in Nebraska?
Yes. Cooper Nuclear. I'm trying to remember. I believe it is now retired.
Okay. This is a 14-state Southwest power pool. Isn't that correct?
That's correct.
And am I correct again that of the 14 states, there are only 2 states, to my knowledge, that's Kansas and Oklahoma, that rely exclusively upon the Southwest power pool as its grid operator. Is that correct?
I believe Nebraska is in that boat as well.
I'm sorry, say again.
I believe Nebraska as well.
Okay, I'll leave that open. Let's move on. I appreciate your response. I'm just trying to put things in perspective.
Sure.
If we look at page 7 of your direct testimony, you describe in some detail there the SPP transmission planning process. That's where it begins. So my question to you is this. To what extent does this transmission planning process involve consideration of transmission needs for the full range of potential baseload fuel sources beyond wind, beyond solar, and to include natural gas or nuclear?
Yes, within each study, we rely on our members and stakeholders to help us develop what we believe the future state of the system will look like. So that includes all fuel sources.
Okay. So a related question to me is what, if any, within SPP, is there a concern for maintaining a balance or a mix or a variety of baseload fuel sources?
I think there are certainly concerns about fuel diversity. That's typically more at the transmission or utility company level. SPP takes those assumptions and incorporates them in our planning process. But yeah, due just the nature of operation of different generating plants and the impact on the transmission system, at least it is my personal opinion that fuel diversity is certainly a good thing. You need different types of machines to be able to keep the system reliable. And obviously the intermittency of renewable generation, you certainly need a generation that is able to be able to react quickly to changes in weather patterns.
Appreciate the answer. I appreciate that answer. I share the concern. I think anyone who went through the adversity we experienced in the winter weather event would agree that we'd better not see that happen again. And perhaps it's through the diversity and balance of these fuel sources that can be averted. We can certainly hope that may be a major factor in seeing that happens. I think you've answered the next question. I want to ask this just for the record. Is the SPP transmission planning process biased in favor of promoting renewable sources over dispatchable sources? And again, I'm thinking especially of natural gas and nuclear.
No, it's not. Again, we go through an extensive stakeholder process to simply develop models that we think represent the future state of the system.
Okay. And so I'm going to ask you a really more directed question here. So you're saying within the purview of this planning process, something more than just passing recognition is given to the prospects or potential of nuclear as an alternative. Is it seriously considered?
I will say it is not seriously considered, at least in the discussions that I've been involved in. I think there's concern certainly at the utility level about the kind of the policy hurdles that would be required to build new nuclear plants. So it is not off the table, but it is not seriously considered given the environment.
I appreciate the candor of your response. I'm not necessarily pleased with it, but I appreciate the candor of your response.
I will say that I believe in our current ongoing 20-year assessment, there is new, I think, small nuclear technology that is actually being considered, but that is new to me, and I need to do my own research on that to see where that might go.
Fair enough. Well, I'm concerned that I'm concerned that that we're not taking closer looks at it within the purview of our RTO, to be quite frank with you. I know that there are many states, east and west of us, that are proactive in exploring nuclear in its current form, which is much advanced over what the public perceptions might be. I'll let it go at that because I've told you just about everything I know about nuclear energy. But I'm concerned about the fact that we wouldn't be open enough to maybe consider other alternatives.
Chair King, could I ask one follow-on to that question?
Yes, please.
I just want to clarify with Mr. Allen what SPP's role is in generation planning and resource adequacy. And just to be clear, Mr. Allen, I understand SPP provides its input on the viability of different generation options, but it's my understanding that SPP is largely a clearinghouse just trying to understand what generation decisions the utilities within its footprint are making, or potentially what direction the states are giving those utilities, that SPP is not necessarily giving directives as to what generation should be hooked up. Is that, I just want to make sure I understand that correctly.
Yeah, I appreciate the opportunity to clarify. I don't want to say that SPP does not seriously consider nuclear. I mean that in the sense that in the appetite of our stakeholders who are performing their own integrated resource plans and working with the states and state policies that kind of guide them in their expectations of generation plans in the future. So to that extent, I have not seen the appetite for nuclear be seriously considered in the planning process.
I only raised that because I share some of Commissioner Keen's thoughts on exploring maybe a wider range of new technologies. And would it be your thought that that needs to be considered at the state level and brought to SPP or to our utilities, that then they can bring it to you? Is that the direction we need to take that?
Yes, that would be the appropriate chain of events to get it into the SPP planning processes.
Thank you. Thank you, Chair Keen.
Absolutely. I appreciate the colloquy. I think it was enlightening. Thank you, Commissioner French, for your question there. My next question actually relates pretty closely to that last discussion. If we could take a look, Mr. Allen, on page 11 of your direct testimony. Tell me when you're there.
Okay.
All right. I'm looking quite specifically at line 11. What I believe lines 7 through 16 try to do is they try to identify the objectives here of this ITP process. And specifically, line 11 indicates that one of the objectives is to facilitate or respond to expected facility retirements. I think you've probably answered this in part, but I'm going to ask it more directly now. Who actually determines the pace of the retirements, specifically of coal plants, within the states within the SPP? Is it the utilities operating these facilities? Are they the ones that are the primary determinants of the facilities to be retired, or is there some involvement in that process by SPP?
I would say twofold. When we build our baseline reliability models, the projection of retirement of generating units is at the direction of the utilities. SPP does not weigh in on those decisions for our reliability assessments. When it comes to our economic analysis, we do go through a stakeholder process where we project additional future retirements. That's a part of the scoping process. In the past few ITP studies, that has just been age-based criteria by fuel type. So it's a blanket, I believe in this study, if a coal unit was 60 years old, it would get retired. But there's also an exception process as well, such that if a utility feels that that assumption is not accurate, they can appeal to the technical working groups.
Very well. Appreciate the detail of that answer as well. My final question, and it will be my final as far as I believe, and I'll try to make it final. Yeah, I want to turn to the settlement agreement if we can. Do you have access to that? I'm looking at page 11.
Pulling that up. Okay.
All right, in particular, I'm looking at D, paragraph small d.
Okay.
And this makes reference to this question, this issue, it's a big one, about the double circuit issue on this 25-mile portion of the Wolf Creek Blackberry line. I asked you some questions about that before. I'm going to double back on that just a bit here because I think it's consequential. The problem as I see it here is that there's 25 miles of an existing Evergy 161 kV transmission line that is likely to be parallel to this Wolf Creek Blackberry line if we approve it. Such that, and you can go on down to the very end of that paragraph, it's subject to receiving necessary approvals for a change in project scope from SPP. Here's my question, I mean this in all candor. I'm not trying to mousetrap you here in the slightest, but my concern is we've had testimony over the course of the last day and a half that doing this in the event we approve this CCN and then the siding that's subsequent could entail some really consequential costs. And so my question to you is, why were such matters as this, an existing transmission line of consequence, not a part of this extensive vetting process within SPP such that we might have to go through a project scope process that could entail a lot of potential funding requirements. And we're doing this all after the fact of the NTC. I mean, does this suggest that there may be something about the vetting process here that needs refinement so that big ticket items like this don't become issues this late in the process?
That is a good question. I think I would answer that by saying that, again, SPP does not do line routing. So to the extent that the proposed route parallels directly that 161 line, that is not something that we would have known or considered. We don't do detailed routing studies to aid in our transmission project selection. We do take into consideration, I'd call it feasibility factors, and try to reflect those in our costs, meaning if we've got to build a line over a giant lake or around a lake, some of that is captured, but typically by our through our cost estimates that we get through either a third party or the local transmission owner. I'll stop there to see if you have any follow-up.
Well, my concern, and I'm being somewhat rhetorical here, and I'll be very succinct, is there's a lot at stake here. There's from the perspective of Kansas ratepayers, Kansas landowners, the efficiency that and the hoops that Evergy is going to have to jump through to try to be a part of this potential rescoping project here. It just seems to me that how something this significant could evade consideration through this vetting process, it's just rhetorical to me. You don't have to respond. it strongly suggests that the process needs refinement. That this didn't work perfectly this time. That's my view. You may or may not respond. I appreciate your hearing me out.
Sure.
All right. I believe, let's see, no, we have not. Ms. Starnes, if we have the opportunity for your redirect, if you wish to have it.
Yes, I have just a couple, Chairman, if that's okay. And I think one of them, while it may not address the concern that you have just raised, it might explain it a little bit better, if that's with your permission.
Go ahead.
Mr. Allen, I want to clarify just a little bit for the record some of the questions that have come up earlier. In SPP's planning process, it's my understanding that SPP determines the points of interconnection of transmission facilities and not the actual location of the line. Is that correct?
That's correct.
Okay. And in dealing with these types of issues, especially when you see a project that is very likely to fit within the criteria for a competitively bid project, isn't there also sort of a sensitivity of trying to keep that project distinct?
Yes. Yeah, especially when it comes to the competitiveness of projects. Line routing could be a consideration in the bids, and SPP engineering definitely does not want to get involved in that.
So in response to Chairman Keene's concern, yes, there is some concern about the proximity to another Evergy facility, but SPP sort of has to stay away from that particular issue and let the project go through its process. Is that correct?
That's correct.
Okay. So I want to clarify one other particular issue that was raised, just so that the record is clear. We have two different sets of measures that we use with respect to costs for projects. We have a non-competitive set of information and a competitive. Is that correct? Let me rephrase. So what I mean by that, for the PCWG review of a project exceeding its 20% bandwidth, that is for non-competitive projects. Is that correct?
That's correct.
So if a project goes through the competitive process and it has cost caps included in that bid, that is separate and different from the project cost working group bandwidth review. Is that correct?
I believe so. I am not too familiar with the cost caps of competitive projects and how that works.
I appreciate that. Let me see if I had anything else that I wanted to clear up. Oh, yes, I did have one last question for you. We've talked a lot in the last day and a half about the levelization of LMPs that's referred to in the ITP report. Do you remember that?
Mm-hmm.
And I think on a couple of occasions, folks were asked to provide a definition of levelized. And the issue arose of, does levelization mean that if some LMPs go down, other LMPs may go up? Isn't it possible that all the LMPs could end up meeting at a lower level, at the lowest level rather than the higher level?
There is the potential for that, yeah. I think the point to remember about levelization of LMPs is that it reduces overall energy costs for the entire region. And the point of transmission planning is to weigh that benefit against the cost of new transmission.
I appreciate that very much. That's all I have. Thank you, sir.
Thank you, Mr. Allen. Pardon me, Mr. Allen. One of the questions Ms. Starnes asked of you prompts me to ask a follow-up question. She asked you somewhat of a leading question. We've all done it. There's no sin in that, to be sure. But it had to do with this existing Evergy 161 kV transmission line that's going to be proximate, probably no matter where the route is of this of this should it ultimately be built. It's still going to be proximate enough that this is going to have to be involving a change in project scope from SPP. She suggested, and I'm quoting, I think she said that she asked you if it wasn't it true, basically, that you needed to stay away from this issue. And I think you responded yes. And my question is why?
Well, for a hypothetical in this situation, I guess, you know, if we as SPP directed the paralleling of the new Greenfield Wolf Creek to Blackberry project for the 25-mile portion of the existing 161 line, I believe that would make that portion of the line non-competitive because it would utilize existing right-of-way, and therefore SPP would be weighing in on the competitive process at that point. That gets into an arena that I, as an engineer, I guess, don't want to necessarily get into.
I'm not suggesting you do that at all. All I'm suggesting is, should it not be taken into consideration as a major factor? That's all I was asking. And I think it should. I think it's a blind spot in the process. I think we may have to just agree to disagree on that and have differences of opinion. That's fair enough. I appreciate that. Ms. Starnes, I'll give you the opportunity to respond if you do, in fairness to you.
Could I ask one follow-on to that?
Yes.
Mr. Allen, as I understand it, that what you've explained is the reason that you didn't define that part of the route is that you wanted to leave open the flexibility for competitive parties to propose whatever solution they believed would be most competitive and most likely to gain approval by the industry expert panel at SPP. And feel free to correct me if that's a mischaracterization. But would it have been, is there flexibility within that process where an entity perhaps partnering with Evergy or perhaps Evergy itself could have proposed a solution that would incorporate double circuiting that line or paralleling that line?
Yeah, absolutely. I mean, to the extent that the transmission owners want to work together, whether it's in response to the RFP or after, work together to do that, which, I mean, honestly, my personal opinion would be, you know, that's certainly more efficient use of land, then yeah, they can do that.
Okay. I appreciate that. Thank you.
Thank you, Commissioner French. You did my work for me.
I'll never say that.
So just to add on to that, so there's no minimum. I mean, if it was 5 miles, something like that, fine. But this is a quarter of the proposed route. I mean, it's 25 miles. Really, it's a little bit more than that. So within your criteria, you don't have a minimum or maximum that, well, not a maximum, but a minimum that if there is some overlap, it actually is addressed and like showcased in the RFP.
No, SPP does not weigh in on that. You know, I think that would be effectively coordination between two different transmission owners to, you know, own and operate, I guess, common facilities. And I'm no expert on that, but my experience is that can be problematic.
Okay, thank you.
I believe we're at an end here. I'm tempted to add another comment, but I'm going to show restraint and I will not. I believe we are concluded here. Mr. Allen, thank you so much for your testimony. We're grateful for that and your time as well. You are dismissed and you may virtually step down.
Thank you, Chair Kane.
Thank you. And with my apologies to our court reporter, we're way over the time for having a break at this point. By my reckoning, it's 2:20. Let's take a break until 2:30. We will stand in recess until 2:30. Michelle, could we go back to full screen? All right. Is Commissioner Duffy with us? She is.
I am, I'm sorry.
Nope, no problem at all. Denise, are you ready?
I'm ready. Thank you.
Okay, very good. It's 2:30 and we're back on the record once again. I want to take this occasion to remind the parties that we have 7 witnesses to go. It's the commission's intention to finish this hearing, this evidentiary hearing this afternoon. So I would just encourage all parties to be mindful of that fact. Having said that, Mr. Zakura, will you please call your witness?
Yes, thank you, Chair Keen. KIC calls to the witness stand Dr. Jeff D. Macomb.
Here I am.
Please raise your right
When you-
hand.
Yes,
You do solemnly swear the testimony you're about to give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
good afternoon, Dr. Macomb. Is it correct that you filed 36 pages plus 1-page affidavit on May 17th, 2022 in this matter?
Yes.
And if I were to ask you those same questions in that pre-file testimony, would your answers be the same?
Yes.
Do you have any corrections or modifications to that testimony?
No.
And is it also correct that you filed 21 pages plus one page of an affidavit on May 27 in this docket? Is that a correct statement as well?
Yes.
Do you have any changes or corrections to that?
No.
I move for the admission into the record of the testimony of Dr. Jeff D. Macomb, dated May 17, 2022, and also dated May 27, 2022.
Is there any objection? Without objection, they're admitted.
I also, Chair Keen, have included 3 exhibits of Dr. Macomb's writing: KIC Exhibit 1, KIC Exhibit 2, and KIC Exhibit 3. I would move at this time to have those admitted as well.
Is there any objection? Without objection, they're admitted.
At this time, I would turn the. Hello?
I'm sorry, I did not follow what exhibits you were referring to. Are these pre-filed exhibits or are these exhibits that were circulated to the parties in advance?
KIC Exhibit 1, KIC Exhibit 2, KIC Exhibit 3, which were circulated several days ago to all parties and to the commissioners.
Okay.
Is there an objection to the admission? It's been admitted. Please continue, Mr. Zakura.
At this time, Chair Keen, I would turn questioning over, cross-exam, excuse me, over to the commissioners first and then to the parties as required. So I tender the witness for commissioner exam.
Very good, thank you. Good afternoon. Good afternoon, Dr. Macomb.
Good afternoon.
Let's begin as we have with each witness here during the commission, if it wishes to do so, the opportunity to first ask questions or to defer. In that respect, I will begin this time with Commissioner French.
Good afternoon. I'll defer any questions till after the party's cross-examination. Thank you.
Thank you. Commissioner Duffy?
I will as well. I'll defer.
And I as well will defer. So we'll turn next to Mr. Schulte, your witness. Mr. Schulte? Mr. Schulte, do you have questions for cross?
I'm sorry. Yes, I do. I do have just a brief cross-examination. Dr. Macomb, good afternoon. My name is Andrew Schulte on behalf of NETE Southwest. is it accurate that you have not performed any independent analysis of the rate impacts of the 2019 ITP portfolio, which includes the Wolf Creek to Blackberry project?
Yes.
Could you please turn to page 26 of your direct testimony?
Yes.
Thank you. I'm referring to lines 17 and 18 on page 26. Is the sole basis for your claim that the Blackberry project will result in rate increases for Kansas customers? Is that based on the direct testimony of Becky Walding, where she identifies a 4-cent per month impact?
Well, you had asked me that question in a data request, and I responded that way. And it's NETE-28. I think you circulated it before the cross here. And so that's consistent with my answer to that data request.
Okay, yes, sir. And that data request is not yet in the record, so just wanted confirmation in the record. Thank you, sir.
That's what
That's
I
all
wrote
I have.
in when you asked me the question in a data, in an information request. Yes.
Okay, no further questions.
All right, thank you very much. Evergy, any questions of Dr. Macron?
No questions. Thank you.
All right. SPP?
No questions, sir.
Thank you. Curb?
Just briefly, please.
Proceed.
Thank you. Good afternoon, Dr. Michael. My name is Joseph Bastrap. I'm an attorney for CURB. I have a couple questions about your testimony and proposals and how that might play out, okay?
Yes. Hello, Mr.
Okay.
Bastrap.
Hello, thank you. So as part of your recommendation to deny the CCN, you also recommend that the Kansas and the KCC continue collaborating with the SPP on transmission matters, or is it more of a complete separation from SPP transmission services?
No, I described, I think what I referred to as, to some of my colleagues with whom I was talking about such thing as a hitchhiker's guide at the end of my reply testimony on what the commission should do. It's my conclusion in this case that there are elements in the new electricity firmament that give the KCC a lack of information on what's going on in Kansas. We know SPP, and it's easy to admire what SPP has done, and I have to say I enjoyed the testimony of Mr. Allen. But it's also true to say that the SPP has visited no specific analysis on Kansas or Kansas effects, either in the 41 or 44 portfolio of projects or in the overall rate impact. And I think that in the new world that the KIC is facing and the effects of the entry of wind in Kansas on Kansas transmission, as I have shown in my testimony, the KCC needs more evidence on that respect. And it can get that evidence by working with SCC, firstly.
Thank you for that. In regards to the Kansas-specific rate impacts and discussion there, as far as the specificity of detail that you think the KCC should have in front of it, are you specifically referring to dollars and cent impacts on a bill? Are you talking about what utilities pay for energy? What metrics exactly are you looking for there?
I provided a table and a chart in my reply testimony showing the sharp increase in transmission costs in Kansas because of various actions over time with respect to the additions of transmission throughout SPP. I think the KCC needs answers with respect to where those costs are coming from. My tables were not totally complete. They were using the data that I could find, Form 1 data from the federal government and other elements of data on transmission costs and revenue requirements in Kansas. But that's nowhere near sufficient to get to the bottom of why those transmission costs are going up so quickly. With the addition to wind, I don't know how the KCC can accept that kind of galloping transmission cost increase without a better explanation of where it's coming from.
Okay. So it's your contention that the KCC should disregard any cost increases or applications without any sort of specific references to impacts or dollar amounts or rate impacts. Is that correct?
I'm not sure I agree with, you're asking me whether the KCC, what they should or should not disregard. Could you be more specific on that?
Oh, sure. So if an application doesn't provide these detailed dollar and cent impacts or rate impacts for a particular project, the KCC should blanket disregard them. Is that correct? Or deny the application.
Disregard.
Deny the application.
Let me put it a different way, if I could. This is a rapid type of docket for this kind of project. And the KCC does not have Kansas specific rate impacts evidence before it. And I think it's reasonable for the KCC to slow this docket down and do some things in order to satisfy itself that it's reasonable for these kinds of transmission cost increases that I've shown to happen as a result of the kind of process that's driven by SPP. We know in this case that you guys at CURB and staff have deferred to SPP in its modeling and its decisions. And I think it's reasonable as a result, since we have seen staff and CURB defer to SCC, to have SCC do a better job of describing in this modern wind-driven world in Kansas why the rates are looking the way they are and why we've got such a rapid increase in transmission costs as a result of capacity increases in transmission throughout SPP. I think if I were a commissioner, I would very much want to get answers to those questions, and they're not on the record in this case.
Okay, thank you for that. Let's move on to your discussion about collaborative efforts with other states and customers who are wanting Kansas wind energy, okay?
Yes.
And so in your testimony, you describe the importance of eminent domain in transmission planning, correct?
Yes.
And you'd agree that transmission planning is a very important, eminent domain is an important aspect of transmission planning, correct?
You cannot do without it, correct.
And so when you refer to collaborative states' efforts to build long distance transmission lines, will that necessarily require the use of eminent domain in other states?
Yes. Understanding that successful transmission developers, whether it's transmission wires or oil pipelines or natural gas pipelines, try their best not to invoke eminent domain and do deals with landowners along the way. Most of the time that doesn't come up. But to the extent that it does come up, they need the power to do so, and that power comes from the states.
And so under any proposals that you've laid out in your testimony, eminent domain will still play a role in the transmission process, correct?
Yes.
Thank you. No further questions.
Thank you, Mr. Astran. Mr. Jevons, the KCC staff.
Thank you, Commissioner. Good afternoon, Dr. Malcolm. Thank you for your participation in this hearing today.
Hi, Mr. Jevons.
Dr. Malcolm, you are familiar with the Grain Belt project, correct?
Yes.
You are aware an application for that project was approved by the Kansas Corporation Commission in 2013, correct?
Correct.
Your testimony enunciates several legal principles, including regulatory common law, on pages 2 and 29, correct?
Let me just familiarize myself with 2 and 29 if I could.
Yes, page 2, line 17.
Got it.
And then also on page 29, line 15.
Yes, thank you.
Okay, so I'll just restate the question for you, Dr. Mackham. Your testimony enunciates several legal principles, including regulatory common law, on those pages, correct?
Well, I would call them regulatory principles. I might not call them legal principles. I'm no lawyer, but I am a regulatory economist, and those principles fall within my jurisdiction.
Okay. On those pages, you refer to regulatory common law, correct?
Yes.
Okay. I know you're not an attorney, as you just stated, but because you are referencing regulatory common law, are you aware of any Kansas law directing the commission to apply regulatory common law as a basis for exercising its authority?
Generally? Yes, of course. Yes, of course. The concepts of regulatory common law are simple. They're driven by Brandeis, Justice Brandeis, and they have to do with prudence, which is important in this case, because prudence is part of the statute that you can read into in terms of Kansas, as with any other state, and costs, and how we denominate costs, and how we record costs over time, and how we give a return to the companies involved. Those elements of what commissions, not me, call regulatory common law, and accounting scholars of regulation in the US, not me, call regulatory common law, are things that all states hew to in the work that they do.
Okay. Thank you for that clarification that you are not able to cite any Kansas case law that directs the commission to apply regulatory common law. Dr. Malcolm.
I wouldn't agree with the vibe of that summation of what I said. What Kansas is doing and what regulators, I've seen most of them, various generations of most of them in the US, they all conform to the same kind of principles as enunciated by the US Supreme Court. And those items are generally referred to as regulatory common law. There's nothing that this commission, the KCC, does that's inconsistent with that.
Dr. Malcolm, it is true that you would prefer to have the electric transmission system regulated in the same manner as oil transport pipelines rather than the system adopted by the regional transportation organizations, correct?
I cannot agree with that. First, you use the word prefer. There's nothing in terms of what I've done here that displays a preference on my part. My preferences are unimportant. To the extent that I've talked about aggregating capital or obtaining land for a national purpose in transmitting energy from one part of the country to another, I'm talking about the goals of achieving that national purpose through the aggregation of capital in a well-reasoned way with reasonable regulation along the way. It's not my preference. It's just the fact of how in the US we aggregate capital for those purposes. And what I've tried to do, well, you saw, what I've tried to do in my testimony is to say that there's nothing so inherently unique about electricity that means that the principles that underlie the way we aggregate capital for the transmission of energy in other industries and conquer geography, like interstate natural gas pipelines or interstate oil pipelines, is inimical to what we should consider when we're thinking about the new wind generation problem and the backlog we have in the United States. If we think about interstate wind energy transmission, we deal with the same issues. How to aggregate capital at a low cost by anchoring it to an engine of capital repayment, resting in utilities in the end, and how we get competitors to plan and build projects in an interstate fashion that we've done before. We know that tool. We know that story in the US from a broad perspective. It's one of my complaints. And if I have a preference, the preference would be to take a little longer view and a little wider view for everybody who has to contend with problems like Kansas has, to see where the solutions lie with respect to aggregating capital to transmit energy in a multi-state, interstate fashion for a national purpose. And that's the point of the context that I provide with my testimony.
Okay. Thank you for that explanation. And that would require a fundamental change to how FERC regulates interstate transmission, correct? To use the comparison to the oil and natural gas context, correct?
Not necessarily, no. You brought up grain belt. The KCC has given 2 authorizations to grain belt. I've read all the orders. And that didn't involve any FERC policy, except to the extent, for instance, that SPP would be satisfied that as the power exits Kansas, it didn't interrupt any of SPP's operations. And at the destination of grain belt, it would mean that as the power lands and is converted back into AC power in MISO or PJM, that those RTOs would have to understand how their RTO situations would digest that import of energy on that HVDC grain belt line. The FERC itself wouldn't have any direct involvement in that. They don't involve the land. They wouldn't invoke eminent domain. They have organs, the RTOs, that have to deal with the line on either end, but they're not directly involved.
Dr. Mackham, did you author testimony on behalf of NextEra in a docket before the Illinois Commerce Commission regarding NextEra Energy Transmission Mid-Atlantic and docket number 18-0843?
Yes, I have it right here. Thank you for sending it around in advance.
Yeah, no problem. And NextEra Transmission Mid-Atlantic is an affiliate of NextEra Energy Transmission Southwest, the applicant in this docket, correct?
Yes, they were my client in that case.
Okay. Are you familiar with the substance of that testimony?
Yes.
Okay. I'm going to ask you several questions about that, and so I understand you've got a copy in front of you. And staff would like to motion to have this evidence be entered into the record as Staff Exhibit 1. My understanding is OGC has circulated this with the commissioners. Is that correct?
Chair Keen, you're on mute if you're speaking.
Thank you very much. That would help. My apologies. Is there objection? Without objection.
No objection.
I'm sorry?
No objection.
Oh, thank you. It's admitted without objection.
Dr. Mackham, I'd like to direct you to page 2.
Yes.
And if you're looking at it on your computer, maybe PDF page 3.
No, I'll have a hard copy. It's easier this way.
Okay. Lines 38 to 41. You state there that NETE MA is qualified to operate and maintain the transmission facilities and to provide safe, reliable, and efficient service using those facilities, and to do so in a least cost manner consistent with its service obligations using the extensive resources and expertise of its large and experienced overall corporate organization. You say that correct?
Correct. In the context here, they were buying an existing line in Illinois from a small co-op. And I was describing the company's overall expertise. We've seen that on display in this case with witnesses like Amanda Finnis and Kelly Harrison. But that was what I was describing there for this line that NETE proposed to purchase.
Okay, thank you. I'll now direct you to page 7. Lines 149 to 152. Here you state NETE may. Oh.
Before we get to line 7, I mean, would you mind if before we get to line 7, since we're going through all the testimony, if I describe something on line 6 that I think is important for this case?
No, so with respect to the cross-examination here, would like to stick with my line of questioning here.
Okay,
fair enough. I'd like the witness to be able to give a full answer if he could. And I believe he's contending that would take the review of line 6 to give a complete answer, counsel.
And I would say that there will be an opportunity for him to address that on redirect.
Very well.
On page 7, lines 149 to 152, you state NETE MA, supported by its affiliates, is part of one of the largest electric utility enterprises in the United States. It is manifestly qualified to provide efficient and responsible transmission service in Illinois, as it does in other states. You said this correct?
Yes, you read that correctly. I think everybody knows that.
I'd like to point you to page 15. Line 340 to 342. And continuing on page 16, lines 343 to 344. Stated in relation to NextEra Mid-Atlantic, certification is not an unbounded speculation.
Oh, excuse me, let me just look at that paragraph on these 2 pages before we read it. Could you? Okay, I appreciate that. Thank you, Mr. Jevons.
Yeah, no problem. So on those pages and in those lines, you stated in relation to NextEra Mid-Atlantic, certification is not an unbounded speculation into all present and future consequences of certification, but rather a confirmation that a willing and able enterprise is in position to meet a public need to provide safe, adequate, and reliable services at a reasonable cost, using the least cost means available to it, consistent with its other service obligations to provide that service. You said that correct?
I said, yes, I said that, and that's the end of it. But in order to make sure that we give it the proper context, I would have to add for that existing line in Illinois. We're talking about NETE proposing to purchase a small transmission line in Illinois that had been operating for decades. There was no new service. There was nothing new going on. There was just one owner switching place with another owner in Illinois. All that I said there is still true, but it's in the context of an unchanging situation on the ground. Just a new owner for an existing co-op transmission line. I hope you understand that that's a sort of an important context for this piece of evidence, as opposed to the situation facing us here, where we're talking about a new entry of a new line. There was no entry there, just a new owner.
Okay, so if asked the question of whether NETE Southwest is qualified to operate and maintain the transmission facilities in question here in this docket, and their ability to provide safe, reliable, and efficient service using those facilities, and to do so in a least cost manner using the extensive resources and expertise of its large and experienced overall corporate organization, would you have a different opinion on NETE Southwest?
Meaning, is there something about this case in Kansas that changes my opinion about the qualifications of the larger NETE organization to operate transmission facilities? No, there's no difference here. To me, they're manifestly qualified to own and operate transmission facilities. And in this case, they propose to construct some. And I've been involved with testimony very much like the one that you're mentioning for the CREZ project in Texas 11 years before, where there was new construction going on. And I said they were qualified to do that too in that case.
Thank you. I have no further questions.
Thank you, Mr. Jevons. Let's turn to the commissioners and see if they have questions at this time. I'll turn first to Commissioner Duffy.
I'll pass. Thank you.
Commissioner French.
I will ask a couple questions, but I am going to try to be quick, given where we are in the afternoon. Good afternoon, Mr. Macomb.
Hi, Commissioner French.
I am. Let me just first say how much I appreciate your testimony, and parties can debate the relevance of some of these proposals to this specific project, but I do think it's very interesting and certainly part of the broader conversation we're all trying to have about how the country moves forward and how we move low cost or fuel savings type energy from one geographic location to the load centers. And so in that respect, I want to express my appreciation for the academic work you've done, and I certainly have reviewed it pretty closely. I do have, I guess, a couple just specific questions about some of your testimony, and please forgive me if some of this seems a little nitpicky, but I want to make sure I understand some of what you're saying. If you'll look at page 11 of, I think it's your reply testimony, at the very bottom of that page, you are describing, you're just generally talking about how the escalation of retail transmission rates within the state of Kansas, and the fact that this commission, in your opinion, does not have a firm analysis of why that is occurring. I want to start off by saying I share your concern on this issue, and it's certainly something that's gotten a lot of debate. One thing you say here, it's the very last sentence. You say it simply makes no sense that each individual project is claimed to have benefits that exceed costs, and yet in the aggregate, transmission costs and prices are rising radically. That would, let me phrase it a different way. For projects that are built to meet a reliability need, or if transmission is built to modernize the grid or rebuild aging infrastructure, nobody would be claiming that those projects, I guess, APC costs or economic costs exceed, or benefits exceed the costs, correct? So here we are not talking about all projects, right?
Yeah, the table that precedes that sentence on table 11 was trying to put transmission in context by charting the growth in transmission at compound 11.26%, with the growth in total electricity sales, which was a proxy for the rest of the stuff, which was 3%. And that's the point I was getting to. It wasn't 3 to 4 or 3 to 5. And there is replacement of aging facilities in distribution territories and in generation in other places, but it's 3 to 11. And that's what I was trying to point to in saying, as in this case, we have a complex debate about whether or not this BlackBerry project is worth the price. And
I apologize for the interruption. I understand the point of the chart. I guess I'm just trying to clarify that there is a lot of building going on that I don't think anybody is even claiming is cost beneficial. It's just reliability, or maybe it's just necessary, but it is not transmission intended to drive down costs, which would, I think, to me, that's in direct conflict of what you've said here, which is that somehow the commission has been bamboozled that these projects were all going to pay for themselves. And that's not my understanding of what's gone on. I'm not saying that all of the cost has been justified, but you would agree that nobody has claimed that every single transmission cost was going to have benefits that exceeded its costs, correct?
Correct.
Okay.
In a pooled transmission system like the one you're discussing, Commissioner French, no one's is trying to say that each individual new link is going to pay for itself over its useful life. That's what the people who build grain belt do. They have relenders and investors that are making sure that that will pay for itself over its useful life as a single line, but no one does that within the confines of the pooled transmission system of SPP. But if I could, you raise an important point, and you've done it a number of times, and I've listened to it, and I've heard what you've had to say, which is that transmission is lots of transmission is built to lower other costs, power costs, to lower LMPs on an average basis for the entire system. And that, of course, is true. But one thing we haven't wrestled with to this empirical satisfaction in this case, is whether that's true of this project. We don't know, because we don't have Kansas information. And I have to say that if this were 15 years ago, in the old pre-wind, when wind generation was 3 times the cost that it was today, and there wasn't such a drumbeat to buy renewable energy downstream in the non-resource rich states. If this were 15 years ago, it would be easier to say that SPP's planning in order to create an economic project. By economic, it means to cure congestion. That's what economic means in terms of economic or reliability. Economic is curing congestion. It would be easier to just go along with what's going on with SPP and their modeling processes, which are 15 years old. But my basic point, and it goes to your questions, as I've heard them again and again, is there something new? Is something changed? And I think things have changed. Wind has declined by 2/3 in terms of the price. The demand for wind downstream has gone up like a rocket. And at the same time, we've heard, it was great testimony of Kelsey Allen. He takes the projects as they hook up to the system. He doesn't decide what comes on or not. If you fulfill the regulations, you get on. And to the extent that we've got much more wind than Western Kansas needs, it's washing over Kansas. And he has a program that investigates congestion. And he specifies projects like Blackberry to deal with that congestion. What I'm saying is that the world has changed. And it very well may merit taking a closer look at 66-1180, which easily 15 years ago, I would conclude that it's reasonable enough and prudent enough where SPP says something is good for them, it's good for the group of 14 states. But those 14 states aren't in the same boat anymore. And to the extent that we don't have answers as to why transmission is going up so greatly compared to everything else, that's something that may, I'm not a commissioner, I've never been one. You guys are the practical, politically minded people who have to interpret 66-1180. But to the extent that focuses on Kansas, we don't have those answers in Kansas.
So I think what I'm struggling with, I completely understand your point about figuring out the export problem. I think we've been trying to figure that out. Since we certificated Grain Belt Express 11 years ago. So that point is well taken. The KCC in recent comments to the FERC said we have concerns about just continuing to hook up more and more new intermittent generators and the diminishing economic returns that may be if we don't have ability to export that power. But I want to focus in on this particular project and our region. And to the extent we do still have the ability to build projects that do drive an economic benefit to our region, it seems that your position is that we should send a message by just refusing to go to create those economic benefits for the region until I'm not sure how we make the Grain Belt Express paradigm just work, but you seem to be saying we should forego regional benefits of these economic lines until we get that paradigm. Is that?
Yes, and let me, if you got nitpicky with me, I'll pick one nit with you, which is that when you use the terminology of SPP to say economic, you're talking about congestion curing. We're not talking about, and that's a congestion-based transmission cure. We're not talking about export, but export has become important. And I would recommend that you start treating congestion and export as two different kinds of economic transmission. Totally different. Grain Belt is a visionary project. It's slow to get off the ground. They probably underfunded the legal work that had to be done in the states along the way. I know how much that costs. I was involved in the capacity increase for the Dakota Access Line. Huge increases, and that was in North Dakota, South Dakota, Iowa, and Illinois. In every state, you had to do great legal work to get a line like that through. But it worked, and it did, like I say in my testimony, the benefit to North Dakota that we see in North Dakota. But getting back to these two, congestion and export, I don't think the KCC has evidence that this line, Blackberry, is good for Kansas. And I think I think that given the costs involved and given the way it distracts from other export-related activities, it's bad for Kansas. But this proceeding doesn't have the data to show it. It's too short, it's too confined, and it was, if you permit me, docketed in a way that presumed this project would be confirmed like all others that SPP proposes, and manifestly qualified companies like NETE would bid for and win.
So I understand I completely understand KIC's points as to the limits of what the benefit cost analysis shows or does not show. My understanding is that I think all the parties agree that there is a cost benefit analysis showing a benefit to the region, but there appears to be a lot of debate as to what that means for the state. If we take it as a given, at least, that there is a pretty sizable cost benefit to the region, then I guess my question would be, we have a cost allocation mechanisms, the highway byway method. Is it KIC's contention that the highway byway method is producing an unreasonable allocation of cost in this case?
That's a great question. I would answer it this way. If the highway byway method is there not just to cure congestion problems and local power market problems, which is what SPP was designed to do. That's its mandate. I was there at the FERC giving live testimony when this whole business started. That's what they're supposed to do, and they do it very well. Just listen to Mr. Allen. He was very good in describing what they do and how. He's truly an expert. But if you're starting to apply highway byway to what really is masquerading as an export line, then highway byway is no good. Because what you're doing is you're charging the locals for the export of the local goods. It would be as if you charged North Dakotans, generally, all people in North Dakota, for the Dakota Access Line. You don't want them to pay for the export. You want the users to pay for the export. So to the extent that you fogged the difference, and I believe that in this case, the difference is quite fogged, between a facility that's there just to deal with the congestion that the power market requires, and another facility that actually is exporting wind-based power in western Kansas to Missouri and further east, then you're applying highway byway to an export project, as if you applied highway byway to grain belt, which would never make any sense.
Yeah, when you say export, you're not claiming export to other regions, right?
When I say export, I'm dealing with it in not like an expert would who works in SPP or elsewhere, but just somebody looking down on Kansas and seeing far more wind generation than the utilities in Kansas can use in western Kansas. And it's all going across the state, and it's congesting facilities that have been in place for decades.
But I guess what I'm getting at is
that looks like export to me.
The evidence indicates 97% of the benefits are remaining in SPP, and the Evergy systems in Kansas are getting big cost benefit from this line. So are you just saying export as far as export from Sunflower to Evergy, or You would agree
No,
the
I-
evidence does not indicate that this line has anything to do with exporting to MISO.
In terms of where the power flows, it crosses the border. And it's going across the border. And the congestion that it's designed to cure.
Which border are you
caused by
talking about?
The Missouri border.
You would agree Missouri is an SPP.
A little bit of Missouri is an SPP. But as SPP said, and other people have said in this case, within the pooled system, nobody's got capacity rights. You know that this stuff is going to flow from the destination in Blackberry, where it's going to flow. Some of it's going to flow back across Kansas. Some of it's going to go into MISO. We know that.
Can you point me to the analysis that says that this power is being exported to MISO? Because that was something that I don't know that was in your testimony. I know I saw it in a pleading, and quite frankly, it was shocking. It was shocking to me. You know, this is a project planned to meet the needs of SPP customers. It was meant to benefit SPP. And I saw this assertion, I think it's even been repeated in the media, that this line is being built to benefit customers in other regions. And to me, it seemed like a pretty outrageous claim. And so I guess I would either, well, I guess I'd like to see which analysis you or your clients were relying on to make that claim.
I don't know who else is making that claim, and I don't know what's going on in the newspapers. But I don't. I barely have time to read my own here. I haven't read yours. But I do know that as the price of wind power has dropped by 2/3, there's a backlog of companies that want to create wind generation to take advantage of those low cost, that new technology. And as they apply that new technology and those low costs to where the wind is blowing in Western Kansas, in places like Western Kansas, it's creating a problem for RTOs that weren't built around that geographical issue. There's no geographical interstate transport component of the RTOs. They weren't built that way. That wasn't their job. Their job was to try to facilitate power markets the way they could and deal with the reliability issues of transmission. But to the extent that you're seeing a broader movement, much more generation in Western Kansas that they can use, of wind power that's preferred generation source because the prices dropped so greatly. Consider what would happen if wind generation were free. It dropped the other third. You'd have a huge backlog of wind being generated in Western Kansas, and it would all be heading east. And SPP's models would be dinging at you, showing different constraints and congestion paths as that increased wind generation would move to the east. That's where it's going, because that's where the load is. When I say export, I'm not using it technically. I'm just seeing where the wind is and where it's being generated into electricity and where that electricity is headed, and it's headed east. And the failure, and it is a failure to me, to distinguish between economic projects that have to do with congestion relief of the old style 15 years ago, and projects to deal with congestion relief that's driven by this new geography of resource-rich states' power supply. That's a failure, and that's what's getting us into the problem of bickering over these cases like this one for Blackbird. We don't have the data to separate those two because this data is the procedures are rote. They're expert and rote. What SPP is doing is terrific, but it was designed for another purpose. They can't see geography. They don't see exporting power. They just see curing constraints when the stuff connects to the system, just like Mr. Adams said.
I understand your point. I just want to confirm that you did not prepare an analysis and you have not seen any analysis or evidence in this docket that this line is delivering benefits predominantly to MISO or being built to export power to another region. In fact, that's more what you think we should be focusing on, correct?
Bingo. There's no time to do it here. The procedures that we had 15 years ago were okay then. To me, I would have been here for NETE then. except that the opposition wasn't strong enough that required them to hire somebody like me to overcome. But we have a new world. And my principal point is that we're not wrestling with that problem. And particularly for Kansas, the most wind-endowed state in the lower 48. If you did that, you would help the grain belts. And you might defer this kind of case, which is sucking capital out of the system. And it may very well, I don't have the study to show it yet, but it may very well be deterring from the kind of electricity export that you really want to do.
The only other question I'd have would be related to Mr. Allen's testimony on congestion relief and how much congestion relief you do. You know, you talked about the fact that we just keep building and building and building wind, and we keep building transmission to relieve the congestion associated with that. But you would agree with Mr. Allen that under their studies, at a certain point, we only do congestion relief if it's cost beneficial. And so there's going to become a point where they're not going to suggest we approve projects, correct? Economic projects are only approved to the extent they are cost beneficial, correct?
Yes, but cost beneficial is not in evidence in this case. You don't have evidence of Kansas cost beneficial. And well, it's what I said, you might prudently be able to sweep that under the rug 15 years ago before the geography of the new electricity supply came up. But it would appear to me harder and harder now that this has become more hotly contested topic. And in Kansas better than anybody else because you're first in line if you're going to make money on exporting electricity. It's you guys who are going to benefit the most. That it's high time you stopped treating every BlackBerry-like project as if we were in the 15-year-old world, but all of them could have been presumed to have been there to deal with local power markets, rather than bleeding over into masquerading as export projects, which I think this one is. And if there were more study, we could show it.
Well, I appreciate, I'm sorry to cut you off.
I went on and on. My apologies.
I appreciate the back and forth, and I know I come across as nitpicky sometimes, but it is because I do enjoy this discussion, and so I hope that you took the back and forth in the good nature that it was intended. With that, I have no more questions. Thank you.
Thank you, Commissioner Duffy.
Yeah, real quick. So in your rebuttal testimony, I think it's on page 20 and 21, you talk about then what you would do, your 4-point plan.
A hitchhiker's guide.
Okay, a hitchhike. Well, all right. Hitchhike only once in high school to get to a tennis meet. See my boyfriend play. Sorry, that's all I know. A dad picked me up and had me crying so hard because he said, if you had been my daughter, da, 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 da. All right. So I don't know what you mean by Hitchhiker's Guide.
It's a book. Hitchhiker's Guide to the Galaxy. I apologize, but
well, to me, it's kind of like, okay, that's your solution to this issue, and I find it lacking.
Okay. Then let me reply that I read the fortnightly article where you three commissioners were saying what I think was exactly the right thing. Even the editor began the article by saying that your number one issue was to how to figure out a way to get Kansas wind electricity to the states that need it. And I thought in that respect, you defined the nature of the biggest inchoate problem that you face. And I thought this February 2022 article was really good. How you define the procedures to actually separate out export transmission from congestion transmission for the local power market is a difficult thing to do. It took us many years to figure out how to do this in interstate natural gas supply. It took us other years to deal with it in terms of oil, going from common carriage to contract carriage in oil pipelines. That was a big deal too. I'm not saying this is easy. And by putting these things down, I mostly said, you have to start demanding evidence where you don't have evidence now, like in this docket. And the only way to get evidence is to work through these issues. I don't have a path to lead you through other than to say you have to start studying the issues. And if it's deficient in that respect, I take the criticism.
Well, it wasn't, your testimony was enjoyable to read. I do think you're making some good points about we need to reflect, and a lot has changed in 15 years. I agree with you there. And but we're also technology, and we've become more worldly in that we're part of an RTO, and that we see things beyond our borders of the state. And I don't think that can be ignored. I think that has been a benefit. And I go back to what happened in February, Storm Uri, the winter storm event, how that may have played out differently had we not been in an RTO, had we not had the ability to move power as it was needed. And I think it's an evolution, and we're still in the middle of it, but I appreciate your testimony.
All right, very good. I believe we've, let me add my 2 cents worth here, Dr. Macomb, if I may. I too appreciate the value of your testimony. I thought it was very evocative. It's very interesting as well. I really don't have any questions to pile on to the questions already asked of you. Given that, I'm sorry.
I have a redirect.
Well, I was headed there if you'll give me a minute, Jim.
Sorry.
Having said that, I will turn to Mr. Zakura for redirect.
Thank you. I'll do my best. The discussion was kind of wide ranging, so I'll do my best to tie it back to the particular items if I could, and hopefully bring some clarity in. And I want to thank each of the commissioners and the other parties for their presentation of questions to Dr. Macomb. We truly asked Dr. Macomb to be here to give advice, to testify this, to help us with a path forward in Kansas. And I believe he did that. But let me turn to some direct items if I could. I believe I'm going to tie this back to both CURB and staff on their examination. But I know CURB basically said the position, why are you proposing to reject this? Is it because you think we should do a collaborative process? And it seems to me that your testimony is divided into 2 parts. Number 1, why you believe the project should be rejected for CCN, and number 2, what is a collaborative process? Would you respond to why it should be rejected, and 2, why you think a collaborative process is appropriate?
Yes. If you read my testimony, you will see that I think there was always a gap in prudence analysis. And I think the gap could be forgiven 15 years ago, but now it's obvious and it's a big problem. And the idea that I've dealt with data for this my entire career, going back to my graduate work. The great increase in transmission costs are coming without scrutiny in Kansas. And it's imprudent to let that continue, in my opinion. That's why I would reject the certificate. But you can only answer the questions with respect to the overall prudence of participating in these kinds of projects, where this commission has the role and they control the land. FERC doesn't do that, you do at the KCC. is to study the issues that I described in that poorly named Hitchhiker's Guide, to elicit what you can from SPP, if it can do so, to split out. They've got the people, they can do this. They can split out state by state benefits and costs. It's not beyond their capability. They have the talent. We've already seen it here today. So that you can decide whether or not to participate, or whether or not a particular project like BlackBerry is more export related than what they used to call economic related to facilitate power markets. And that's why those two things go together. I think that you've come to the end of the road with respect to agreeing to certain procedures by the RTOs that no longer work when the different states are differentially situated with respect to their resource endowments. RTOs ignore resource endowments like that. Sure, they have to model the contingencies to come up with respect to it, but they're irrelevant to the planning of things like Grain Belt or to any other of the kinds of projects that head either west or east from the windy areas. The ones who are going west don't deal with RTOs. They're in non-RTO areas like the Pacific Corp large project that just is getting going. So if the states like Kansas are going to monetize the benefit of being resource rich and not squander it in bigger transmission costs for their own local residents, I think they have to grasp this nettle. And it isn't going to be easy, but Kansas has already spent a lot of money studying issues that don't pertain to this export versus congestion issue, and I think it should.
Let me see if I can summarize that a bit, Mr. Macomb. Your objection to granting the certificate is that there is no demonstrable benefits on the record to Kansas, and that would echo the testimony of Mr. Allen today, and also Mr. Franz. Is that correct?
Yes.
And it's your further testimony that the commission should not grant the certificate until that kind of Kansas-specific information is provided by SPP.
Yes, and if not SPP, another party who could do the kind of analysis required.
Now, let me speak to the issue and try to bring some clarity of what we're talking about in movement of Kansas energy outside the state. You were listening, I'm sure, to the testimony of the last 2 days. Is that correct?
Yes.
And part of the evidence that was brought forward is that Kansas is producing much more electric energy than is used by Kansans. Is that correct?
Correct.
And as we looked at the evidence for 2018, where that number was 19% more than consumed, and it grew to 26% more than consumed, your concern, and maybe export is the right or the wrong word, but your concern would be, how do you manage the process of Kansas producing more energy than is used by its customers, its consumers, and the fact that that is likely to grow as more wind additions are added in the state?
Yes, that's my overarching concern. I think Kansas should monetize for the benefit of Kansans the export of Kansas resources, just like North Dakota has modified for the benefit of North Dakotans the application of new technology for the extraction of oil in the Bakken field.
And in this case, the BlackBerry line has a terminus point at Associated Electric Cooperatives, Inc. Is that correct?
Yes.
And AECI at that point is not a member of SPP. Is that also correct?
That's my understanding.
And what happens to the power after it goes into AECI? We have no evidence in this record where that might go. Is that correct?
I've seen none.
So we know that the physics of the project is to deliver from the Wolf Creek area to AECI in Jasper County, Missouri, which is not a member of SPP, and beyond that, we don't know.
I've seen no evidence, like I said.
With that, Chair Keen, I believe I'm concluded with the recross.
All right, thank you, Mr. Zakura. Dr. Macomb, I believe that concludes your cross-examination. I appreciate that very much, and we appreciate your testimony. At this time, you are dismissed. You may step down, and have a good day.
Thank you all. Thank you, commissioners.
Thank you. At this time, we are roughly an hour into this latest part of our session. I'm going to have us take a 5-minute recess at this point, and then we'll resume. So we'll be in recess until 3:41.
Look at this.
Denise, how are you hanging in?
I'm okay, thank you.
Okay. It's 3:41 and we're back on the record. Before we move to the next witness, for the record, I want to note that Mr. Schulte, on behalf of NextEra, has proffered the following stipulation, which the commission has accepted and which I will now read into the record. NETE Southwest stipulates that it has executed 9 option agreements in Kansas, substantially in the form of the option agreement and transmission easement, which has been identified as McGee Exhibit 1 and admitted into the record of this case. All of the executed option agreements include payments to the landowners. End of stipulation.
Chair Keen?
Mr. Schulte, have I properly read and introduced the stipulation as you proposed?
Yes, Chair Keen, thank you.
Thank you. Mr. Cohen?
Yeah, IT just called and said that Curb has dropped from the meeting or has been having trouble getting back in and may have missed some of the end of Dr. Macklum's testimony. And I just want to make sure they're back in and we're able to see everything.
I see Mr. Astraub as you speak.
Yes, hi, let me address that briefly. Thank you, Mr. Cohen, for bringing that up. Yeah, right after redirect had started to that first question, Curb staff had lost internet signal quite a bit, were kicked out of the Zoom meeting for approximately about 5 minutes leading up to the 5-minute recess that we just came back from. So we had missed that portion of it, but I believe if it's available on YouTube, we can probably circle back around and catch that aspect of it prior to a transcript. So I believe the Curb staff in the office are all back online. So I think we're able to proceed now, but if we have any other interruptions, we will definitely go run to IT because we won't be able to communicate otherwise.
Very well, thank you.
Thank you.
All right, Mr. Calcara, if you would, please call your witness.
Thank you, Chair Keen, and good afternoon. Good afternoon, Commissioner French and Commissioner Duffy. Sunflower Electric Power Corporation would call Mr. James Brungard. And just logistically, Mr. Brungard and I are in the same location. So I'm actually just going to turn the camera so that you can see him and I'll be off camera.
Fair enough.
Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Thank you.
Mr. Brungard, could you please state your name and business address for the record?
My name's James Brungard. My business address is 301 West 13th Street in Hayes, Kansas.
Are you the same James Brungard that filed direct testimony in this docket on May 17th, 2022?
Yes, I am.
You have any corrections or additions to that testimony at this time?
No.
If I asked you the same questions today, would your answers be the same?
Yes, they would.
Chair Keen, I would move for the admission of the pre-filed direct testimony of Mr. James Brungard.
Very well. Is there any objection? Without objection, it's admitted.
And with that, Chair Keen, I would tender the witness for cross-examination.
All right. Good afternoon, Mr. Brungard.
Good afternoon, Chairman Keen.
Let me turn to the commission first, give them the option to ask questions first if they wish. I will turn first to Commissioner Duffy.
I'll defer. Thank you.
Thank you. Commissioner French.
I'm going to hold my questions till after cross. Thank you.
Fair enough. Thank you. Mr. Brungard, I have one question for you to begin this round of testimony. My question is very simple. In your opinion, why would this line be beneficial to your customers if it's constructed and operated?
Quite simply, Sunflower, I was very careful in my testimony to not state one way or another whether we're supportive or non-supportive of this line. I look at it more as we're a member of SPP. We're part of the stakeholder process. We rely on SPP to plan projects across the region. We were more interested in that if NextEra is granted a certificate in this docket and was granted TO status in Kansas, that we set some parameters around it. That was basically what my testimony focused on, just like we did in the Grid Alliance application a few years ago. So I can't necessarily say that this particular line would benefit or hurt the Sunflower ratepayers, but more specifically, those protections not being put in there could hurt the Sunflower ratepayer.
Very fair answer, Mr. Brungard. I appreciate it very much. I didn't mean really for my question to be perhaps as leading as it appeared. I think you've adequately covered the waterfront about that. I appreciate that response very much. Let me move on to other questioners here. Next up would be Mr. Zakura.
Good afternoon, sir.
Good afternoon, Mr. Zakura. Good to see you again.
Good to see you always, sir. I only have really procedural matters for you, sir. Last evening, I received what's been denominated as KIC 45, which is a response to a data request of KIC from Sunflower. It's data request 1-01. And I labeled that and distributed it this morning to everyone as KIC 45.
Yes, sir.
I would please ask you, sir, if that is in fact the authenticated response of Sunflower Electric Power Corporation to that data request.
Yes, that's our official response to that data request.
Chair Keen, I would please move to admit into the record KIC 45.
Is there any objection? Without objection, it's admitted.
Mr. Bethart, just one other item. We had listed, I had accessed the Sunflower Power Corporation website and had certain Sunflower documents listed as exhibits. And they were particularly KIC 21 and let's see, KIC 21 and KIC 24. And those are from the website of Sunflower Electric Power Corporation. 21 is recent wind build-out brings operational changes. And 24 is Sunflower Electric Power Corporation transmission system and system operations.
Yes, sir. I have those.
I would like to introduce those as exhibits as being accurate downloads from the Sunflower Electric Power Corporation website. Could you verify that those, or can you verify, sir, that those come from the website and that you have seen them before?
Yeah, I've verified that those did come from our website. Yep.
Chair Keen, I would please move that KIC Exhibit 21 and KIC Exhibit 24 be admitted into the record.
Is there any objection? Without objection, they're admitted.
I have nothing further for you, sir, and thank you very much for your testimony.
Thank you, Mr. Zakura.
Thank you, Mr. Zakura. All right. Mr. Kimmel, any questions for this witness?
I have no questions, Commissioner. Thank you.
Thank you. Do any commissioners have any further questions of Mr. Brungard? Commissioner Duffy.
I do not. Thank you.
Commissioner French.
Just a couple, and I'll be very quick. Mr. Brungart, were you here earlier when we were speaking with Evergy witness Ives?
Yes, I was, Commissioner French.
We had a discussion about LMPs, and I think Mr. Ives indicated that, you know, while it is good to have low wholesale energy prices, sometimes there are negative effects or having congestion and having maybe artificially low price signals and what that says to your generators. And I didn't want to get specifically into Sunflower with Mr. Ives, but would you have any commentary on that from a Sunflower perspective of, is it always a good thing to keep LMPs as low as possible, or are there times where a higher or more accurate price signal is better for Sunflower in your area?
Yeah, so specific to Sunflower, I would always say that there's got to be a balance, right? There's got to be a balance between achieving as low as price as possible, but also not giving up the reliability in order to achieve that. The risks that you run with bouncing price signals, as I call them, or bouncing LMPs, where you'll go from a negative LMP to the LMPs that we saw in February of 2021, is that prior to 2014, fossil resources, particularly sunflowers, and I think most across the nation, were built as more what I call base load resources. So they were designed to run for the base, to serve the utilities base load at a high level over a flat period of time. What happens when there's a lot of intermittent wind generation that comes onto the system is you wind up using those base resources to chase price signals. And that, to me, can be risky in terms of reliability. I also agree with some of the other witnesses that you don't want to necessarily achieve or pay for a system that has no congestion whatsoever, because then, in my opinion, you're driving a Mercedes when you could be driving a Toyota. Is the way I guess I would phrase that. So that's kind of the way I look at the balance between achieving as low a price as we can, and then also not giving up on reliability.
I'm very glad to have the Sunflower perspective on those. So we've hit kind of both sides of the state. The only other question I had, actually, do you have a copy of the 2019 ITP report with you? We may be able to do it through just discussion if you do not.
Not in front of me, but I'm familiar with it. If there's something you can generally.
What I wanted to ask you about is, we're here today to talk about the Wolf Creek to Blackberry line, which is, I think, roughly an $85 million cost and spread across the region. I think Sunflower's percent of that is probably about 2%, which, if I'm doing my math right, maybe $1.7 million. So I know that's probably not exact, but I'm ballparking it for your pricing zone. But actually, I was looking at the list of the economic projects in the 2019 ITP, and I noticed that there is another economic project in SUNC's area, which I assume is Sunflower Cooperative's area. It's a $3.7 million project, and it looks like it's only 115 kV, which to me would indicate 2/3 of the cost of that project would fall on Sunflower. Is all of that correct so far?
Yeah, you're pretty spot on. You're spot on with the 2%. The specific project you're referring to, I'm not familiar with, but if it's a base plan project that comes out of SPP, and it's prior to any changes in cost allocation, then yes, it would be a base plan project and we'd pay 67% of the cost.
So my math on that is, you're actually paying $2.5 million of that project, which is intended to provide benefits to the whole region. So it's a smaller project to some, but it's actually, to me, it looks like maybe a more noteworthy project to you all than the Wolf Creek to Blackberry line. Has Sunflower considered, I assume it's economic in the sense that it's economic benefits to the entire region, just like Wolf Creek to Blackberry. Have you done any analysis of how that line is going to impact you all, and how that line is going to be used, if it's going to be used for export or whether it's going to drive benefits to your folks? That may be more granular than you can get right now.
Yeah, that line, that particular line, I haven't done a detailed analysis on. I can just say generally, that I think you're correct. And as you are well aware of with your great work at SPP and why you have a lot of fans out here in Western Kansas, is that, we deal with projects that are they driven by the sunflower, the sunflower zone, the sunflower customers, or are they driven by other things that are causing those facilities? And that's why we've done so much work in terms of cost allocation at SPP. So yeah, you're right in the sense that it doesn't take much of a project to have a greater financial impact to us than, or when you compare it to this particular Wolf Creek to Blackberry line. Like I said in the beginning, obviously we're always concerned with the financials and our costs and what we're passing on to ratepayers. But this just as much is a concern for us about protecting us as a TO in Kansas and making sure that the requirements are met for all entities that want to build transmission in Kansas.
And maybe just one final line of questioning, because I don't know if everybody has the background on who Sunflower is, but you are a generation and transmission cooperative owned by a number of retail cooperatives, correct?
That's correct.
And those cooperatives are owned by their members, which are actually their retail customers, correct?
That's exactly right. Yes, sir.
So Sunflower represents a little different view than an investor-owned utility in the sense that your ownership and operations and oversight really flow from your customers. Is that right?
That's right. We operate at what we call cost-based rates. So we don't have a return. All of our return is given back to our members, either in the form of rate reductions or patronage capital. So we operate, co-op people like me would tell you we operate much differently than the IOUs. Doesn't mean we don't cross and have similar interests at certain times, but we do have a different structure altogether. Yeah.
And in your view, by being a signatory to this settlement agreement, that is, I guess, the stamp of approval from your entity that you believe a certificate should be granted in this case.
Again, by agreeing to the settlement agreement, by signing the settlement agreement, my position would be that we think that the parameters for a TO operating in Kansas are included in that settlement agreement, and that those give us comfort that if the commission chooses to grant the certificate, we can be comfortable with it. Again, we don't, if we're not advocating one way or another that the line should be built or shouldn't be built, I see us signing it as a way of saying that we think the proper protections are in place for entities such as Sunflower.
I appreciate that. You're a unique party, so I appreciate your perspective. Thank you.
Thank you.
Yes, thank you, Commissioner French. Commissioner Duffy? You're on mute. You're muted.
Since we don't get an opportunity to talk to you a lot, and Commissioner French kind of opened up the door about your involvement in the SPP. Do you feel like you're a valued stakeholder in this process and that your uniqueness is understood and that you are heard?
Are we talking about through the SPP process or
through the SPP process? Yes.
Yeah, we do a lot of work at SPP. We've got a policy group that dedicates pretty much all of their time to work at SPP. We've pushed a lot of initiatives at SPP. Commissioner French has been closely involved in a lot of those. So yeah, I think overall throughout the management team at Sunflower, we feel like SPP works with us well and cooperates with us well when we have issues.
Okay, thank you. I appreciate that.
Thank you, Commissioner.
Mr. Brungard, I'm fairly certain I didn't hear you state that Toyota products were inferior to Mercedes products.
I drive a Chevy.
I was fairly certain I had misheard that. So fair enough. With a Chevy owner, you're on neutral territory. Very good. All right. Okay. Mr. Calcara, redirect if you wish.
I also had some redirect on the Toyota, but in the interest of time, I will waive that. No redirect.
All right, fair enough. We appreciate that too. Mr. Brungart, we appreciate very much your time and your testimony this afternoon. At this time, you are dismissed and you may step down virtually. Thank you, sir.
Thank you, Mr. Chairman.
Okay, next up, Mr. Kimmel, if you would,
Yes.
please call your witness.
Yes. Thank you, Commissioner. Commissioner, we're in the same room as well, so I'm just stepping to the side. I'll be off camera asking the questions.
Fair enough.
Please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I so swear.
Thank you.
Will you please state your name for the record?
Rochelle McGee Smart,
Where do you live?
Anderson County, Kansas.
And what do you do for a living?
My father and I own and operate a family farm. I am the fourth generation to farm and ranch on that property.
Are you the Rochelle McGee Smart that submitted written testimony in this matter on or about on May 17th?
Yes,
Do you have any additions or corrections to that testimony?
I have some additions.
What are those additions?
In regards to the statements made by Becky Walden yesterday that NextEra demand that the landowners sign.
Can I lodge an objection to additional direct testimony being offered outside of the requirement that parties file all direct testimony in written question and answer form according to the procedural schedule?
I'll rule on your objection, Mr. Schulte, but first I want to give this party an opportunity to tell me what it is that you're objecting to. Please continue.
You said that you had some additions to your testimony, Ms. Smart. And those were in regard to Becky Walton's statements yesterday regarding demands for easements.
Yes, the demands that NextEra has, excuse me, let me rephrase that. The demand that they have made on landowners for signing option and access agreements and
Okay. What were those demands?
Mr. Kimmel, if I might interrupt. Let me rule on Mr. Schulte. Are you objecting to this, Mr. Schulte?
Yes.
I would like an opportunity to respond.
Please, hold on. And your basis, Mr. Schulte, is?
This is additional direct, or it could be considered another round of rebuttal testimony, which is not permitted for in the schedule. This is the procedural schedule allowed for pre-filed written testimony on set dates and cross-examination today, but there's no additional recross or I'm sorry, re-rebuttal or direct testimony.
Mr. Kimmel, your response?
Commissioner, first off, this is in response to Ms. Walton's testimony yesterday. Furthermore, this witness is speaking about damages that my clients are only limited to one witness in this case. The other witness, Ms. Smart's father, Darren McGee, was going to speak about these very issues, but was not allowed to testify. So, NextEra has had 5 witnesses here. Evergy's got 3. I think KIC's got 3. My client's testimony is going to last a hot 2 minutes probably here. So I just ask the commission just to allow us to
Under the circumstance, pardon me, I didn't mean to talk over you, Mr. Kimmel. Under the circumstances, I'm going to overrule the objection and allow the testimony. Please continue.
Ms. Smart, you indicated that that NextEra has made demands. How are those demands made?
They were made, or excuse me, they were made on about the option and access agreements multiple times that NextEra has badgered us through phone calls and continually talked to us about signing these agreements, and we have specifically told them that we are not interested.
Okay. You also mentioned that Ms. Walton made threats. What were those threats?
Objection. This is rebuttal testimony that's being elicited with no opportunity for the applicant who has the burden of proof to respond.
I'm going to overrule the objection. You will be provided in short order here, Mr. Schulte, the opportunity to cross. Mr. Kimmel?
We won't be provided an opportunity to present evidence, though, in response to rebuttal testimony, even though we're the applicant with the burden of proof.
We'll entertain that. I'm going to allow the witness to continue.
Again, Ms. Smart, what threats did NextEra make to you?
They have made many threats in regards to the access agreement. They have said that if we did not sign these access agreements voluntarily, that they will be acquiring the land by eminent domain.
When did they tell you that?
Miss Tracy Davis, which is an attorney for for NextEra, said that said this in their public meetings.
Are you referring to the virtual public meetings NextEra held on March 22nd, 2022?
Yes.
Are you aware that NextEra held 2 public meetings on March 22nd, 2022?
I am. I have listened to both of those and the threats Miss Davis has made in both of those.
You mean the threats to take your property by eminent domain?
Yes.
Did they say anything else?
Yes, they have said that they are pushing to get access agreements, and they continually badger us about access agreements. And they have done this to not only myself, but my neighbors as well.
Did they say anything about the location of their proposed route?
But again, I'm again going to object. This is going beyond. First of all, this information is not new information. All of the events that are being referred to occurred prior to when direct testimony was due. This is additional direct testimony or rebuttal testimony that is coming after the applicant with the burden of proof has had an opportunity to testify in response.
I'm going to overrule your objection, Mr. Schulte, and I will note it. I would ask this, if the witness could confine her her statements to matters that she has direct knowledge of, as opposed to opinions of other parties who are not a party to this. Thank you.
I'll ask the question again, Ms. Smart. Did NextEra make any statements in those public meetings regarding the route of their proposed transmission line?
Yes, they said that they were not going to move the siding.
Has NextEra approached you regarding, in addition to easement agreements, access agreements?
Yes. They have.
When did they ask you for access, to sign access agreements?
They've asked us numerous times, and we have specifically told them that we do not want them on our property.
Thank you, Ms. Smart. In regard to the written testimony that you presented on May 17th, if I ask you those same questions today, Would your answers be the same?
Yes.
Commissioner, I move to admit Ms. Smart's May 17th testimony into the record.
Is there objection? Without objection, submitted.
Well, I'm gonna need, I'm sorry.
Mr. Schulte?
May we have a recess before we begin cross-examination, because we're gonna have to respond to testimony that we just heard for the first time and with no time to prepare for cross-examination.
Commissioner, my response to that is we're at a late time in the day here. This is testimony that's directly refuting Ms. Walding's testimony yesterday. That's simply what it is.
Which is exactly the problem with it. It is sur rebuttal testimony out of order regarding the procedural schedule that was set forth, the burden of proof, and the fair procedure and due process rights of the applicant.
It's simply not unfair. Ms. Walding made statements about these various topics.
In response to
Smart has responded.
Gentlemen, please. The commission and these administrative proceedings, it has to have some latitude. This is an unusual circumstance, I'll grant you that. Mr. Kimmel represents the only two landowners that are a party to this proceeding. The sequence of events is such that we've covered a lot of ground during the cross-examination of multiple parties up to this point. And I think the interest of fairness here does weigh in favor of allowing the testimony. Mr. Schulte, you will have the opportunity for cross. If you want to supplement that cross-examination with some further documents after the case, we can take that up. After the docket's closed today, we can take that up.
I would also like just a brief recess too, so that I can prepare some cross-examination on the testimony that we just heard.
That's fair. I'll give you, it's now 4:15. 5 minutes adequate time?
We have 10.
All right, I'll give you until 4:25.
Thank you.
We're in recess until 4:25. Denise Graham?
Yes.
Michelle? Denise? Yeah,
Yes.
Denise. Yes. Can't ever have too many Denises. Denise has, are you ready to go forward?
Yes, I am.
All right, very good. Denise Grau, if you could give us the full screen, please. Thank you. All right, it's 4:26. We are back on the record. Just make certain that I'm correct about the sequence of events. I believe, Mr. Kimmel, you had tendered Ms. McGee Smart for cross-examination. Is that correct?
That's correct. You will remind me, Commissioner, that you did admit the testimony without objection, correct?
We did. That's correct. That's correct. Yes. All right, let's begin, as we have with all other witnesses, with the commission, see if the commissioners have any questions for the witness or would opt to defer. We'll begin first with Commissioner Duffy.
I do not at this time. Thank you.
Thank you. Commissioner French.
Same here. I'll defer. Thank you.
All right. And I will defer as well. Next up would be for cross-examination, NextEra, Mr. Schulte.
Hi, Ms. McGee Smart. My name is Andrew Schulte. I'm representing the applicant, NETE Southwest, in this proceeding. Just a couple of cross-examination questions. Have you ever met Becky Walding?
Not in person. No.
Have you ever met or interacted with her outside of this hearing?
No.
Have you ever interacted with Tracy Davis outside of the March 22nd open houses?
No.
Okay, I have no further questions.
All right, thank you. Evergy. Ms. Caper, any questions for this witness?
No questions, thank you.
Thank you. Southwest Power Pool. Any questions for this witness?
No questions, Your Honor.
Curb, any questions for this witness?
No questions from Curb. Thank you.
The KCC staff, any questions for this witness?
No questions from staff.
All right. Let me double back again and see if the commission has any questions. Commissioner French?
I do not. Thank you.
Commissioner Duffy?
Yes, just one. I believe, Ms. Smart, that you, McGee Smart, I'm sorry, you were, you said you were threatened at a public meeting. Was it you directly, or was it everyone who had gathered?
It was everyone that was present at the meeting.
Okay, thank you. That's all. Thank you, Commissioner Keith.
All right, thank you. I have no questions of you, ma'am. Mr. Kimmel, redirect if you wish.
Just one question, Ms. Smart. Who at NextEra did you interact with?
Neil Harperin.
Thank you. And okay. Did Neil Harperin identify himself as an agent of NextEra?
Not initially.
Did he at some point?
Yes.
When you said not initially, what did you mean?
The initial conversation that was held was we were under the impression that they were the NRCS taking survey and soil samples off of our property. And then when we found out that they were NextEra, we immediately told them not to enter the property. And then they entered the property anyway, and surveyed and took core samples on our property.
Thank you.
Okay.
No further questions.
I'm sorry, but I asked that last answer be stricken from the record. That is outside the scope of the cross-examination, and it's additional evidence, new evidence that we have not had an appropriate chance to respond to.
I'm going to overrule the objection. I will say this, Mr. Schulte, if you wish to file an affidavit, an additional affidavit supplementally, in that event, you may do so. If you do that, I'm going to provide Mr. Kimmel with the opportunity to respond. You may take that under consideration. You need not decide now. If you wish to file this supplementally, you may. I believe we've concluded with this witness.
The last remaining issue, Your Honor, is the admission of the two videos that Ms. Smart referred to in her testimony. We'd like to admit those into evidence. We referred to them yesterday as well in Ms. Walden's cross-examination, and which again, like to ask the commission to admit those videos into evidence. They've been provided to the commission.
Is there any objection?
Excuse me.
Pardon me. Is there any objection? Without objection, no. I'm sorry, Mr. Schulte.
1 minute. Are the videos, are the particular videos that are being offered into evidence can be found at the YouTube email, or sorry, the YouTube addresses that were, or links that were provided by Mr. Kimmel yesterday via email?
I believe those links were the links. If they're not the links, if there was some typographical error, it is the March 22nd, 2002 YouTube videos that are not only available on YouTube, but also on NextEra's website. They're the YouTube videos that Ms. Walding testified to as well and acknowledged was on the website.
Is there objection?
So the concern that we have is that there were, NextEra did post videos of the March 22nd open houses on the website for the project. We have not viewed the entirety of the YouTube links that were provided. And so we're not sure if those match up exactly, or if there's some.
They're URL links that came off your website.
Okay. I mean, subject to that representation.
That was why, unless I mistyped something, then I think that we're all aware of what the videos are. They're the March 22nd, 2002 videos of the public meeting. One was held at 10 o'clock in the morning. Another one started around 7 o'clock in the evening, Central Time.
I understand that. I'm not trying to be.
Mr. Schulte.
I'm not trying to be difficult. I just want to make sure that that's the accurate full record of those meetings. And anybody can post to YouTube, as you know. And so I just wanted to make sure that those were the official videos. That is all that I'm getting at.
And I just don't want there to be a situation in which I mistyped something and another YouTube video came up and you suggest that there was an error in that case. But as long as we're all on the same page, that it's the March 22nd, 2022 videos from 10 o'clock in the morning and roughly 7 o'clock at night, then those videos came from your client's website.
Since they're NextEra
videos, does it make sense if everybody's in agreement to have NextEra provide the 2 videos rather than a YouTube link, and that should satisfy everybody? Or is that?
Yeah, and as long as it includes the entirety of the video that is in, I have a copy, I got a hard copy. I will send it if we can get if I can exchange it with the technical folks, I can upload the copy of both of the YouTube videos to the commission. And I'm happy to do that after talking with your staff about it. But I have them downloaded and I'm happy to
We
share.
have the.
Thank you.
And we have the.
Go ahead, Mr. Schulte. Go ahead.
We do have the official NextEra website link that has both videos on it that we can provide.
Just as long as it includes all the entirety of the video, that's wonderful. Both the presentation and all the answers to the farmers' questions.
Yes, it does.
Thank you.
Okay. We agreed that we are going to admit the NextEra videos from the NextEra website that Mr. Schulte is proffering. Is that agreed, Mr. Kimmel?
Wonderful. Thank you.
All right. It's admitted.
And just so I'm clear, NextEra is filing those links into the docket following today's hearing?
We can certainly make a filing. We can, yeah, sure. If that would be best, we can make a filing with the URLs listed or the URL.
I can provide the hard copy, the electronic copy too. You can download it off of YouTube. So, and I got it.
And if you would, Mr. Schulte, in fairness to Mr. Kimmel, please provide to him directly what it is that we're admitting in the record from your website.
We will send an email to all the parties with the URL, and then we can follow up with a filing.
Very good. Mr. Kimmel, did you conclude your redirect?
I did, Your Honor. All right. Thank you.
Very good. We are, I believe, at an end of your testimony now, Ms. McGee Smart. If you're still there, there you are.
Sorry.
Okay. Thank you very much for participating in these proceedings. We appreciate it very much. And at this time, you are excused and you may step down virtually.
Thank you, Commissioner.
Thank you. All right. At this time, I will turn to Mr. Astraub and ask him to call his witness.
Thank you, Commissioner. This time, Curb calls Josh France to the stand. And I'll let Josh get sworn in by the court reporter.
Please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
Thank you. Tell us your name, spelling your last name for the reporter.
Yeah, my name is Josh France. My last name is spelled Frantz.
Thank you. And what is your occupation and business address?
I'm a senior rate analyst for the Citizens Utility Ratepayer Board, often known as CURB. My business address is 1500 Southwest Arrowhead Road, Topeka, Kansas.
Thank you. Are you the same Josh France that caused to be filed on May 27th, 2022, pre-written cross-answering testimony, and then again, pre-written testimony in support of the non-unanimous settlement agreement on June 7th, 2022 in this docket?
I am, that's correct.
Okay. And have you had a chance to review those documents that was filed with the KCC prior to your appearance here today?
Yes.
Okay. And as you sit here, do you have any changes or corrections to make to those documents?
None that I'm aware of at this time.
Okay. And if I were to ask you the same questions from those documents today, would your answers be the same as it is in those documents?
Yes.
Okay. Chair, at this time, I would move to admit the pre-written filed testimony or cross-answering testimony and testimony in support of the non-unanimous settlement agreement by Josh France. Move to admit to the record.
Is there any objection? Without objection, they're admitted.
Thank you. At this time, I would tender the witness for cross-examination and commissioner questions.
Thank you very much. Good afternoon, Mr. Franz.
Good afternoon.
As has been the practice here with this hearing, we'll turn first to the commission and see if there are any questions for you. I'll turn first to Commissioner Duffy.
I have no questions at this time.
All right, thank you. Commissioner French.
Questions? Thank you.
Thank you. I have no questions either. We'll turn next to Mr. Zakura. Jim, you're on mute.
2 days. Now okay.
You're good to go now.
Okay. The first item is I would like to move admission of KIC 6, which is Citizens Utility Ratepayer Board Information Requests 15 and 16 and NextEra responses. Is there any objection from council?
Let's find out. Is there objection?
No objections from Curb.
Any objection?
Then I would.
Pardon me. Any objection from any other parties? They're admitted.
KI 6 is admitted. Mr. Franz, am I saying your last name correctly, sir?
Yes.
I don't have questions about your testimony, but I would like to speak to you about the settlement agreement if I could. And I would ask you, sir, to place the settlement agreement before you. And I am particularly interested, sir, in paragraph 16 of the settlement agreement. And please tell me when you're ready to proceed, sir.
I have it.
Okay. Are the commissioners ready to proceed as well?
Okay. We're ready.
Okay. Mr. Franz, the settlement agreement there are 6 parties signatory to the settlement agreement. Would that be correct? And let me list them if I can. NETE Southwest, Sunflower Electric Power Corporation, CURB, KCC staff, Evergy, and SPP.
Did you name NETE Southwest?
Yes, I meant to. NETE Southwest. Okay. Do you have that before you, sir?
Yeah, I think that might be 7. I don't know. But sure, yeah, I agree with everyone you've named.
Okay. Now let me direct your attention, sir, to paragraph 16 particularly. But let me give you a little bit more background before we start. Your client was a client that filed a motion for approval of a unanimous settlement agreement by the commission. Is that correct?
We were signatories to the agreement, yes.
And that settlement agreement includes terms and conditions that the settling parties agreed to. Is that also correct?
I would assume that you would not be a signatory if you did not agree with the agreement. So yes.
Okay. And what you and the other signatory parties to the agreement are asking the commission to do is to approve the settlement agreement in total. Is that correct?
Yes.
Now, if I could direct your attention to paragraph 16, it says the provisions in this agreement have resulted from negotiations among the settling parties and are interdependent. In the event the commission does not approve and adopt the terms in this agreement in total, it shall be voidable by any settling party. Do you see that?
Yes. You've read that correctly.
Okay, let me ask a couple of questions about that. What do you define the term voidable to mean?
Objection, that calls for a legal conclusion.
I don't think it was asking for a legal conclusion. I asked him what he thought voidable means. The fact that it's in a contract doesn't make it a legal opinion.
If I could respond, I think this is being proffered by what kind of conditions or situations would have to occur before somebody could void a legally binding document. I think that calls for a legal conclusion. That's better reserved for briefing.
Mr. Zakura, could you rephrase the question?
Certainly. What is your understanding of what the word voidable means in paragraph 16?
That still calls for a legal conclusion interpreting the legal ramifications for the document.
Let me ask you, do you want to rule on that, or would you like me to proceed?
No, I
can
sustain the
read.
objection.
Okay.
I'm sorry, I did not hear
hear
the chairman's comment.
Pardon me, all parties. Denise Haas, please.
Chairman, I didn't hear your comment after Mr. Zakura asked if you would like to rule.
I think what I said was I had already ruled and I had sustained the objection.
Thank you.
Sure.
Mr. Franz, let me pose a question a different way. Looking at the dictionary, it says a voidable contract is a formal agreement between two parties or more that may be rendered unenforceable by any number of legal reasons. Would you agree that that's your understanding of what voidable means?
I don't know what when you say dictionary, I don't know what source you're using. There's certainly a lot of dictionaries out there, but subject to check. I mean, that sounds like a definition that you would find.
We're making progress. Okay. Now let me ask you about that term. It says, in the event that the commission does not approve and adopt the terms of this agreement in total, it should be voidable by any settling party. Now, when it's voidable by any settling party, what does that mean? Is this agreement of no further import, or are we done with this agreement if any one of the six parties is not agreeable to any condition that the commission puts on it?
Yeah, I don't know. It's not necessarily set out here in my experience. I've worked for both the KCC and for CURB. In my experience, it is possible to find an amended settlement agreement. So it is possible that the parties could maybe perhaps go back to the drawing board. I know there is a timer on the docket. There's the docket has to be resolved within so many days. And so I don't know what that does to that time limit on the docket itself. If the commission were to reject the settlement agreement, I suppose, yeah, I don't exactly know what would happen. I suppose there would be an opportunity to petition for reconsideration, and then I don't know what happens after that point. And again, I'm not an attorney. I need to make that clear.
Let me continue. This is an important part of the settlement agreement. I think we should understand it as best we can. It goes on and says, if this agreement is terminated or voided, no settling party shall be bound, prejudiced, or in any way affected by any of the agreements or provisions to this agreement. Do you see that, sir?
I do. You read that correctly.
So the question I have for you, of your understanding of this agreement, and I'm not asking for a legal opinion, if the commission were to add additional conditions, or if the commission were to delete conditions, and that was unsatisfactory to any party, is the settlement agreement at an end?
I would say, I mean, again, I don't want to give a legal opinion, but I'll answer your question. It's to the best of my ability.
I'm not asking for.
Yeah. So I think that the agreement, this agreement, would probably be ended, but it would be possible to reach a new agreement or an amended agreement or something along those lines. I think that could be a possibility. I also, I mean, the commission can, my understanding is the commission can order whatever it wants. And so if the commission orders something different, at that point, I don't know what happens. Like I said, I'm sure there's an opportunity for a petition for reconsideration. And then beyond that, I really don't know.
Well, I'm really exploring this, sir, for both to understand the settlement agreement, but also to talk in terms of practicalities. We've been here 2 days now hearing testimony. And if the commission feels like, if the commission determines that this settlement agreement is not appropriate and it's rejected by any of the parties, it seems to me we've wasted 2 days, because the only thing before the commission is the approval or non-approval of a settlement agreement. Would that be your understanding?
Objection. That calls for speculation and relevance regarding a waste of time on these last 2 days.
Well, may I respond to that?
Yes.
The testimony in this proceeding is, it's a proceeding in support or in opposition of a settlement agreement. It is not a proceeding wherein the commission is entertaining whether or not to grant a certificate of need. It is not that at all. That is not the manner in which it's presented to the commission. So it seems to me that we're in a position where the commission, if I may say, is put in a situation where they either approve this, they approve it with conditions if they feel it's appropriate to do it, additional conditions. And if any one of the 6 parties that signed this determines that those aren't conditions they can live with, then this agreement's over.
I object to the legal argument, and I believe that the chair already sustained an objection that this line of questioning calls for a legal conclusion. So this is not productive.
Sustained.
Let me take just a moment more.
Sure.
Because this seems to be an important point. Okay. And I'm not asking you for a legal opinion, Mr. Franz, excuse me. In the event that the commission issues an order and CURB finds it inconsistent with its signatory to the settlement agreement, do you believe that CURB could simply terminate the agreement?
Objection calls for speculation and legal conclusions.
Overruled. Linda's may
I'm
answer
sorry.
within the scope of his knowledge.
I'm gonna have to ask, I really didn't hear the last part of what you asked. I didn't hear it.
May I please ask, I'm doing my best to push forward quickly. May I ask Denise, if I may say that, Ms. Hawes, to read the question out, Pat?
Yes, just a moment, please. Question. Let me take just a moment more because this seems to be an important point. I'm not asking you for a legal opinion, Mr. Franz. In the event that the commission issues an order and CURB finds it inconsistent with its signatory to the settlement agreement, do you believe that CURB could simply terminate the agreement?
I believe that would be an option. My understanding or my interpretation is that we would not be bound to terminate the agreement. I don't know. I mean, actually, I might change my answer. I think that at that point, I think it might require an amended agreement if there were to be conditions added. You know, again, not a lawyer. I'm answering to the best of my ability as I was instructed by the chair.
Final question. I'm going to go by your changed answer too. Final question.
That's fine. Final answer for now.
That your understanding of this agreement is that what the signatories to the settlement agreement are agreeing to is they're asking the commission to approve this agreement in total with no changes. That would be your understanding?
Yeah, that is my understanding. And I just will say, I mean, this seems, in my understanding, this is pretty boilerplate language that is in nearly every settlement that comes before the commission. So I mean, I don't want this to come across as like some unique. I don't think this is any unique aspect of this settlement that's not in any other settlement.
Would you agree that this is an important case before the commission involving many parties and a lot of money, and that the terms of the settlement and what the commission is asked to do are important considerations?
Yes, I would agree with that.
I have no further questions. Thank you.
Thank you, Mr. Sakara. Mr. Kimmel, any questions for this witness?
No, Commissioner.
Thank you. We'll turn back to the commission, see if they have any questions. Commissioner Duffy?
I do not. Thank you.
Thank you. Commissioner French?
One question, a line of questioning, just to clarify something here, and I'm going to apologize if this goes into asking for a legal conclusion, and if you're not comfortable answering, or if you think you need counsel's assistance to answer, then we'll just stop. That provision, we've mentioned it several times, where I think it's sort of an interdependency provision where the parties agree that's a complete package, and the agreement or the contract is voidable if it's changed or modified. That provision does say that that's an agreement among the parties, correct? It's a provision for the parties to enforce it against each other, correct?
Yeah, that's correct. I mean, the commission is not a signatory.
So the commission can make whatever decision it wants in this case. It can approve the settlement, it can decline to approve the settlement, it can modify the settlement, and that becomes its decision, correct?
Yeah, I mean, in my 6-7 years of experience between CURB and KCC, I mean, that's always been my understanding.
And at that point, maybe this is a legal conclusion, but isn't it irrelevant whether the parties can enforce that settlement against each other once we have a commission decision?
Yeah, I mean, my understanding is a settlement agreement without an order is pointless. It doesn't get you anywhere.
All right, that's all I had.
All right. Mr. Astrap, did you have redirect?
Just briefly, first off, hats off to Commissioner French for taking the wind out of my sails for redirect, because that's where I was going to go. But I'll try to put a finer point on it. Mr. France, in your experience working at the KCC, both for staff and both for CURB, have you either been part of evaluation in a docket, or have you seen dockets where the commission orders different terms or conditions on an application that may be different or in addition to what another set of parties or a settlement agreement has, and the docket was still resolved?
Yeah, I believe so. I mean, I don't have any specific dockets in my mind, but I mean, I think I've seen, usually it's something minor. Usually it's maybe some reporting requirements or something along those lines. But I believe I have seen it where, you know, it's very minor adjustments to the settlement were made and the settlement goes forward.
Okay. And to kind of go springboard off a finer point that Commissioner French was making regarding the enforceability of the settlement agreement itself, if there were changes by the commission to parts of the settlement agreement or just generally about the commission's order, would parties have an opportunity to move forward with certain, upon an agreement, would they be able to move forward with certain provisions of the settlement agreement in addition to whatever additions the commission makes, or would the parties be able to agree to move forward based on what the commission says? Are those options available to parties?
Yeah, I mean, you know, in scenarios like this, again, not a lawyer, but what I have seen, if the order is substantially different from the settlement agreement, I've seen scenarios where the applicant may pull the application and they may retry. They may submit a new application based on, you know, the advisement that they were given from the commission's order. I mean, that's a scenario that I've seen play out. You know, as I mentioned, you know, there's the petition for reconsideration process. I've seen that several times, or petition for clarification. That's another option that is maybe not as severe as a reconsideration, but yeah, there are options.
Thank you. No further questions.
Thank you. I believe that concludes your testimony, Mr. Franz. Thank you for your appearance here. We appreciate that. You're excused and you may virtually step down.
Thank you all.
Thank you, commissioners.
All right. Let me ask our court reporter. We have 3 more witnesses ahead of us here. How are you doing?
I'm fine, thank you.
All right. Would you like to take a break?
I'm fine to continue, thank you.
Okay. Mr. Jevons, I'll turn to you. Would you please call your first witness?
Oh, Josh isn't muted.
Mr. Franz, please mute.
Thank you, Commissioner. I am ready to begin presenting witnesses. At this time, I'd like to call staff's witness, Adam Gatewood.
Please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
Good afternoon, Mr. Gatewood. Would you please state your full name and business address for the record?
Good evening. My name's Adam Gatewood. My business address is 1500 Arrowhead Drive, Topeka, Kansas. I'm employed by the KCC as Senior Managing Financial Analyst in the Utilities Division.
Are you the same Adam Gatewood who Cosby filed in the docket staff's report and recommendation on May 17th, 2022?
Yes, I am.
If you were asked the same questions today as you were in your report and recommendation, would your answers be the same?
Yes, they would.
Do you have any corrections that you need to make to staff's report and recommendation?
Yes, as the first witness, I'll go ahead and make the corrections for staff members. First one, in the executive summary heading, second paragraph of the executive summary, on the very last line, there's a reference to Southeast Missouri, and that should be changed to Southwest Missouri. Then I have 2 exhibits. I'm looking at the PDF version, so I hope these line up similarly with everybody else's. Let's see. And I'm looking at the confidential version on page 28, where it says 7 project recommendations. That should contain a heading at the top that says Exhibit 1. And for some reason, it's 1 page different on the public version. Should be page 29 on the public version. And the only other change we have is to Exhibit 2, which should be page 31 of the PDF. It says LMH1, that should be LMH2. Exhibit 2, I'm sorry. That should be Exhibit 2. And those are the corrections we have from the first staff's report and recommendation.
Thank you. I now move to admit staff's report and recommendation into the record.
Is there objection? Without objection, it's admitted.
Thank you. I tender the witness for cross-examination.
Very well. Good afternoon, or as you characterized it, Adam, good evening.
Good evening, Commissioner Keen.
Let's turn to the commission first to see if we have any questions or if they choose to defer. I'll begin first with Commissioner French.
No questions, thank you.
Thank you. Commissioner Duffy.
No questions, thank you.
Thank you. I'll defer my questions as well, Adam. We'll turn next to Mr. Zakura, please.
Mr. Gatewood, good evening. Usually you don't see you except in rate cases, so it's nice to see you, but I have no questions for you. And I wish you the best. Thank you.
Very well. Yes, no. Yes, sir, I'm sorry. I lost you there. Mr. Kimmel, any questions for this witness?
No, Commissioner. Thank you.
Thank you. Let's turn back and give the commission a second chance if they wish for questions for Mr. Gatewood. Commissioner Duffy?
No, I don't. Thank you.
Thank you. Commissioner French?
I still have no questions, but like Mr. Zakura, I do want to wish Adam well.
Thank you, Commissioner French.
Well, that makes at least three of us, Adam. I believe that that concludes your testimony. I appreciate very much the matters that you have spread on the record. I think it's very helpful. We appreciate your willingness to be here this afternoon for cross-examination. At this time, you are dismissed and you may step down virtually. Thank you.
Thank you.
Mr. Jevons, would you please call your next witness?
At this time, I'd like to call staff witness Leo Hanos.
Please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
Good evening, Mr. Hanos.
Good evening.
Would you please state your full name and business address for the record?
My name is Leo M. Hanos. My business address is 1500 Southwest Arrowhead Road, Topeka, Kansas.
Please state your title and position at the commission.
I'm the chief engineer for the Utilities Division of the Kansas Corporation Commission.
Are you the same Leo Hanos who caused to be filed in the docket staff's report and recommendation on May 17th, 2022?
Yes, I am.
If you were asked the same questions today as in your report and recommendation, would your answers be the same?
It would.
I tender the witness for cross-examination.
Very well. Good afternoon, Mr. Hanos.
Good afternoon.
Let's turn to the commission first to see if we have any questions for you. I'll turn first to Commissioner Duffy.
No, I do not. Thank you.
Thank you. Commissioner French?
No, I'll defer.
Thank you, Commissioner French. I will defer as well. Mr. Zakura.
Good evening, Mr. Hanos. I generally only see you in terms of either a pipeline crisis or an electric crisis. So it's great to see you today. Having said that, I have no questions for you, but thank you for your great work, and we're relatively to the same vintage, so I'm happy to see you. Thank you.
Thank you.
Mr. Kimmel, any questions for this witness?
No, Commissioner.
Leo, I have a question I will direct at you. If we could take a look at Mr. Harrison's testimony, page 19.
Give me a second, please.
Certainly. Tell me when you're there.
It was page 19, sir.
Yes, page 19, please.
Okay, I'm there, sir.
All right. Specifically, I'm looking at lines 13 through 20. Again, this is Mr. Harrison's direct testimony on behalf of Evergy. And it has to do with affiliate transaction costs. And I'd like to lean on your experience as an engineer and as an earth scientist, and your experience with the commission, and have your take on this. I'll read into the record, beginning on line 13. The question is, how does the affiliates of NETE Southwest plan to charge NETE Southwest? That's the question. The answer is, beginning on line 14, per the response to Evergy-7, quotation marks, affiliates are billed on a FDC basis, which includes all direct and indirect costs, including cost of capital and overheads, or at the FMP, whichever is higher, end quotation marks. I continue on line 16. FDC stands for fully distributed costs, and FMP stands for fair market price. Continuing with the next question that was posed on line 17 to Mr. Harrison, is this approach consistent with commission policy? Beginning on line 18 through line 20, Mr. Harrison's response is this: affiliates should charge the lower of cost or market when providing a service to a utility serving Kansas in order to avoid customers paying more than market rates and to avoid affiliates from earning additional returns. I guess my first question to you, Mr. Hanos, is, have I accurately reflected the contents of what I've quoted from page 19 of Mr. Harrison's testimony?
Yes, you have, Commissioner, but I would, although I appreciate your confidence in my abilities, I think this question is better suited for Justin when you're dealing with asymmetric pricing in contracts.
All right. Well, I'm sure he's going to appreciate that handoff. I will respect your wishes. I will defer for this question for him. As a result, I have no questions for you. I'm trying to remember now. Have we had any questions of you here? I don't think we have. I believe your testimony is at an end. Again, Mr. Hennis, we appreciate your testimony on the record. We appreciate your appearance here this afternoon, and I appreciate as well your service to the commission. You're now excused, and you may step down virtually. Thank you.
Thank you.
Mr. Jevons, would you call your next witness?
Yes. At this time, I'd like to call staff witness Justin T. Grady.
Hello.
Please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good evening, Mr. Grady.
Good evening.
Would you please state your full name and business address for the record?
Yeah, my full name is Justin T. Grady, and my business address is 1500 Southwest Arrowhead Road, Topeka, Kansas 66604.
Would you please state your title and position at the commission?
I am the Chief of Revenue Requirements, Cost of Service, and Finance, and I work in the Utilities Division.
The same Justin Grady who caused to be filed in the docket staff's report and recommendation on May 17th, 2022, and testimony in support of settlement agreement on June 7th, 2022.
Yes, I am.
If you were asked the same questions today as in your report and recommendation and filed testimony, would your answers be the same?
Yes, they would.
I now move to admit the testimony in support of the settlement agreement into the record.
Thank you. Is there any objection? Without objection, it's admitted.
Thank you. I tender the witness for cross-examination.
All right, thank you. Good afternoon, Justin.
Good evening.
Good evening. I'll accept your preference. It is after 5 after all. Let's turn to the commission first for any questions they might have. I'll turn first to Commissioner French.
I'll have a couple questions, but I'm going to defer till following cross-examination. Thank you.
Thank you. Commissioner Duffy.
I'll defer as well. Thank you.
All right, thank you. Justin, I do have some questions for you. And let's begin with a question I asked of Mr. Haynos. Were you present at the hearing when I most recently asked a question of Mr. Haynos pertaining to affiliate transaction costs?
I was, Commissioner.
And just to refresh for the record, I was referring to page 19 of Mr. Harrison's direct testimony, specifically lines 13 through 20.
Sorry.
I'm sorry. Yes, 13 through 20.
Yeah, I'm just going to get a paper copy of it real quick.
Certainly. Please tell me when you're there.
Thank you, Leo. Okay, I'm here. Sorry.
My first question for you, Justin, is this in connection with this matter. Does the settlement agreement address or deal with this specific issue?
So yes, it does. Find the settlement agreement, the term itself. Just so it's clear for the record, the specific term that addresses the affiliate transaction asymmetric pricing rule is contained on the top of page 14. It's term M 2 little I or 2 whatever, and it just states that NETE Southwest agrees to implement asymmetrical pricing in its transactions with affiliates, as discussed in the rebuttal testimony of Amanda Finnis. And so I think, if I recall, I think Mr. Harrison addressed this issue that he stated that, you know, his concerns about affiliate transactions were resolved to his satisfaction in the settlement agreement. And I think this is a good example of, you know, a lot of the information exchange and a lot of the meeting of the minds that occurred amongst the parties as the docket continued, and there was additional information and understanding provided, because I think that earlier data request response was a little unclear by NextEra, but it was clarified in Ms. Finnis's rebuttal testimony. And what NextEra clarified was that what she meant to say was, if NETE Southwest is buying goods from affiliates, then they will pay the lower of cost or market, fully distributed cost or fair market value. And if they are selling goods or services to affiliates, then they will charge those affiliates at the higher of cost or market. And that is the gold standard in affiliate transactions. I mean, we apply it in Kansas Universal Service Fund audits because the FCC requires that. affiliate transaction standard, and most fully rate regulated utilities will apply that standard just because it's good regulatory practice. But that's actually that rule actually exceeds our rate making authority with regard to the specific statutory standards. Anyway, we try to apply that and require it, but that's actually a greater standard than our quote unquote policy at the commission. So it's a very positive development in the settlement agreement that they've agreed to do.
Yeah, I appreciate the granular nature of your response as well. I appreciate that detail. While we're on the settlement agreement, let's take a look at page 13 together, if we might.
Okay.
On that page, I'm at subpart M, the very last paragraph on the page. And what this paragraph does, if I can summarize it very succinctly, easily, is that it indicates that the settling parties have agreed to certain waiver of statutes, provisions, and requirements. And I know the staff, of course, is a part of this settlement agreement. The staff has signed on as a settling party, has it not?
Yes.
Here's my question in connection with this provision. Why should there be any waiver of any statutes by the commission in this docket or in connection with the requested CCN? I'll even embellish that question a little bit more with the reason behind why I'm asking it. I mean, don't these statutes for which this waiver is being sought, they speak for themselves? And even more significantly, as it's been pointed out by some prior witnesses here, in several respects, some of these statutes speak to more than just the restrictions on commission action incidental to rates. It goes far beyond that to service issues. Pardon my expansive question there, but if you would respond.
Yeah, no problem at all. So I think that the resolution that's provided in this settlement agreement is actually not a waiver of these statutes, right? So in our report recommendation, we said, look, the statutes either apply or they don't. And I actually view this provision of this settlement agreement very similar to what our position was in our filed report. So, and allow me to explain why I believe that. It says the settling parties agree that FERC preempts the KCC's rate-making authority as set forth in those statutes, and that's key, right? It's all about rates, and it's only about rates. And I think Mr. Ives mentioned it the other day, and it's absolutely accurate that there are several commission orders, previous transmission only, FERC rate-making regulated orders that that basically say the same thing, which is that everybody recognizes that the Federal Power Act provides rate-making jurisdiction to FERC pertaining to interstate transmission. And that's all that this really says. I almost view this provision as not an agree to disagree, but stating the obvious. It was valued by NETE Southwest, I think, for clarity and certainty that all of the key parties in the room agree and understand and recognize that the KCC does not have rate-making authority over NETE Southwest in this line. That's really all I see that provision indicating. But also importantly, it says, unless NETE Southwest acts outside of the conduct covered by FERC jurisdiction, right? And at which time the KCC will decide the applicability of these statutes. So this statute or this language also exactly mirrors the previous Grain Belt Express line, in which is almost it's very similar with regard to rate making. But for efficient, sufficient service or safety, reliability, we still believe that the commission has the appropriate oversight and authority. It's just rate making.
So essentially, it was the means to the end, which was to accommodate the wishes of some parties who were settling parties so that there could be a settlement agreement. Is that fair?
Yeah, I don't want to, it's always a little bit dicey to actually get into the actual, of course, the give and take of the negotiations, but this term was actually recommended by us. I mean, it was obvious that NETE Southwest wanted some sort of an indication that to the world, to the markets, to SPP, that we are not going to be treated any differently than any other transmission only utility that does not have retail customers in the state of Kansas, that's not rate regulated in the state of Kansas. And they were seeking an affirmation and clarification of that. And you read the testimony, as I know you have, there are a lot of different opinions about which aspects of these statutes should apply or should not apply. And this was a perfect middle ground because it was the exact same language that the commission had previously approved. And all it says is FERC sets the rates for interstate transmission facilities. That's why we landed where we did.
All right. I appreciate your response. I'm going to give my personal opinion. I think it's superfluous, notwithstanding the fact that it has appeared in previous dockets. I mean, we could have just as easily restated that a certain provision of the United States Constitution provides for freedom of contract. I mean, we could have done that, and we could have provided for any other citations we wanted. But that's it's just I understand what you're saying. I appreciate the candor and directness of your answer as well. I've read your testimony also in support of the settlement agreement, and it's that document that I really want to focus on a bit more at this point, if I can. Let me ask you this. If this facility is constructed, if this docket is approved and the subsequent siting docket were approved, will this line be used to divert power from the Wolf Creek Nuclear Facility away from ratepayers in eastern Kansas and south central Kansas who have and are paying for the Wolf Creek facility through their rates?
No, absolutely not.
Please explain.
Yeah, thank you. Thank you for the opportunity to do that. So this transmission line originates at a substation, which I almost view it as almost coincidental that it happens to be called the Wolf Creek substation. Granted, it exists right next to the Wolf Creek nuclear power generating station. And because of history and because of the fact that the nuclear power station is there are 3 other 345 kV lines that are all electrically interconnected right there. And so it's a natural gathering place for congestion, and it makes sense for this line to interconnect at that substation. But it is completely inaccurate to say that the purpose of this line is to, quote, move Wolf Creek power or power generated by Wolf Creek Nuclear Operating Station somewhere else. That's just not, that represents a concept of transmission that is not accurate. And it's not the delivery, it's not one-way delivery. This is AC, this is an AC power line. I think Ms. Walding appropriately captured it when she said that these are interconnection points. It's all electrically connected. It's not a delivery point, right? So the other thing I think that's so critically important is this substation, the AECI substation, is, and I haven't done the exact calculations, but we were looking at a map earlier. It's 75 to 100 miles inside of SPP's service territory. It's not moving any power to MISO, or granted, it is a half mile on the other side of the Missouri border. It's a half mile on the other side of the Missouri border, and it terminates at a AECI substation. Now, AECI is not a member of SPP, which means that that substation that they own that is otherwise in SPP service territory, it's like it terminates at an island within SPP. But if you look at the SPP map, any of the maps that are in this docket, there's 75 or 100 miles further east that's all SPP service territory. So there's no question that, you know, the purpose of this line is all of the reliability and congestion relief issues that are in the ITP, and that are identified in my testimony. But it's moving congestion further east within the SPP footprint. It's not to ship wind power to MISO or to Missouri or to move nuclear power out of the state. It's just not that. And it's really, really unfortunate that the public narrative has been spun in that fashion, or it exists in that fashion, that there's just a giant misunderstanding that's occurring in the public discourse and with regard to the purpose of this line. So I really appreciate the opportunity to talk about it.
Thank you for your response. Let me go one step further then. Please identify for us what you believe are the primary benefits to Kansas ratepayers to be derived from the construction and operation of the Wolf Creek to Blackberry transmission line.
So what was, and I touched on this some in my testimony, but what was so convincing for me, really, regarding the benefits of the line were, you know, one, those congestion relief maps that were in the STP, or I'm sorry, the ITP 2019 overview. Those are really pretty telling maps when you look at, you know, the projected congestion relief that is expected in Southeast Kansas. And then also the, you know, the benefit cost ratios of the project as a whole for both Kansas as a whole, as well as, you know, individual Kansas zones, zone by zone. It's obvious that there's benefits associated with the ITP project portfolio, as well as with this line. And the reason for that is it was touched on by Mr. Ives, it was touched on by Miss Walding. But if you look at the individual list of projects in the ITP, and you look at where those projects exist and the individual adjusted production cost benefits that come from those projects, and then you don't have to get a calculator out and do the math or do the calculation in order to make an informed professional judgment that it is clearly this line that is creating those adjusted production cost benefits and those benefits that are existing in Kansas. It's just, there just aren't other projects that are large enough and substantive enough to do that. You know, I thought Commissioner French's questions earlier were really, really good. I can't remember actually, maybe it was of Darren Ives that, you know, if if the portfolio of 44 projects is beneficial to the state of Kansas, and those are all going to be built, and the one project we don't build is the one that produces the vast majority of adjusted production cost benefits in the state, then is the state going to be better off or worse off if we don't build the line? I'm absolutely convinced that the line creates benefits for the state as a whole, and particularly for Evergy and Evergy customers and customers in Southeast Kansas. And you can look at it, right? You can look at it in the ITP. I have all the notes here and the specific pages, but just look at section 8 of the ITP. And you can just look at it by zone, by zone, by zone, or state by state. And Kansas benefits from this line.
Chair Keen, you're muted.
Thank you very much. Sorry about that. Justin, are the maps to which you just made a reference, are these the same maps that appear on page 13 of your testimony in support of the non-unanimous settlement agreement?
Yes.
Are those the maps? Let me ask you one question about those maps, and then that'll conclude my questions of you at this time. These are interesting maps. We have the before on the left and the after on the right, if I'm looking at that correctly. Is that right?
Yes.
It's kind of an anomalous situation that I'd like to have you explain, if you could, as I see it. If we take Southeast Kansas, you can see that, at least according to this portrayal, the average LMP prices without the projects and those with the projects, there's a decided lowering of prices in Southeast Kansas as we move from the before to the after. However, an interesting anomaly here to me is that if you take kind of the much of the balance of the state to the west, except for the far west, witnesses basically what appears to be a bit higher rate in the after than in the before. Did I sufficiently explain basically the essence of what I'm trying to ask by a question?
You did.
Could you explain that for us and help me out in trying to figure out the net effect of what this all means?
Yeah, absolutely. So, it's I think Mr. Zakura in some of his comments has alluded to the fact that if you look at those zone by zone impacts in section 8 of the ITP that I referred to, then it's accurate to say that you see higher adjusted production costs in certain of the zones in Western Kansas. So the Sunflower Zone and the Mid-Kansas Electric Company Zone and the Midwest Zone, they go up. But they don't go up in total as much as energy prices go down in Eastern Kansas for the Evergy Kansas Central customers and the KCPL customers in Northeast Kansas. So there's also congestion you'll notice in that map that goes away in Northeast Kansas, right? That looks like between Topeka and Kansas City, actually. And there was some discussion about it earlier, but it's levelizing is an okay word, but I thought that Kelsey, if I'm remembering it correctly, the SPP witness, somebody said it's about optimizing, and the thing is, it's true that there will be all other things being equal, I would say slight LMP increases as you allow that power that is currently trapped in western Kansas to get over into eastern Kansas. But you know, really, really low LMPs in western Kansas, and which is what's represented there, right, by that really dark blue shade. That's not a good thing, right? I mean, it's just not. You know, negative prices are a real problem. Mr. Brungart referred to it. You know, if Sunflower and Midwest didn't own any generation assets at all, and they bought all of their power from the integrated marketplace, then I would agree with you that they would be harmed by this. But that's not accurate. They own a large coal-fired generating plant. They want to run that plant, and there are hours of the day that they have to sell that plant at a loss when power prices are too low. And you know, there was another really good example when the conversation came up with Mr. Brungart of an economic project that was required from this ITP out in western Kansas. And you know, it's a great realization of the fact that an overabundance of really, really low cost power might look and sound great until it's so much overabundance that it actually causes your transmission costs to go up, which is what's happening out there in the western Kansas zones, right? If really low power prices and an overabundance of congestion on the system was a really beneficial thing to western Kansas, we wouldn't have to have the C2 waiver process that we have, right? So it's, I don't know, I know that's kind of a long-winded, complicated explanation, but it's removing inefficiency and removing congestion and spreading out that low-cost power to as much of the state as possible. It is a beneficial thing. And that's what you see. That's what you see in the benefit cost ratios of the project. I mean, that's what you see in the benefit cost ratios of the whole ITP, but it's not. There is adjusted production costs specific to this line. There are adjusted production cost benefits specific to this line calculated in the ITP. And that's what's going on.
Thank you very much for your response, Justin. For the record, I prefer long-winded and detailed, so you fit the bill there. I mean that in the most positive sense, because I think you added levels of detail and granularity there that gives some perspective, and I'm grateful for that. That concludes my questions for the time being. Let me turn next to Mr. Zakura. Jim, please.
Nice to see you, Mr. Grady.
Good to see you as well.
I have no questions for you this evening. Thank you, sir.
All right. Mr. Kimmel, are you still with us?
I am.
Do you have any questions for this witness?
I do not.
All right, thank you. Let me turn to my fellow commissioners, see what questions they might have. Commissioner Duffy, please.
And thank you, Chair Keen, for asking the question about the heat maps. That was a question I had, and I appreciated the explanation. Justin, so we sat through Dr. Maycombe's explanation of perhaps the SPP of the state of Kansas and the wind that we generate. being taken advantage of by the SPP to our detriment. Do you, and you've been with the KCC for a long time, since really the program of 20% by 2020 that was put into place by Governor Sebelius that kind of started a lot of this. But do you believe at this point that to the detriment of Kansas ratepayers, we're being used by the SPP and taken advantage of?
Well, no, not in those words. I certainly don't. One thing I think that Mr. Macom's testimony misses is he's pointing to Evergy Kansas Central's transmission costs and their transmission investments. But a lot of those transmission investments are outside of the SPP planning process and are conducted under Evergy's internal planning. And there's, they've replaced, I think, all of now their 69 kV aging transmission infrastructure. And there's we've had obviously a lot of discussion about their transmission investment and what they're doing through their sustainability transformation plan, right? So the first problem, I think, is that he starts off that argument by saying, well, just look at how high your Evergy's transmission costs are. Something truly must be wrong. Well, he's not looking at the fuel and purchase power savings that have resulted from a lot of that transmission spend, at least the SPP driven transmission spend. But then, also it's just that there's other drivers there that are affecting that transmission spend. I really enjoyed Mr. Macom's testimony, but both the written version of it and also some of his questions too, or his responses to the testimony. A lot of his bigger picture ideas, I think, are good ideas, and I don't think a lot of us disagree with a lot of that. I mean, it's clearly this country, if we're going to continue to rely on more and more carbon-free energy, then it's obviously going to come from the central part of the United States, and we obviously need to figure out a way to get it, to areas of the country that need it. The problem is that's been a problem for a long time, and who knows when there's going to become a solution for that. What I would argue is it's not like the KCC hasn't done anything to assist in that regard. We have certificated the Greenbelt entity, and we've been a champion of that project. So, unfortunately, I think it just takes a while to change sometimes the whole system. Where I disagree so significantly with him is that, one, he continually restated the argument that I totally disagree with, which is that there's no evidence that there's a Kansas specific benefit to this project. I just disagree with that. There's reliability benefits. There's economic benefits. You can clearly see that by looking at the benefit cost ratios of the projects and where the projects are occurring. The benefit cost ratios of the portfolio and where the projects are occurring that are creating those benefits. But the biggest concern I have with his overarching testimony is he seems to bring up all these arguments that the grand system is broken or needs to be improved. Again, a lot of aspirational goals that I think a lot of us agree with. And then seems to jump to the conclusion that since we need to fix these big giant problems, we shouldn't fix the problem at hand right in front of us that actually provides benefits to the state. And that's where we, I think, have our biggest disagreement.
Okay. I appreciate that. I cannot imagine a world without us being in an RTO. I mean, well, enough said there. That's all I have, Chair Keenan, and thank you, Justin.
Thank you.
Thank you, Commissioner Duffy. Commissioner French.
Thank you. I'll just have a couple questions. Let me find my place real quick. Well, if I could just summarize, Mr. Grady, I think you gave an unequivocal answer to this before, but it's really important to me. And so I want a brief unequivocal answer again. There was a direct statement in a pleading filed in this case, and then there's been media attention or portrayal that this line is being built for the benefit of customers in another region. And if that is true, to me, that is outrageous, it's scandalous. It's a big problem. I mean, if that were true, it is newsworthy. And so I guess I just want you to unequivocally state, have you seen any evidence in this proceeding? Has any analysis crossed your desk that would suggest that the reason this project was planned and a notice to construct was issued was to serve or benefit customers outside of SPP?
Yeah, so no, I appreciate the opportunity to address it again. No, I haven't seen anything that would indicate that the purpose of this line is to benefit anyone other than the region of SPP. Now, is it true to say that all of the benefits of this line are only going to be shared by Kansans? No, that's not true. Because we aren't in this alone, right? We are a member of an RTO, and there are 13 other states, but it's just so critically important. It was eye-opening to me. Honestly, it wasn't until late in this process that I realized this line was only a mile over the border of Kansas. And I don't know why I didn't realize that. I think it's because it was a 94-mile line and 85 miles of it is in Kansas, but that 9 miles traverses right on the other side of the border, and it terminates a half mile over the border. And so it's like 99.5% in Kansas. And so it's just not accurate, to say that. I just think I just don't think there's any evidence, even Mr. Markham sort of hinted around like, well, it's a project masquerading as an export line. I just haven't seen anything to suggest that. And I don't think there's any evidence of that. I think you brought it up earlier. It was in my direct testimony, but there was an attempt to try to do this as an interregional project, right? And there's a yearly effort of that. As you know, it's been an interest of this commission's and others for a while. And this line was studied with MISO, and MISO said, no way, 97% of the benefits of that line go to SPP. No thank you, that doesn't qualify. So I feel like that's the most unequivocal evidence that I've seen, frankly, that this is clearly an intra-regional SPP-oriented, SPP-benefited line. So hopefully that helps.
Yeah, the final question I have is, you made me think of it when you were comparing, I guess, Evergy, Kansas Central only transmission to SPP plan transmission. Would it be fair to say that you and I have had a lot of conversations over the last several years when I was both inside and outside of the KCC about my and your concerns about escalating transmission cost?
Absolutely.
And I think, you know, it's probably been well documented through the STP proceeding that a lot of our concern just has to do with the visibility of why certain transmission, particularly local transmission, is being built on the pace that it's being built. I guess pace and scale of more of the local transmission. Is that fair to say?
Yeah, absolutely. There's a lot of work that needs to be done. I mean, it's obvious that they have a lot of aging equipment. You know, maybe that's why we didn't take a stronger stance, maybe against the STP or more, you know, firmly, because you look at the age of their equipment, the average age of it, the amount of it, that there's a lot of work that needs to be done on the transmission and on the distribution side. Where we have a difference of opinion with Evergy sometimes is exactly what you stated. It's the pace of it, it's the scale of it, the rate of change. You know, I think one of our recommendations in the STP was that, you know, you get a bigger bang for your buck sometimes from a reliability standpoint by focusing on distribution investment instead of transmission. And so we were recommending that they shift some of their capital spend, that internally planned capital spend, from transmission to distribution. It also gets a different return, as you're aware, and so that can help. But it's you know, it's marginal. It's around the edges. It's moving. We want to move in the right direction and maybe slow down just a little bit, but there's a lot of work to be done.
So I think it was Mr. Mackelm earlier referred to the concern, I think that he's saying his clients have about, well, his words were that these investments were coming without scrutiny, basically. And I guess I'd like you to just juxtapose our concern about, you know, wanting more visibility into those planning processes and trying to understand the pace of you know, why things have to be built at the pace they do and scale they do. But if we're talking about the level of scrutiny that something receives, or our level of comfort that it's the right project, could you maybe juxtapose those local planning processes with the level of transparency and the process that a project has to go through to get approved as a regional competitively planned project at SPP?
Yeah, no, that's a really good point. You know, a lot of times what gives us pause or concern about the locally planned outside of SPP transmission spend, and we've been focusing on Evergy in part because they're an active participant in this proceeding, but also because we just recently wrapped up the STP investigation. They're not obviously the only party, but you know, because of the FERC formula rate, and because of the transmission delivery charge statute existing in the fashion that it does, you know, there are customer review processes. We're involved in that, KEPCO, other large sophisticated clients or customers, but there's a lot of work that needs to be done, and nobody questions that. So if Evergy just decides that we need to do $500 million worth of transmission investment in the next 2 years, then they just do it. Then they just decide to do it. They have their internal local planning criteria, and they have a lot of aging infrastructure, and so they just do it. And then, you know, the way the formula rate works, it's a projected rate. So if they project that it will be in service after July or January 1st of 2023, then it goes into service on January 1st, 2023. And then it gets the higher return and an RTO adder, you know, and all of that. And so we have, you know, a fair amount of concern about the trajectory of those costs and the lack of control that we have as a commission and as a staff over the timing of that investment and the recovery of it. But it's pretty easy to justify the spending because there's a lot of old stuff and a lot of stuff that needs to be fixed. But you know, you compare that to this process, right? And the ITP process and the fact that everybody pays equally for that line, right? So you've got a SPP staff has a Herculean task ahead of them, really, when they come up with those ITPs. They analyze it all, you know, 6 different ways, group the projects together, take some out to optimize it, and then ultimately they try to convince people across 14 states that, hey, everybody's going to pay for this, you know. So we're paying 16.5% of this line, and you can look at the congestion relief maps, and you can look at look at the zone by zone benefits, and it's clear we're getting 90% of the economic cost benefit of this line. But there are 13 other states that are paying for 83.5% of this line. All right. So anyway, it's not an easy process. There's a lot of hoops that they jump through, and I'd say there's a lot of transparency and scrutiny that goes into a project like this, as opposed to Evergy's locally planned transmission investment.
Thank you. That's the last question I had.
Okay. Thank you very much. I believe, Justin. No, I'm sorry. Pardon me, Jared. I didn't mean to give you a short change. Mr. Jevons, if you wish, the staff may have redirect.
Staff has no redirect for Mr. Grady.
All right, thank you. Mr. Grady, I believe we're at the end of your testimony. It was outstanding, very detail oriented. I've searched around here while you were asking the last couple of questions to see if I could find something else that I could harass you with or bug you with. I failed in that because I think your answers have been complete, and if I couple with all your pre-filed testimony, it's gives me a pretty complete picture of your opinion and your take on these matters, and I appreciate that very much. Accordingly, thanks for your testimony. You may stand down, and you are excused.
Thank you, Chair.
Well, it is 6:03 by my reckoning, and this concludes our hearing in docket 22-NETE-419-COC. As a reminder, the briefing schedule is as follows. We have post-hearing briefs. We have, first of all, simultaneously post-hearing briefs are due on June 20th. Yes, that is 2022. That seems like day after tomorrow for some of you, I'm sure. And then simultaneous post-hearing reply briefs are due on July 12, 2022. Anything further we need to take out before we dismiss?
Yes, Chair Keen, I believe that the hearing script had an error in that the procedural schedule has simultaneous initial briefs due on the 30th, June 30th.
Mr. Cohen.
Yeah, I'm checking right now.
And then while he's checking, NETE Southwest would also suggest that we have a page limitation of 30 pages on the initial briefs and 20 on the reply briefs.
And why do you request those limitations?
Well, most particularly on the initial briefs, there's less than 2 weeks to respond for the reply briefs. And we think that would be better for all parties in the commission to have focused briefs that we can respond to within, the 7 business days that we're given.
I see. Wouldn't you be benefited if you had a focus brief and somebody else didn't? Wouldn't that benefit you?
I think it's all
relative.
I think we all have to play under the same rules.
Mr. Cohen, what say you?
Mr. Schulte is right. I made an error in the script. The post-hearing briefs are due June 30th, and the post-hearing reply briefs that are also simultaneous are due July 12th.
Very good.
Sound right to everyone?
I'm sorry?
I was just making sure that sounded right to everyone else.
Yes. Thank you for bringing that to our attention, Mr. Shelby. I appreciate that very much. My personal inclination is to not limit the scope of the briefs, the size of the briefs. I just hate to tell lawyers how to do their work in something like this. So respectfully, Mr. Shelby, I'm going to deny your request. Surely you can filter through these things. I'm hopeful, regardless of the size of the briefs, and reach your own conclusions independently of that. All right, a commission order in this docket is due. Am I correct here, Mr. Mr. Cohen? I haven't done well on dates so far this evening. I have by August 29th, 2022. Is that correct?
I believe that's still the case. But again, Mr. Schulte, you can correct me.
Okay. All right. Thank you. Are there any further matters to come before us? Hearing none, we will close the record and adjourn. I want to, before we completely depart here, I want to thank, first of all the parties. It's been a long 2 days, but I think we've covered a lot of ground. It's been an orderly and I believe a very deliberative process, and I think a very positive process in providing a foundation from which the commission can consider all the various arguments and reach a decision. I want to extend a special thanks to our IT staff as well for their efforts throughout the past 2 days. We've run the gamut here from executive sessions or something akin to that to breakout sessions, and they've really acquitted themselves quite well. So our hats are off to Denise Grau and to Michelle Stovall. Thank you for that. And I'm going to say we owe an extra special thanks, in my opinion, to Denise Haas, who has to be one of the best court reporters on planet Earth. We want to thank you very much for your indulgence and for your ability to be attentive, respond to our requests for going back into the record and giving us all the benefit of that you did. Thank you so much, Denise, for that. We're grateful that you're willing to work for us, and we hope to see you again. With that, I'm going to bid all of you adieu and have a great evening. Take care.
Take care, everyone.
Thank you, Chair. Good night. Good evening.
Thank you.